Question 1. Section 2(a) of the Code of Criminal Procedure defines A. Bailable offense, B. Non-bailable offense, C. Cognizable offense, D. Non-cognizable offense. Answer A. Question 2. Under Section 138 of the Act, territorial jurisdiction does not arise on the following places: A. Where check is issued, B. In the local limit where the check is presented in the bank, C. Where the check is dishonored by the bank, D. From where the notice to pay the amount is issued. Answer D. Question 3. What are the essential ingredients of a complaint? A. There must be an allegation in the complaint, B. The allegation must be about the commission of an offense, C. The complaint must be made to the magistrate, D. All of the above. Answer D. Question 4. Which is not a negotiable instrument? A. Bond, B. Promissory note, C. Bill of exchange, D. Check. Answer A. Question 5. Section 13 of the Code of Criminal Procedure defines A. Metropolitan area, B. Assistant Public Prosecutors, C. Special Judicial Magistrate, D. None of these. Answer C. Question 6. Negotiable Instruments Act contains sections A. 140, B. 150, C. 147, D. 211. Answer C. Question 7. What are the processes to procure personal attendance of a person in the court? A. Summons, B. Warrant of arrest, C. Attachment of property, D. Above all. Answer D. Question 8. Section 2(c) of the Code of Criminal Procedure defines A. Non-bailable offense, B. Cognizable offense, C. Non-cognizable offense, D. Both B and C. Answer B. Question 9. What are the kinds of warrant? A. Bailable warrants, B. Non-bailable warrants, C. Both A and B, D. None of these. Answer C. Question 10. What is the difference between summon and warrant? A. Issuing of summon is a primary stage. Generally, warrants are issued if the attendance of an offender cannot be procured through summons. B. A summon is issued at the first instance in summons cases as well as in a warrant case, but warrant cannot be issued at the first instance in summons cases. C. Both A and B, D. None of these. Answer C. Question 11. Which condition S must be satisfied before issuing a proclamation? A. A summons should have been legally issued against a person, B. A warrant should have been legally issued against a person, C. Both A and B, D. None of these. Answer C. Question 12. What are the important conditions as necessary for initiation of proceedings under Section 107? A. Formation of opinion by magistrate, B. Existence of sufficient ground for proceeding, C. Both A and B, D. None of these. Answer C. Question 13. Public nuisance may be defined as A. An obstruction, risk or injury to the life, B. A risk or injury to health, C. An obstruction to the comfort or convenience of public at large, D. All of the above. Answer D. Question 14. Section of the Code of the Criminal Procedure deals with the circumstances when a conditional order for removal of nuisance can be passed. D. A. 131, B. 133, C. 139, D. 143. Answer B. Question 15. Which condition S should be fulfilled to constitute the First Information Report, FIR? A. What is conveyancy must be information. B. That information should be related to the commission of an offence on the face of it. C. Both A and B. D. None of these. Answer, C. Question 16. A. Is not entitled to maintenance under Section 125 of the Code of Criminal Procedure, 1973. A. Wife unable to maintain herself. B. Divorced wife, not remarried. C. Minor daughter. D. Divorced wife remarried. Answer, D. Question 17. Inherent powers under Section 482 of the Code of Criminal Procedure, 1973 can be exercised by A. Judicial Magistrate First Class. B. Sessions Judge. C. High Court. D. Chief Judicial Magistrate. Answer, C. Question 18. Information regarding occurrence of a cognizable offence is recorded by an officer in charge of a police station under which provision of the Code of Criminal Procedure, 1973? A. Section 149. B. Section 154. C. Section 155. D. Section 200. Answer, B. Question 19. How many languages are there in the 8th schedule of the Constitution of India? A. 16. B. 18. C. 20. D. 22. Answer, D. Question 20. The Supreme Court's judge retires at the age of A. 58 years. B. 70 years. C. 62 years. D. 65 years. Answer, D. Question 21. Joint meeting of both Houses of Parliament is chaired by A. President of India. B. Chairman of Rajya Sabha. C. Speaker of Lok Sabha. D. None of the above. Answer, C. Question 22. In India, which institution holds ultimate authority to accept 5-year PL? Answer, A. Planning Commission. B. National Development Council. C. Central Cabinet. D. Parliament. Answer, B. Question 23. Who is to certify that any bill is a money bill? A. Finance Minister. B. Speaker of Lok Sabha. C. Prime Minister. D. None of the above. Answer, B. Question 24. In which year financial emergency was proclaimed under Article 360 in India? A. 1962. B. 1965. C. 1975. D. Never. Answer, D. Question 25. The Charter of the United Nations was signed at San Francisco on A. 26 June 1945. B. 15 August 1943. C. 26 January 1946. D. 30 December 1941. Answer, A. Question 26. How many members are there in the Security Council? A. 5. B. 9. C. 10. D. 15. Answer, D. Question 27. The procedure for the removal of Supreme Court judge is given in A. Article 124, 4. B. Article 124, 5. C. Article 125. D. 8 Clay 126. Answer, A. Question 28. In International Court of Justice, there are A. President and 15 other members. B. President, Vice President and 15 other members. C. President, Vice President and 14 other members. D. President, Vice President and 13 other members. Answer, D. Question 29. Cr.P.C Commission was set up for the review of relations between A. The Prime Minister and the President. B. Legislature and Executive. C. Executive and Judiciary. D. Center and States. Answer D. Question 30. A decree may be executed by A. Tahsildar, B. Collector, C. District Judge, D. Either by the court which passed it or to which it is sent. Answer D. Question 31. Which of the following sections of the Code of Civil Procedure defines the misprofit? A. Section 2, 4. B. Section 2, 14. C. Section 2, 6. D. Section 2, 12. Answer D. Question 32. Pleading has been defined in A. Order 6, Rule 1 of the Code of Civil Procedure. B. Order 6, Rule 2 of the Code of Civil Procedure. C. Order 8, Rule 1 of the Code of Civil Procedure. D. Order 8, Rule 2 of the Code of Civil Procedure. Answer A. Question 33. Which one of the following authorities is not entitled to try a case summarily under the Code of Criminal Procedure? A. Chief Judicial Magistrate, B. Metropolitan Magistrate, C. Judicial Magistrate of the First Class, D. Second Class Judicial Magistrate. Answer D. Question 34. Which one of the following suits is not of a civil nature? A. Suits relating to rights to property, B. Suit for rents, C. Suits for recovery of voluntary payments or offerings, D. Suits against dismissals from service. Answer C. Question 35. In execution of a decree for the maintenance, salary of a person can be attached to the extent of A. 1/4, B. 1/3, C. 2/3, D. 1/2. Answer C. Question 36. Where a bill of exchange is drawn in a set of 5, how many of them need to be proved? A. 5, B. 3, C. 1, D. 2. Answer C. Question 37. Promissory estoppel is sometimes spoken of as a substitute of A. Novation, B. Quasi-contract, C. Consideration, D. Coercion. Answer B. Question 38. X contracted with a tent house for erecting a shamiana for performing the marriage of his daughter. On the day of marriage, a curfew was clamped in the area preventing the celebration of the marriage. The shamiana owner claims the charges agreed to be paid by X. In the light of the above, which one of the following is correct? A. X has to pay the contracted charges. B. X need not pay the agreed charges but only reasonable charges. C. X can require the state to bear the claim for damages. D. X need not pay anything as the celebration of the marriage was impossible on account of the curfew. Answer D. Question 39. What are the characteristics of a share? A. A share is an interest of a shareholder in the company. B. It is a bundle of rights and obligations of shareholder of the company. C. These rights and obligations are regulated by the articles of the company. D. Above all. Answer D. Question 40. Which companies are required to have their own articles and get them registered along with the memorandum? A. Unlimited companies, B. Companies limited by guarantee, C. Private company limited by shares, D. All above. Answer D. Question 41. In which case, the acts of a company are said to be ultra vires? A. Acts which do not fall within the main objects of the company. B. Acts which do not fall within the objects incidental or ancillary to the main object of the company. C. Acts done after the main objects become impossible. D. All of the above. Answer D. Question 42. The memorandum of a company must contain A. Name and place clause, B. Object and liability clause, C. Capital clause and subscribers clause. D. Above all. Answer, D. Question 43. What are the main features of Memorandum of Association? A. It is a fundamental document or charter of the company. B. It is essential for every company to prepare memorandum for its registration. C. It should be originally framed. D. It cannot be adopted. D. It contains objects of the company. D. All of the above. Answer, D. Question 44. What are the necessary steps for registration of a company? A. Preliminary steps. B. Delivery of documents by the registrar. C. Scrutiny of documents by the registrar and obtaining certificate of incorporation. D. Above all. Answer, D. Question 45. According to the Memorandum of Association of a company is its charter and defines the limitations of the company established under the Act. A. Lord Justice Cairns. B. Lord Justice Bowen. C. Palmer. D. Ramaya. Answer, A. Question 46. What are the kinds of companies, on the basis of ownership? A. Government companies. B. Non-government companies. C. Association not-for-profit or charitable company. D. All of the above. Answer, D. Question 47. What are the kinds of companies, on the basis of control? A. Holding company. B. Subsidiary company. C. One-man company. D. All of the above. Answer, D. Question 48. The companies with limited liability may be: A. Companies limited by shares. B. Companies limited by guarantee. C. Both A and B. D. None of these. Answer, C. Question 49. For which purpose the central government may appoint inspectors to investigate and report on the matters relating to the company? A. For determining the true persons who are or have been financially interested in the success or failure of the company. B. For determining the true persons who are or have been able to control or materially influence the policy of the company. C. For both A and B. D. None of these. Answer, C. Question 50. According to a company is an artificial person created by law, having separate entity, with a perpetual succession and common seal. A. Lord Justice Lindley. B. Professor Honey. C. Justice Marshall. D. Govere, L. C. B. Answer, B. Question 51. What are the merits of a negotiable instrument? A. Unlimited number of endorsements. B. No notice of answer for endorsement needed. C. A negotiable instrument is valid only when it is for a certain sum of money. D. All of these. Answer, D. Question 52. Which of the following is our negotiable instrument? S. A. Promissory note. B. Bill of exchange. C. Check. D. All of these. Answer, D. Question 53. What is the essential S of a promissory note? A. A promissory note must be in writing. B. There is no prescribed preform for promissory note. C. It must contain an express promise to pay. D. All of these. Answer, D. Question 54. Can make a promissory note payable to bearer? A. RBI. B. Central government. C. Both A and B. D. None of these. Answer, C. Question 55. The main parties to a bill of exchange are: A. Drawer. B. Drawee. C. Acceptor. D. All of these. Answer, D. Question 56. The person who is directed to pay the bill of exchange is called: A. Holder. B. Drawee. C. Payee. D. Acceptor. Answer, B. Question 57. The Transfer of Property Act, 1882 covers A. Movable property. B. Immovable property. C. Both A and B. D. None of these. Answer, C. Question 58. An instrument as defined under Section 3 of the Transfer of Property Act, 1882 means A. A negotiable instrument. B. A transferable instrument. C. A non-testamentary instrument. D. A will. Answer, C. Question 59. Where on a transfer of property, an interest therein is created in favor of a person to take effect only on the happening of a specified uncertain event, the transfer is called A. Conditional transfer. B. Transfer by interest. C. Absolute transfer. D. Contingent transfer. Answer, D. Question 60. Which of the following is not an actionable claim? A. Right to a provident fund account. B. Promise to pay 500 rupees if the promises succeed in LL. B. Examination. C. Agreement to pay 500 rupees if the promise marries a particular woman. D. Right to claim benefit of a contract coupled with a liability. Answer, D. Question 61. A lease of immovable property from year to year can be made by A. Oral agreement. B. Oral agreement accompanied by delivery of possession. C. Simple instrument. D. Only by a registered instrument. Answer, D. Question 62. Universal Dunny is A. Not liable for any debt or liability. B. Dunny is personally liable for all debts to liabilities existing at the time of gift. C. Dunny is only liable for half of the liabilities. D. Dunny is only liable for the 1/3 of liabilities. Answer, B. Question 63. When did the Banking Regulation Act come into effect? A. 16th January 1949. B. 16th April 1949. C. 16th March 1949. D. 16th February 1949. Answer, C. Question 64. Lease of immovable property determines A. By efflux of time, limited thereby. B. By implied surrender. C. By the happening of such event, where the interest of the leaser in the property terminates on the happening of that event. D. When the lessee becomes insolvent. Answer, D. Question 65. An instrument as defined under Section 3 of the Transfer of Property Act, 1882 means A. A negotiable instrument. B. A transferable instrument. C. A non-testamentary instrument. D. A will. Answer, C. Question 66. In case of part performance, what is not necessary with a transferee? A. Possession. B. Contract for consideration. C. Notice to transferor. D. Readiness on his part. Answer, C. Question 67. What is the rank of India in the Foreign Exchange Reserve? A. 15th. B. 2nd. C. 4th. D. 1st. Answer, C. Question 68. What may be transferred? A. Spec successions. B. A right to sue. C. A right of re-entry to the owner for breach of a subsequent condition. D. A right to future maintenance. Answer, C. Question 69. A mortgage by deposit of debts is called A. Anomalous mortgage. B. English mortgage. C. Equitable mortgage. D. Usufruct by mortgage. Answer, C. Question 70. What kind of transfer may be made orally? A. Gift of immovable property. B. Transfer of actionable claim. C. Sale of immovable property of value upward 100 rupees. D. Surrender of lease. Answer, D. Question 71. Whether simple mortgage must always be registered? A. Yes. B. If value of property is more than 100 rupees. C. Registration not necessary. D. None of the above. Answer, A. Question 72. What are the essentials of a valid gift? A. There must be a donor. B. A donee. C. A proper object of gift and an acceptance by the donee. D. All of these. Answer, D. Question 73. In case of usufructuary mortgage, the mortgagee is placed in possession who has a right to receive the rent and other profits till A. Mortgage money is paid. B. Contract is rescinded. C. Period of 30 years. D. Period of 99 years. Answer, A. Question 74. For applicability of doctrine of list pendants, the property would be A. Movable. B. Immovable. C. Both movable and immovable. D. None of these. Answer, D. Question 75. In which of the following cases, a transfer of immovable property can be made without writing? A. Sale of property of a value more than 100 rupees. B. Lease for a term of 11 months. C. Exchange. D. Actionable claim. Answer, B. Question 76. Whether a transfer can be made in favor of an unborn person? A. Yes, by machinery of trust. B. Yes. C. Guardian has got to be appointed first. D. None of the above. Answer, A. Question 77. Which of the following transfers is valid? A. An unregistered usufructuary mortgage for 99 rupees. B. An unregistered gift of immovable property of the value of 99 rupees. C. An oral lease of immovable property from year to year. D. An oral assignment of debts. Answer, A. Question 78. A right to obtain a decree from the court that the mortgagor shall be absolutely debarred of his right to redeem the mortgaged property is called A. A right for foreclosure. B. A right for claim. C. A right for redemption. D. A right for sale. Answer, A. Question 79. Where immovable property is transferred for consideration by persons having distinct interest therein, but their interests in the property are of equal value, the transferor is A. Entitled to get equal share in the consideration. B. Entitled to get unequal share in the consideration. C. Entitled to get equal share subject to further transfers in future. D. None of the above. Answer, A. Question 80. In case of a gift, if the donee dies before acceptance, the gift is A. Valid. B. Void. C. Revocable. D. Irrevocable. Answer, B. Question 81. Sale is a transfer of ownership in exchange for a price. A. Paid. B. Promised. C. Part paid and part promised. D. All of the above. Answer, D. Question 82. Under Section 3 of the Transfer of Property Act, the following does not amount to notice. A. Registration where the instrument is compulsorily registrable. B. Registration where the instrument is not compulsorily registrable. C. Possession. D. Notice to agent. Answer, B. Question 83. A. Gives a lakh of rupees to B. Reserving to himself with B.'s assent, the right to take back at pleasure 10,000 rupees out of lakh. The gift A. is wholly void. B. is invalid. C. holds goods as to 90,000 rupees. D. in onerous. Answer, C. Question 84. What kind of property is transferable? A. Right to re-entry. B. Public office. C. Any kind of property if not prohibited by law. D. Pension. Answer, C. Question 85. A. Has let his house at a rent of 100 rupees payable on the last date of each month. A. Sells house to B. On the 15th of June. On 30th June what will be apportionment? A. Will get 100 rupees. B. Will get 100 rupees. C. 50 rupees to A. and 50 rupees to B. D. The tenant will be exempted from payment of rent of this month. Answer, C. Question 86. In absence of contract or local law or usage to the contrary, a lease of immovable property shall be deemed to be A. Month to month. B. Bi-monthly. C. Year to year. D. Biannual. Answer, C. Question 87. Which one of the following statements is not correct, in context to transfer of property? A. It means an act by which a living person conveys property. B. He conveys property in present or in future. C. He conveys property to one or more other living person. D. He cannot transfer property to himself and one or more other living person. Answer, D. Question 88. How many types of mortgages are there in Section 58 of Transfer of Property Act? A. 4. B. 5. C. 6. D. 7. Answer, C. Question 89. A lease of immovable property from year to year is terminable, on the part of either lessor or lessee, by A. 1 month. B. 6 months. C. 3 months. D. 60 days notice expiring with the end of a year of tenancy. Answer, B. Question 90. What is not required in gift? A. Dona and donee. B. Consideration. C. Movable or immovable property. D. Transfer and acceptance. Answer, B. Question 91. Immovable property does not include timber. A. True. B. False. C. Till it is rooted in the earth. D. Only the branches of timber does not include in immovable property. Answer, A. Question 92. Transferee of the part performance has right to protect his possession. A. Wrong. B. Right can accrue only after payment of full consideration. C. Right. D. Delivery of possession is not necessary. Answer, C. Question 93. Where writing is not expressly required by law, a transfer of property may be made orally. A. False. B. Transfer can only be made by writing. C. With the consent of parties, oral transfer can be done. D. True. Answer, D. Question 94. Where writing is not expressly required by law, a transfer of property may be made orally. A. False. B. Transfer can only be made by writing. C. With the consent of parties, oral transfer can be done. D. True. Answer, D. Question 95. Who is not a citizen by domicile? A. Those who are born in the territory of India. B. Those whose either mother or father was born in the territory of India. C. Those who have been ordinarily residing in the territory of India after of Constitution of India, due to his work in India. D. Who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding commencement of Constitution of India. Answer, C. Question 96. Under Article 227 of the Constitution, who has superintendence over all the courts and tribunals located in the territory to which it exercises jurisdiction? A. State government. B. Central government. C. Supreme Court. D. High Court. Answer, D. Question 97. Which is the latest case wherein Constitutional Bench of the Supreme Court has reviewed the amending power of the Parliament under Article 368 of the Constitution? A. Golkanath vs. State of Punjab. B. Indira Nehru Gandhi vs. Rajnarayan. C. Minerva Mills vs. Union of India. D. Keshwanand Bharti vs. State of Kerala. Answer, C. Question 98. Which cannot be TR answer fed? A. Mere right to sue on the basis of agreement to sell. B. Right to receive arrears of rent. C. Right to recover detrital amount. D. Right to receive provident funds by will. Answer, A. Question 99. For part performance of the contract which is not an essential ingredient. A. Contract to TR answer for immovable property. B. Contract is in writing and signed by TR answer farer or on his behalf. C. TR answer Fairy is in possession of the property. D. TR answer Fairy has paid full consideration. Answer, D. Question 100. Legal validity of recovery of debts due to banks and FE Act 1993 was upheld by 3-judge bench of Honorable Supreme Court in A. UIV Delhi High Court Bar Association. B. Horizon Flora India Lieutenant. D. V. Asset Reconstruction Co. India Ltd. C. Baleshwar Dayal Jaswal v. Bank of India. D. Vijay Ladhu Udyog v. Punjab National Bank. Answer, A. Question 101. The tenancy Y of an immovable property is monthly. In order to terminate the lease of it, a notice of which period shall be given? A. 1 month. B. 2 month. C. 6 month. D. 15 days. Answer, D. Question 102. Interpleader suit is a suit. A. Between two advocates. B. Between Union Govt pleader and State Govt pleader. C. Instituted by a person who has no interest in the subject matter. D. Instituted by a person who has interest in the subject matter. Answer, C. Question 103. Where the plaint is not filed in duplicate, the plaint may be A. Returned by the court. B. Rejected by the court. C. Dismissed by the court. D. Admitted by the court. Answer, B. Question 104. Where the plaint is not filed in duplicate, the plaint may be A. Returned by the court. B. Rejected by the court. C. Dismissed by the court. D. Admitted by the court. Answer, B. Question 105. In a suit against the state government, who may sign the plaint on behalf of the government? A. Governor of the state. B. Chief Minister of the state. C. Chief Secretary of the state. D. A person who by a general or special order appointed in this behalf by the government. Answer, C. Question 106. The court shall not grant temporary injunction where A. Any property, in dispute, in a suit is in danger of being wasted, damaged or alienated by any party. B. Where plaintiff can be compensated by money. C. That the defendant threatened to remove or dispose of the property with a view to defrauding his creditors. D. None of the above. Answer, B. Question 107. The delivery of goods by one person to another for some purpose, upon a contract that they shall, when the person is accomplished, be returned or otherwise disposed of according to the direction of the person delivering them, is a contract of A. Guarantee. B. Bailment. C. Indemnity. D. None of these. Answer, B. Question 108. Which contract is void and initio? A. A contracts to let her daughter on hire to be for concubinage. B. While entering into contract to sell a cow, A disclosed B that the cow gives 5 liters milk in a day whereas it gives 4 liters in a day. C at the time of contract to selling a car is 20 kilometers per liter whereas its mileage is 18 kilometers per liter. D at the time of contract, A told B that the area of his house is 1,400 sq feet but on measurement the area of the house is found 1,398 sq feet. Answer A. Question 109. A person is dispossessed of an immovable property without due course of law. When can he bring a suit for recovery of possession under Section 6 of the Act? Period. A. 1 year. B. 2 year. C. 6 months. D. 9 months. Answer C. Question 110. In which case, the court can grant an injunction. A. To restrain any person from prosecuting a judicial proceeding. B. To restrain any person from instituting a criminal matter. C. To restrain any person from dispossession by force. D. To restrain any person from applying to any legislative body. Answer C. Question 111. The provisions of Section 5 of the Act, extension of prescribed period, are not applicable to A. Appeals. B. Revisions. C. Suits. D. Applications. Answer C. Question 112. The period of limitation of a suit for recovery of arrears of rent from the due date shall be A. 1 year. B. 2 years. C. 3 years. D. 5 years. Answer C. Question 113. Right to life and liberty is ensured under A. Article 21 of the Constitution India. B. Article 36. C. Article 268. D. None of these. Answer A. Question 114. How many times has the preamble to the Constitution of India been amended? A. 1. B. 2. C. 3. D. 4. Answer A. Question 115. Article 360 to the Constitution of India deals with the provisions as to A. Financial emergency. B. National emergency. C. Presidential rule in any state. D. None of these. Answer A. Question 116. The idea of republic and the ideals of liberty, equality and fraternity as laid down in the preamble to the Constitution of India have been borrowed from A. French Constitution. B. American Constitution. C. English Constitution. D. Constitution of South Africa. Answer A. Question 117. The governor of a state is empowered to grant pardons et c. and to suspend, remit or commute sentences in certain cases under A. Article 261. B. Article 161. C. Article 361. D. Article 368. Answer B. Question 118. A person whose fundamental rights are violated can move the High Court under A. Article 20. B. Article 226. C. Article 32. D. Article 22. Answer B. Question 119. Preamble of the Constitution declares India as A. Socialist democratic republic. B. A sovereign socialist secular democratic republic. C. A sovereign democratic republic. D. None of these. Answer B. Question 120. If it appears to the magistrate that the offence complained of is troubled exclusively by the Court of Session, he, under Section 202 Cr.P.C. postponing the issue of process against the accused, A. shall commit the case to the Court of Session. B. May direct an investigation to be made by a police officer. C. Shall call upon the complainant to produce all his witness and examine them on oath. D. Shall return the complaint for presentation before the Court of Session. Answer: C. Question 121 of the Indian Penal Code defines murder. A. Section 299. B. Section 300. C. Section 301. D. Section 302. Answer: B. Question 122. A married man commits adultery if he has sexual intercourse with an A. Unmarried woman. B. Married woman except his wife. C. Any women except his wife. D. Unmarried woman without her consent. Answer: B. Question 123. Copies made from or compared with the original is A. Primary evidence. B. Secondary evidence. C. Inadmissible evidence. D. None of these. Answer: B. Question 124. The following is not the exception to the rule of hearsay. A. Dying declaration. B. Res gestate. C. Medical expert's opinion. D. Confession. Answer: C. Question 125. The relief provided under the Specific Relief Act is A. Discretionary. B. Mandatory. C. Statutory. D. Obligatory. Answer: C. Question 126. Find out the correct statement. Specific relief can be granted. A. For enforcing individual civil rights and not for enforcing a penal law. B. For enforcing penal law and not for enforcing civil rights. C. Only for enforcing penal law. D. For enforcing civil rights and the penal law. Answer: A. Question 127. Find out the incorrect statement in respect of temporary injunctions. A. Preventive relief granted at the discretion of the court. B. Such as are to continue until a specified time or until the further order of the court. C. Regulated by the Code of Civil Procedure. D. Cannot be granted at any stage of a suit. Answer: D. Question 128. Which of the following contracts cannot be specifically enforced as per the provision of Section 14 of the Act? A. Execution of a formal deed of partnership. B. Contract for the construction of any building or execution of any other work on land. C. Contract which is determinable in its nature. D. Contract to execute a mortgage or furnish any other security for repayment of any loan which the borrower is not willing to repay at once. Answer: C. Question 129. An application for amendment of pleading is filed under A. Order 6 Rule 17. B. Order 6 Rule 5. C. Order 38 Rule 5. D. Order 21 Rule 1. Answer: A. Question 130. Which two of the following rights do not find place in the International Covenant on Economic, Social and Cultural Rights? A. Right to work. B. Right to adequate food. C. Right to self-determination. D. Right to privacy. Select the answer using the code given below. A. 1 and 2. B. 2 and 3. C. 3 and 4. D. 1 and 4. Answer: C. Question 131. Which two of the following rights do not find place in the International Covenant on Civil and Political Rights? 1. Right to leave any country including his own and to return to his country. 2. Protection against torture and other forms of cruel and inhumane or degrading treatment or punishment. 3. Right to move the International Court of Justice. 4. Right to be a member of the UN. Select the answer using the code given below. A. 1 and 3. B 3 and 4. C 1 and 4. D 2 and 4. Answer, B. Question 132. Which one of the following statements does not occur in Article 1 of the Universal Declaration of Human Rights? A. All human beings are born free and equal in dignity and rights. B. They are endowed with reason and conscience. C. They should always live together peacefully. D. They should act towards one another in a spirit of brotherhood. Answer, C. Question 133. Consider the following statements. 1. Jurisdiction of the International Court of Justice involuntary and obligatory. 2. Jurisdiction of the International Court of Justice can be imposed on member nations of the UN. 3. General Assembly and Security Council may refer a matter to International Court of Justice advice. 4. International Court of Justice is Court of Appeal from Supreme Court of member nations. Which of the two from the above statements are correct? A 1 and 3. B 2 and 4. C 3 and 4. D 1 and 4. Answer, A. Question 134. Which one of the following is not included in the UN Charter as an objective of the United Nations? A. To protect the sovereignty of the member states. B. To avoid war as a means for settlements of international disputes. C. Development of human personality. D. To ensure respect for international obligations arising from treaties and other forms of international law. Answer, C. Question 135. Consider the following statements. The Economic and Social Council of the UN, 1. May prepare draft conventions for submission to the General Assembly on subjects falling within its competence. 2. May call international conference on matters falling within its competence. 3. May appoint the members of Human Rights Committee. 4. May make recommendations for promoting respect for and observance of human rights and fundamental freedom. Which of the statements given above are correct? A 1 and 2. B 1 2 and 2. C 3 and 4. D 1 2 and 4. Answer, D. Question 136. Which one of the following statements is correct? De facto recognition of a foreign government. A is as conclusively binding, while it lasts, as de jure recognition. B is conclusive. C is always equal to de jure recognition. D has no legal effects. Answer, A. Question 137. What is an act of recognition to new territorial titles or territorial changes brought out by use of force or any other act of doubtful character depriving the rightful claimant thereto, commonly called A. Estrada Doctrine. B. Stimpson's Doctrine. C. Calvo Doctrine. D. Drago Doctrine. Answer, B. Question 138. Arrange the following sources of international law in the preferential sequence in which they are applied by International Court of Justice while deciding such disputes as are submitted to it. 1. General International Convention. 2. General Principles of Law recognized by civilized nations. 3. International Customs. 4. Judicial decisions of international tribunals. Select the answer using the codes given below. A 1234. B 4321. C 1324. D 4231. Answer, C. Question 139. Universal respect for and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion. Which one of the following documents contains the above? A. Universal Declaration of Human Rights. B. UN Charter. C. European Covenant on Human Rights and Fundamental Freedoms. D. International Covenant on Civil and Political Rights. Answer, A. Question 140. Which one of the following is not a source of international law? A. Constitution of sovereign states. B. Treaties. C. International conventions. D. International customs and practices. Answer A. Question 141. Which of the following is an element of I-hearing theory of possession? A. Overemphasis on the element of animus. B. Equal emphasis on the elements of animus and corpus. C. Owner-like appearance in relation to a thing. D. Immediate physical power to exclude any foreign agency. Answer C. Question 142. Ownership without possession can be termed as which one of the following? A. No ownership. B. Quasi-ownership. C. Incomplete ownership. D. No corporeal ownership. Answer D. Question 143. Which one out of the following statements is not correct with reference to Savigny's theory of Volksgeist? A. Law cannot be universal or general in character. B. Law is found and not made. C. Law grows with the growth and strengthens with the strength of people. D. Law is an instrument of social change and social reform. Answer D. Question 144. Who among the following propounded the theory of possession which lays stress not on animus, but on de facto control? A. Salmond. B. Pollock. C. Holmes. D. Herring. Answer B. Question 145. A. Borrowed a sum of Rs 5,000 from B, which he did not repay for a period of 3 years. Now which one of the following rights does B have against A. Perfect rights. B. Imperfect rights. C. Proprietary rights. D. None of the above. Answer B. Question 146. What do rights in realia mean? A. Rights in the things of others. B. Rights in one's own things. C. Rights relating to property. D. Rights to receive damages. Answer A. Question 147. Match list L with list LL and select the answer from the codes given below the list. List I. List 2. A supreme legislation. B. Executive legislation. C. Debated legislation. D. Conditional legislation 1. Law based on discretion of the authority 2. Law enacted by authority other than legislature 3. Law enacted by the legislation 4. Ordinance issued by the resident governor. Law made by judges while the case codes. A.B.C. D 3421. B 2154. C 3124. D 2451. Answer A. Question 148. Who among the following divided the sources of law into formal sources and material sources? A. Allen. B. Keaton. C. Salmond. D. Gray. Answer C. Question 149. Why is the expiatory theory of punishment obsolete now? A. It does not empower the state to impose punish. B. It is incapable to reform the wrongdoer. C. It is based on moral doctrines. D. It enlarges the limits of jurisprudence. Answer C. Question 150. Eugen Ehlich is a well-known jurist of sociological school of jurisprudence. Which one of the following statements may not be attributed to the theory propounded by him? A. Law is derived from social facts. B. Law depends on social compulsion. C. 3 is a living law, underlying the formal rule of the legal system. D. State law has significant influence on shaping and development of living law. Answer D. Question 151. balancing of social interests and the doctrines of social engineering is the greatest contribution to sociological school. This is attributed to whom? A. Duguid. B. Roscoe Pound. C. Savigny. D. Herring. Answer B. Question 152. Which of the following factors are responsible for the resurgence in favor of natural law thinking in the 20th century? 1. The decline in social and economic stability in the 20th century. 2. The expansion in government activity. 3. Growth of weapons of destruction and policies of genocide. 4. Growing inclination of people towards religion. Select the answer using the codes given below. A 2, 3 and 4. B 3 and 4. C 1, 2 and 3. D 1 and 4. Answer C. Question 153. Match list L, jurists, with list LL, view about law jurisprudence, and select the answer using the codes given below the lists. List I, jurists, list -2, view about law jurisprudence. A. Bentham. B. Austin. C. Kelson. D. Hart 1. Concept of law. 2. Pure theory of law. 3. Limits of jurisprudence defined. 4. Province of jurisprudence determined. 5. Concept of living law codes. A. B. C. D 1 2 5 3. B 3 4 2 1. C 1 4 2 3. D 3 2 5 1. Answer B. Question 154. There is a clear-cut division between the spheres of the legislature and the judiciary. The former makes the laws and the latter applies them. Which one of the following propounds this doctrine? A. Analytical jurisprudence. B. Historical jurisprudence. C. Sociological jurisprudence. D. Philosophical jurisprudence. Answer A. Question 155. It is said that the next step forward in the long path of man's progress must be from jurisprudence to jurimetrics. In this context, what does jurimetrics signify? 1. Speculation about law. 2. Scientific investigation of legal problems. 3. Increasing awareness of the fruits of interdisciplinary cooperation. 4. Relationship between law, economy and society. Select the answer using the codes given below. A 1 2 and 3. B 2 3 and 4. C 1 3 and 4. D 1 2 and 4. Answer B. Question 156. In India, which one of the following is the real guiding factor for the state to meet social needs and for the establishment of new social order? A. Fundamental rights. B. Preamble of the Constitution. C. Directive principles of state policy. D. Distribution of powers. Answer C. Question 157. The Supreme Court has interpreted the power of judicial review as a basic feature of the Constitution. However, there is a schedule to the Constitution, in which if a statute is specified, it cannot be questioned in a court of law on the ground of violation of fundamental rights. Which one of the following is that schedule? A. 10th schedule. B. 11th schedule. C. 9th schedule. D. 12th schedule. Answer C. Question 158. The following are enshrined in the preamble to the Constitution of India. 1. Equality of status and opportunity. 2. Liberty of thought, expression, belief, faith and worship. 3. Justice social, economic and political. 4. Fraternity assuring the dignity of the individual. 5. Unity and integrity of the nation. Which one of the following is the correct order in which they appear in the preamble? A. 5 1 2 4 3. B. 3 2 1 4 5. C. 3 1 2 5 4. D. 1 2 4 3 5. Answer B. Question 159. Which of the following sections of citizens should be excluded from the benefits of reservations according to the principles of creamy layer, as propounded by the Supreme Court in Mandal Commission judgment? 1. Advanced sections among the other backward classes. 2. Advanced sections among the scheduled castes. 3. Advanced sections among the scheduled tribes. 4. Advanced sections among the economically backward classes. Select the answer using the codes given below. A1 only, B1 and 2, C1 and 4, D2 and 3. Answer D. Question 160. Match list L, case, with list LL, subject dealt with, and select the answer from the codes given below the lists. List I, case, list 2, subject dealt with. 1. L. Chandra Kumar vs. Union of India, BTM. A. Pal Foundation vs. State of Kerala. C. Randhir Singh vs. Union of India, D. S. Jagannath vs. Union of India. 1. Equal pay for equal work. 2. Prawn culture and coastal zone regulations. 3. Judicial review. 4. Rights of minority educational institutions. 5. Uniform civil code codes. A. AIBC D1452, B 3214, C 3412, D 1254. Answer C. Question 161. Which one of the following fundamental rights is available to both the citizens and aliens? A. The right to equality of opportunity in public employment. B. The right to sex freedoms. C. Cultural and educational rights. D. The right to equality. Answer D. Question 162. In which case has Supreme Court of India held that there is no reason to compel non-smokers to be helpless victims of air pollution? A. Salem Advocate Bar Association, Tamil Nadu vs. Union of India. B. Onkar Lal Bijoy vs. Union of India. C. Murli S. Deora vs. Union of India. D. Ramakrishnan vs. State of Kerala. Answer C. Question 163. Which one of the following is not a directive principle of state policy? A. Organization of village panchayats. B. Uniform civil code for citizens as well as non-citizens. C. Right to work, to education and to public assistance in certain cases. D. Participation of workers in management of industries. Answer B. Question 164. Which one of the following statements is correct? Right to free and compulsory education to all children of the age of 6 to 14 years is A. Fundamental right enforceable in a court of law. B. A fundamental duty. C. A directive principle of state policy. D. A fundamental right which, however, can be enforced only if the state makes an enabling legislation. Answer A. Question 165. For which of the following can special provisions be made under Article 15 of the Constitution of India? 1. Women and children. 2. Scheduled tribes. 3. Economically backward classes. 4. Socially backward classes. Select the answer using the codes given below. A1, 2 and 4. B1 and 3. C2, 3 and 4. D1, 2, 3 and 4. Answer A. Question 166. Who appoints the judicial officers of the subordinate judiciary other than the district judges? A. Union Public Service Commission. B. State Public Service Commission. C. Governor in accordance with the rules made by him in consultation with the High Court and State Public Service Commission. D. Governor in consultation with the High Court exercising jurisdiction in relation to such state. Answer C. Question 167. Which one of the following statements is correct? On receipt of a constitutional amendment bill after its passing by each house of the Parliament, the President A. shall give his assent. B. may give his assent. C. may withhold his assent. D. may return the bill for reconsideration. Answer A. Question 168. Through which provisions does the Constitution of India explicitly prohibit racial discrimination in India? A. Articles 14 and 17. B. Articles 17 and 23. C. Articles 15 and 16. D. Articles 17 only. Answer C. Question 169. Consider the following judgments of the Supreme Court which dealt with the appointment and transfer of judges of the Supreme Court and High Courts. 1. S.P. Gupta vs. Union of India. 2. Sankal Chand Seth vs. Union of India. 3. In re Special Reference Number 1 of 1998. 4. Supreme Court Advocates on Record Association vs. Union of India. Which one of the following is the correct chronological order in which the above judgments were delivered? A. 1234. B. 2134. C. 2143. D. 1243. Answer C. Question 170. Consider the following statements. The High Court has jurisdiction to 1. Punish for its contempt. 2. Tender advice on the legal question referred to it by the Governor of the state. 3. Tender advice on a legal question referred to it by the Governor of the state. 4. Issue certain writs for enforcement of fundamental rights or for other purposes. Which of the statements given above are correct? A. 1 and 4. B. 1 and 2. C. 1, 2 and 3. D. 2, 3 and 4. Answer A. Question 171. Which one of the following statements is correct? A. Union Public Service Commission may serve the needs of a state if requested by the governor of that state and approved by the President. B. Union Public Service Commission may serve the needs of a state if requested by the Chief Minister of that state. C. Union Public Service Commission cannot serve the needs of a state. D. Union Public Service Commission may serve the needs of a state simply on request of governor. Approval of the President is not necessary. Answer A. Question 172. The amendment in Article 31, c, which gave precedence to all directive principles of state policy over fundamental rights, was declared ultra-vires and void. In which one of the following cases? A. Minerva Mills vs. Union of India. B. N.K. vs. Union of India. C. Vamam Rao vs. Union of India. D. Sanjeev Coke Manufacturing Company vs. Bharat Coking Coal Lieutenant. D. Answer A. Question 173. In which one of the following cases did the Supreme Court rule that the principle of sovereign immunity will not apply to a proceeding for award of compensation for violation of fundamental rights? A. State of Rajasthan vs. Vidyavati. B. Kasturi Lal vs. State of Uttar Pradesh. C. Murli S. Deora vs. Union of India. D. Neelabati Behera vs. State of Orissa. Answer D. Question 174. The first amendment to the Constitution made in 1951 made changes in relation to which of the following provisions? 1. Special provisions for advancement of socially and educationally backward classes. 2. Validation of certain acts and regulations specified in the 9th Schedule. 3. Saving of certain laws giving effect to certain directive principles. 4. Saving of laws providing for acquisition of estates. Select the answer using the codes given below. A. 1, 2 and 3. B 1, 2 and 3. C 2, 3 and 4. D 1, 3 and 4. Answer A. Question 175. Which one of the following statements is correct? When the President issues a proclamation of emergency, A. All the fundamental rights are automatically suspended. B. Only Article 19 is automatically suspended. The enforcement of all other fundamental rights can be suspended by an order of the President. C. Only Article 19 is automatically suspended. D. The enforcement of all other fundamental rights except Articles 20 and 21 can suspended by an order of the President. D. Article 19 can be suspended. D. Other fundamental rights cannot be suspended. Answer C. Question 176. In which list vertical bar is the subject of preventive detention enumerated? A. The Union list. B. The concurrent list. C. The state list. D. None of the above. Answer B. Question 177. Which of the following are the matter covered under List 1 of 7th Schedule of the Constitution of India? 1. Foreign law. Answer 2. Atomic energy. 3. Insurance. 4. Public health. Select the answer using the codes given below. A 1, 2, 3 and 4. B 1, 2 and 4. C 1 and 4. D 2, 3 and 4. Answer B. Question 178. Consider the following statements. The executive power of the Union extends to giving of direction to a state in respect of 1. Construction and maintenance of means of communication of national or military importance. 2. Maintenance of law and order in that state. 3. Protection of railways within the state. 4. Protection of secular character of the country. Which of the statements given above are correct? A 1 and 2. B 2 and 3. C 1 and 3. D 1, 2, 3 and 4. Answer C. Question 179. Match list vertical bar. Case with list vertical bar, subject, and select the answer using the codes given below the lists. List I, case, list -2, subject. A. State of Rajasthan vs. G. Vijola. B. K.T. Mupil Nair vs. State of Kerala. C. Gujarati University vs. State of Kerala. D. M. Karunanidhi vs. Union of India. 1. Harmonious construction. 2. Colorable legislation. 3. Repugnancy. 4. Pith and substance. 5. Incidental powers codes. A. ABCD 1352. B 4213. C 1253. D 4312. Answer B. Question 180. A manufacturer of ginger beer had sold to a retailer bottles of ginger beer in opaque bottles. The retailer sold one such bottle to A. who gave to his girlfriend, which contained the decomposed remains of a dead snail. The lady alleged of that she became seriously ill on consuming a portion of the contents from the said bottle. Which one of the following conclusions is correct as to the liability in law of torts? A. The manufacturer of the ginger beer shall be liable for negligence. B. The manufacturer is not liable at all. C. The retailer will liable to the lady as he sold the bottle. D. The lady is not entitled to damages due to her contributory negligence. Answer A. Question 181. Match list vertical bar, rules maxims, with list vertical bar, cases, and select the answer from the codes given below the lists. List I, rules maxims, list -2, cases. A. Neighbor principle. B. Last opportunity rule. C. Res ipsa loquitur. D. Doctrine identification. 1. Davies vs. Mann. 2. Byron vs. Bodle 3. Matthews vs. London Street Tramways Co. 4. Donoghue vs. Stevenson 5. Ashby vs. White Codes. AIBC D3254. B4123. C4253. D3124. Answer, B. Question 182. In which one of the following cases did the Supreme Court of India give a ruling that sovereign immunity of the state is subject to the fundamental rights? A. State of Rajasthan vs. Vidyavati. B. Shyam Sundar vs. State of Rajasthan. C. Kasturi Lal Ralia Ram Jain vs. State of UP. D. People Union for Democratic Rights vs. State Bihar. Answer, D. Question 183. Which one of the following statements is not correct? A. The principles of master's liability for the acts of a servant is based on the doctrine is respondent superior. B. The rule of master's liability for the acts of the servant is based on the maxim qui facet per alium facet per se. C. Master's liability for the torts of his servant is absolute and it is immaterial whether the tort was committed in the course of his employment or not. D. The rule of master's liability for the act of the servant is based on the capacity to pay. In most of the cases, servant is not financially in good position to pay the damages. Answer, C. Question 184. Where does vicarious liability generally arise from? A. A contract of service. B. A contract for service. C. A contract of service as well as a contract for service. D. A wrongful act of the master. Answer, A. Question 185. An army truck driven by an army driver while going to leave army joints on the station for enabling them to catch their hometown, hit a pedestrian and killed him due to rash and negligent driving. Which one of the following is correct? A. In this case vicarious liability is to be imposed on the Government of India. B. In this case vicarious liability would be claimed under the defense of sovereign functions of the state. C. In this case no liability will be imposed under the defense of inevitable accident. D. In this case both Government of India and the driver personally would be liable. Answer, A. Question 186. C. A stranger blocked the water pipes of a wash basin and opened the tap. The wash basin was otherwise in the control of the defendant. B. The overflowing water damaged the plaintiff goods. Thereupon the plaintiff filed a suit for damages against the defendant. B. C. Was not made a party. In the aforesaid suit, which one of the following conclusions is correct? A. The defendant was liable for damages to the plaintiff to the basis of rule of strict liability. B. The defendant was not liable for damages. C. The stranger C will have to pay damages. D. The plaintiff's suit will be decreed in his favor. Answer, D. Question 187. Due to the collapse of the clock tower situated opposite the town hall in main bazaar of a city, a number of persons died. D. The clock tower belonged to the municipal corporation of the city and was exclusively under its control. It was 60 years old, but the normal life of the structure of the building which had fallen could be 40 to 45 years, having regard to the kind of material used. D. Mrs. X, whose husband died due to the collapse of the clock tower, filed the suit for damages against the municipal corporation. Which one of the following maxims is applicable in the aforesaid case? A. Damnum sine injury. B. Injury sine damno. C. Res ipsa loquitur. D. Volenti not fit injuric. Answer, C. Question 188. The defendants by digging a coal pit in the land intercepted the water which affected the plaintiff's well at a distance of about 1 mile. The plaintiff brought a suit for damages against the defendants. Which one of the following maxims is applicable in the aforesaid case? A. Damnum sine injuria. B. Injuria sine damno. C. Res ipsa loquitur. D. Volenti non fit injuria. Answer A. Question 189. Who gave the pigeonhole theory in defining tort? A. Austin. B. Huston. C. Salmond. D. Winfield. Answer C. Question 190. A magistrate in making a report to the superior casts an imputation on the character of a person Z in good faith and for public good. D. Which of the following defense is most appropriate? A. Justification. B. Fair comment. C. Absolute privilege. D. Qualified privilege. Answer D. Question 191. In India, an action of slander may be maintained without proof of special damage in some cases. Identify in which of the following cases proof of damage is necessary. A. Imputation of crime. B. Vulgar abusive language. C. Imputation of contagious disease. D. Imputation of lack of chastity to a woman. Answer B. Question 192. When does the tort of conspiracy exist? A. Two or more persons agree to commit an unlawful act. B. Two or more persons agree to commit some recognized tort. C. Two or more persons caused harm to the plaintiff. D. Two or more persons committed a concerted action to injure the plaintiff. Answer D. Question 193. During the scarcity of potatoes, long queues were made outside the defendant's shop, who, having a license to sell fruits and vegetables, used to sell only 1 kilogram of potatoes per ration car. D. The queues extended onto the highway and also caused some obstruction to the neighboring shops. The neighboring shopkeepers brought an action for nuisance against the defendant. Which one of the following decisions will be correct in this suit? A. The defendant is liable for nuisance. B. The defendant is not liable for nuisance. C. The plaintiff's suit should be decreed in their favor. D. The defendant is liable to pay damages to the plaintiffs. Answer B. Question 194. A theft had been committed in the defendant's house. He informed the police that he suspected the plaintiff for the same. Therefore, the plaintiff was arrested by the police. A complaint was filed by the defendant, but the plaintiff was subsequently discharged by the magistrate, as the final report showed that there was no evidence connecting the plaintiff with the theft. The plaintiff filed a suit for damages on the ground of malicious prosecution. In the above case, which one of the following decisions is correct? A. The plaintiff is entitled to claim damages from the defendant. B. The plaintiff is entitled to claim damages from the police. C. The plaintiff is entitled to claim damages from both. D. The plaintiff is not entitled to claim damages for malicious prosecution at all. Answer D. Question 195. The branch of a tree growing on the defendant's land hung on the highway at a height of about 30 feet above the ground. D. In fine weather, the branch suddenly broke and fell upon the plaintiff's vehicle, which was passing along the highway. For the damage to the vehicle, the plaintiff sues the defendant on the ground of nuisance. Which one of the following conclusions is correct in this suit? A. The defendant was liable for nuisance. B. The defendant was not liable for nuisance. C. The defendant was liable under the principle of strict liability. D. The plaintiff's suit should be decreed in his favor. Answer B. Question 196. The defendant had filed a complaint to the magistrate against the plaintiff. The complaint was dismissed. D. The defendant moved the sessions judge in appeal. He got himself examined in sessions trial although he knew the charge was false and he was acting without reasonable and probable cause. His complaint was dismissed by the session judge. Thereupon the plaintiff filed a suit for malicious prosecution against the defendant. In the aforesaid case, which one of the following conclusion incorrect? A. The defendant is liable for malicious prosecution. B. The defendant is not liable for malicious prosecution. C. The defendant is not liable to pay damages to the plaintiff. D. The plaintiff's suit must be dismissed. Answer: A. Question 197. Which of the following is an element of strict liability in tort? A. Duty to take care. B. Fault. C. Breach of duty. D. No fault. Answer: D. Question 198. Section 300 of the I.P.C. speaks of situations in which if a murder is committed, then it is treated as culpable homicide not amounting to murder. Which one of the following situations is not covered under S.300 I.P.C? A. Exercise of the right of private defense. B. Exercise of legal. C. Exercise of legal powers. D. Sudden fight. Answer: C. Question 199. A lady wishing to get a railway ticket, finding a crowd at the ticket window at the station, asked X, who was near the window, to get a ticket for her and handed him over the money for the same. X took the money and instead of getting the ticket ran away with the money. What offense has been committed by X? A. No offense. B. Offense of criminal breach of trust. C. Offense criminal misappropriation. D. Offense of theft. Answer: B. Question 200. Which of the following elements constitute criminal misappropriation of property? 1. Movable property belonging to a person other than the accused. 2. Any property belonging to a person other than the accused. 3. The accused must have misappropriated the property to his own use. 4. There must be dishonest intention on the part of the accused. Select the answer using the codes given below. A. 1, 2, 3 and 4. B. 1, 3 and 4. C. 2 and 4. D. 2 and 3. Answer: B. Question 201. A. Government of India Act 1858 Control 1. Absolute Imperial. B. Indian Councils Act 1861 2. Non-official members in Executive Council. C. Indian Council 3. Separate Representation of Muslim Community Act 1909. D. Government of 4 Diaki in the India Act 1919 Provinces. A. B. C. D. 2314. B. 4123. C. 3412. D. 1234. Answer: D. Question 202. Which of the following are the principal features of the Government of India Act 1919? 1. Introduction of diarchy in the executive government of the provinces. 2. Introduction of separate communal electorate for Muslims. 3. Devolution of legislative authority by the centre to the provinces. 4. Expansion and reconstitution of central and provincial legislatures. A. 1, 2 and 3. B. 1, 2 and 4. C. 2, 3 and 4. D. 1, 3 and 4. Answer: D. Question 203. Consider the following statements. The Indian Constitution is 1. Unwritten Constitution. 2. Written Constitution. 3. Largely based on Government of India Act 1935. A. 1 and 2 are correct. B 2 and 3 are correct. C 1 and 3 are correct. D none of the above. Answer B. Question 204. Consider the following statements with reference to the term secularism. 1. Secularism means that the state has no recognized religion of state. 2. Secularism means that the state treats all the religions equally. 3. Secularism means that the state regulates the relation of man with God. D. Which of these statements are correct? A 1, 2 and 3. B 1 and 2. C 2 and 3. D 1 and 3. Answer B. Question 205. Which one is not correctly matched? A. Freedom of speech, include freedom of an expression press. B. Freedom of, include right to wear and carry Cr.P.C by 6. C. Conscience right to personal, include right to carry on any trade or business liberty. D. Right to equality, includes principles of natural justice. Answer C. Question 206. The governor of a state is appointed by the president on the advice of the A. Prime Minister, B. Vice President, C. Chief Minister, D. Chief Justice. Answer A. Question 207. An accused person has been provided with the following protections by Constitution of India. 1. Ex post facto law. 2. Safeguard against arrest and detention. 3. Double jeopardy. Arrange the protections in the order in which they appear in the Indian Constitution. A. Codes 1, 3, 2. B 1, 2, 3. C 3, 1, 2. D 2, 1, 3. Answer A. Question 208. Article 16, 4A, which gives power to the state to make laws regarding reservation in favor of scheduled castes and scheduled tribes, was added by the A. 75th Amendment to the Constitution of India, B. 76th Amendment to the Constitution of India, C. 77th Amendment to the Constitution of India, D. 78th Amendment to the Constitution of India. Answer C. Question 209. Match the following. A. Right to go 1. Bhim Singh's case. Abroad. B. Prisoner's right to. Maneka Gandhi's case. C. Death penalty 3. Bhakan Singh's case. D. Government's 4. Sunil Batra's case. Liability. A. Codes A. B. C. D. 2413. B. 4231. C. 2431. D. 4213. Answer C. Question 210. A resolution passed under Clause 1 of Article 249 shall remain in force for such period not exceeding A. 3 months, B. 6 months, C. 9 months, D. 12 months. Answer D. Question 211. Which one of the following pairs is correctly matched? A. Habeas corpus, available against private individual as well. B. Quo warranto, available against subordinate courts only. C. Certiorari, available against autonomous bodies only. D. Prohibition, directs a public authority to perform a task. Answer A. Question 212. Match the following. A. Right to go abroad 1. Bhim Singh's case. B. Prisoner's right to. Maneka Gandhi's case. C. Death penalty 3. Bhakan Singh's case. D. Government's liability 4. Sunil Batra's case. A. B. C. D. 2413. B. 4231. C. 2431. D. 4213. Answer C. Question 213. Match the following. A. Right to live with human dignity enshrined in art. 21 derives life breath from DPSP clauses E and F of Art. 39, 41 and 42. B. Speedy trial is an essential ingredient of just, fair and reasonable procedure guaranteed by Art. 21. C. In PIL, a total stranger to a trial cannot be permitted to question the correctness of the conviction of the accused. D. In case of helplessness or disability, any member of the public can maintain an answer. C. Question 214. List I. List 2. Balaji vs. State F. Mysore 1. Doctrine of Waiver of Fundamental Rights Maneka Gandhi 2. Religious Freedom vs. UI Rev. Stanilos 3. Right to Life and Personal Liberty vs. State of MP Basheshwar Nath 4. Reservation for Backward Classes vs. IT. Comra. 5. Doctrine of Severability. AIBC D 4231. B 5432. C 4321. D 5321. Answer C. Question 215. List I. List 2. Independence of Judiciary 1. Administrative adjudication. Executive legislation 2. Parliamentary form of government. Quasi-judicial functions 3. Appointment and transfer of judges. Collective responsibility 4. Ordinance. AIBC D 2143. B 3412. C 2413. D 3I42. Answer B. Question 216. The 73rd Amendment provides a tier system of panchayats. A3. B4. C2. D1. Answer A. Question 217. List I. List 2. A. Habeas corpus 1. Violation of natural justice. B. Mandamus 2. Unlawful arrest and detention. C. Quo warranto 3. Exercise of power without jurisdiction. D. Certiorari 4. Non-performance of public duty. AIBC D 2431. B 1342. C 2341. D 1432. Answer B. Question 218. The fundamental duties provided in the Constitution are 1. To value and preserve rich heritage of our composite culture. 2. To safeguard private property. 3. To develop scientific temper, humanism, and spirit of inquiry and reform. Of these fundamental duties include A1, 2 and 3, B1 and 2, C2 and 3, D1 and 3. Answer D. Question 219. If a new state of Indian Union is to be created schedule of the Constitution must be amended. A. First. B. Second. C. Third. D. Fourth. Answer A. Question 220. Which one of the following statements correctly describes the fourth schedule of the Constitution of India? A. It lists the distribution of powers between the Union and the states. B. It contains the languages listed in the Constitution. C. It contains the provision regarding the administration of tribal areas. D. It allocates seats in the Council of States. Answer D. Question 221. The 8th schedule of the Indian Constitution contains the A. Fundamental rights. B. DPSP. C. List of languages recognized by the Constitution. D. Number of states and UTS. Answer C. Question 222. Provisions regarding anti-defection are provided in of the Constitution of India. A. 2nd schedule. B. 5th schedule. C. 8th schedule. D. 10th schedule. Answer D. Question 223. At the time of framing there were ____ schedules in the Constitution of India. A8, B10, C12, D11. Answer, A. Question 224. The House may declare the seat vacant after ____ of any member, if he is absent from all meetings without permission of the House. A 30 days, B 45 days, C 60 days, D 90 days. Answer, C. Question 225. When the offices of both the Speaker and the Deputy Speaker are vacant, ___ appoints a person to perform the functions of the Speaker. A. The President. B. The Prime Minister. C. The Chief Justice of India. D. Council of Ministers. Answer, A. Question 226. The framers of the Constitution borrowed the idea of judicial review from the Constitution of A. France. B. USA. C. United Kingdom. D. None of these. Answer, B. Question 227. Decision of ___ is final regarding the disqualification of a member of either House of Parliament under Art. 103. A. The Election Commission. B. President. C. Speaker of Lok Sabha. D. Prime Minister. Answer, B. Question 228. Part ___ of the Constitution of the India talks about municipalities. A. Part 9. B. Part 9A. C. Part X. D. Part XA. Answer, B. Question 229. It is often said that the key to the minds of the makers of our Constitution lies in the A. Preamble. B. Fundamental rights. C. Fundamental duties. D. Directive principles of state policy. Answer, A. Question 230. Disqualification of a member of Parliament on the ground of defection is to be decided by A. The President. B. Speaker of Lok Sabha. C. Speaker of Rajya Sabha. D. Either B or C, as the case may be. Answer, D. Question 231. Preamble to the Constitution of India. A. Is not a part of the Constitution. B. Indicates the objectives to be achieved. D. C. Indicates the source from which the Constitution derives its authority. D. Is a source of authority of the Constitution of India. Answer, C. Question 232. The preamble to the Indian Constitution is A. A part of Constitution, but it neither confers any power nor impose any duties, nor can it be of any use in interpreting other provisions of the Constitution. B. A part of the Constitution and can be of use in interpreting other provisions of the Constitution in cases of ambiguity. C. A part of the Constitution and it confers powers and impose duties as any other provision of the Constitution. D. Not a part of the Constitution. Answer, B. Question 233. The source of directive principles of state policy in our Constitution can be traced back to the Constitution of A. USA. B. United Nations. C. United Kingdom. D. Ireland. Answer, D. Question 234. The following are enshrined in the preamble to the Constitution of India. A. Equality of status and opportunity. B. Liberty of thought, expression, belief, faith and worship. C. Fraternity assuring the dignity of the individual. D. Unity and integrity of the nation. Which one of the following is the correct order in which they appear in the preamble? A. 51243. B. 32145. C. 31254. D. 12435. Answer, B. Question 235. Which one of the following is in correct order in the preamble of the Indian Constitution? A. Sovereign, socialist, secular, democratic and republic. B. Sovereign, secular, socialist, democratic and republic. C. Sovereign, secular, democratic, socialist and republic. D. Sovereign, democratic, secular, republic and socialist. Answer A. Question 236. The text of the preamble of the Constitution of India aims to secure A. Fundamental rights to all individuals. B. Fundamental duties of citizen of India. C. Dignity of the individual and unity and integrity of the nation. D. Security of service to government servants. Answer C. Question 237. Words secular and integrity were added by amendment of the Constitution. A. First Amendment Act. B. 24th Amendment Act. C. 42nd Amendment Act. D. 44th Amendment Act. Answer C. Question 238. Preamble of the Constitution of India has been amended times so far. A. 2. B. 3. C. 1. D. Never. Answer C. Question 239. The word secular denotes A. Keeping away from all religions. B. Freedom of religion and worship to all religions. C. Belief in one God. D. Practicing different religions. Answer B. Question 240. The term socialist used in the preamble means a state whose basic policy is to A. Prohibit concentration of wealth. B. Distribute equitably the natural resources. C. Prohibit concentration of wealth and uplift the living standard of people. D. That the state shall endeavor to achieve socialistic goals through democratic means. Answer D. Question 241. In which of the following case is the 6 rights guaranteed by Article 19 can be suspended? 1. External aggression. 2. Internal emergency. 3. When martial law is in force. A. 1 only. B. 2 and 3 only. C. 1 and 3 only. D. 1, 2 and 3. Answer D. Question 242. Which of the following rights are available to foreigners in India? 1. Right to education. 2. Right to information. 3. Right to vote. A. 1 and 2. B. 1 only. C. 1, 2 and 3. D. 2 only. Answer B. Question 243. Article 21 declares that no person shall be deprived of his life or personal liberty except according to procedure established by law. The protection under Article 21 is A. Against arbitrary legislative action. B. Against arbitrary executive action. C. Both A and B. D. Neither A nor B. Answer C. Question 244. Which of the following statements are correct? 1. Right to information is a fundamental right enshrined in Article 19, 1, of the Constitution. 2. Supreme Court of India is not under the purview of RTI Act. 3. Supreme Court of India has the advisory jurisdiction. A. 1 and 3. B. 2 and 3. C. 1, 2 and 3. D. 3 only. Answer A. Question 245. Article 32 confers the right to remedies for the enforcement of the FR of an aggrieved citizen. Consider the following statements. WRT. Article 32. 1. Parliament can suspend this right during national emergency. 2. Only SC shall have the power to issue writs for the enforcement of any of the FR. 3. High courts have the power to issue writs under Article 226 of the Constitution. A.I. only. B1 and 3. C1 and 2. D3 only. Answer, B. Question 246. Which of the following rights are enshrined in Article 21? No person shall be deprived of his life or personal liberty except according to procedure established by law. 1. Right to speedy trial. 2. Right against delayed execution. 3. Right against wrongful detention and arrest. A1 and 3. B2 only. C1 and 2. D1, 2 and 3. Answer, C. Question 247. Which of the following writs can be issued against administrative authorities? A. Prohibition, certiorari and mandamus. B. Certiorari and mandamus. C. Prohibition and mandamus. D. Prohibition and certiorari. Answer, B. Question 248. The directive principles were made non-justiciable and legally non-enforceable because 1. The country did not possess sufficient financial resources to implement them. 2. There was widespread backwardness in the country that could stand in the way of implementation. A.I. only. B2 only. C. Both 1 and 2. D. Neither 1 nor 2. Answer, C. Question 249. Which of the following statements are correct? 1. The directive principles are meant to establish political democracy. 2. The directive principles are meant to establish social democracy. 3. The directive principles are meant to establish economic democracy. A.I. only. B2 and 3 only. C1 and 3 only. D1, 2 and 3. Answer, B. Question 250. Which of the following statements are correct? 1. Fundamental rights enjoy legal supremacy over directive principles. 2. The Parliament can amend the fundamental rights for implementing the directive principles. 3. Fundamental rights cannot be curtailed under any circumstances by the Parliament. A1 and 3. B only 2. C1 and 2. D1, 2 and 3. Answer, B. Question 251. Which of the following statements are correct regarding Constitutional Amendment Bill? 1. Prior permission of President is required before introducing the Constitutional Amendment Bill in Parliament. 2. President must give his assent to the bill if duly passed by both houses. 3. Constitution Amendment Bill can be introduced in any house of the Parliament. A1 and 2. B2 and 3. C1 and 3. D.I. only. Answer, B. Question 252. The emoluments, allowances, privileges and so on of governor can be altered by A constitutional amendment bill passed by simple majority of Parliament. B. A constitutional amendment bill passed by special majority of Parliament. C. A constitutional amendment bill passed by special majority of the Parliament and ratified by half of the state legislatures. D. By a normal legislative process that does not require constitutional amendment. Answer, A. Question 253. Which of the following is our federal feature of our Constitution? 1. Supremacy of the Constitution. 2. Rigid Constitution. 3. Independent judiciary. A.I. only. B2 and 3 only. C1 and 3 only. D1, 2 and 3. Answer, D. Question 254. Which of the following statements are true about center-state relations? 1. In respect to matters enumerated in the concurrent list, the executive power rests with the states. 2. In respect to matters enumerated in the concurrent list, The legislative power rests with the centre. 3. Residuary powers are assigned to the Parliament. A1 and 3. B2 only. C1, 2 and 3. D3 only. Answer, D. Question 255. Which of the following statements are true about centre-state relations? 1. During the proclamation of emergency, Article 352, the centre can give direction to a state on any matter. 2. During the proclamation of emergency, Article 352, President can modify the constitutional distribution of revenues between the centre and the states. 3. Word Cabinet is mentioned only once in the Constitution under Art. 352. AI only. B2 and 3. C1, 2 and 3. D3 only. Answer, C. Question 256. Which of the following statements are correct? 1. The chairman and members of state PSC are appointed by the governor, but can be removed only by the president. 2. The state election commissioner is appointed by the governor but can be removed only by the president. 3. Finance commission is mentioned under Art. 280 of the Constitution. A1 and 2. B2 only. C1, 2 and 3. D2 and 3. Answer, C. Question 257. Which of the following statement is correct with regard to proclamation of emergency? A resolution approving and disapproving the proclamation of emergency is to be passed by both houses of parliament by a special majority. B. Resolution approving and disapproving the proclamation of emergency is to be passed by either house of parliament by a simple majority. C. Resolution disapproving the proclamation of emergency is to be passed by either house of parliament by a simple majority. D. None of these. Answer, A. Question 258. Which of the following situations will be proper to impose President's rule in a state? Article 356. 1. Where after general elections to the Assembly, no party secures a majority. 2. Serious maladministration in the state. 3. Stringent financial exigencies of the state. AI only. B2 and 3 only. C1 and 3 only. D1, 2 and 3. Answer, A. Question 259. Which of the following situations are correct with regard to proclamation of financial emergency? Article 360. 1. It can be extended to an indefinite period with an approval of the Parliament for every 6 months. 2. A resolution approving the proclamation of financial emergency is to be passed by either House of Parliament by simple majority. 3. The President may issue directions for reduction of salaries and allowances of Supreme Court and High Court judges. AI only. B2 and 3 only. C1 and 3 only. D1, 2 and 3. Answer, B. Question 260. The Electoral College for President's election consists of 1. Elected members of both the Houses of Parliament. 2. Elected members of the Legislative Assemblies. 3. Elected members of all Union territories. A1, B2 and 3. C1 and 2. D1, 2 and 3. Answer, C. Question 261. When the offices of both Speaker and Deputy Speaker falls vacant, Art. 95 provides that other members of Lok Sabha immediately elect a Speaker. B. The senior most willing member of Lok Sabha becomes the Speaker. C. The President appoints any member of Lok Sabha as Speaker. D. The Deputy Chairman of Rajya Sabha presides over till the next Speaker is elected. Answer, C. Question 262. With regard to constitutional amendment bill, A. The President can reject the bill but cannot return the bill. B. The President cannot reject the bill but can return the bill. C. The President can neither reject the bill nor return the bill. D. The President can either reject the bill or return the bill. Answer: C. Question 263. The correct statement S with regard to ordinance making power of President is R1. The President cannot promulgate an ordinance to amend tax laws. 2. The President cannot promulgate an ordinance to amend the Constitution. A1 only. B2 only. C both. D none. Answer: B. Question 264. The Vice President can be removed from office before completion of his term in which of the following manner? A. He can be impeached in similar manner as President. B. A resolution of Rajya Sabha passed by special majority and agreed to by the Lok Sabha. C. A resolution of Rajya Sabha passed by simple majority and agreed to by the Lok Sabha. D. A resolution of Rajya Sabha passed by an absolute majority and agreed to by the Lok Sabha. Answer: D. Question 265. The Council of Ministers does not consist of 1. Deputy Ministers, 2. Parliamentary Secretaries, 3. Deputy Chairman Planning Commission. A1, 2 and 3. B2 only. C3 only. D none of these. Answer: D. Question 266. The representatives of states and UT in the Rajya Sabha are elected by 1. The members of the State Legislative Assembly only. 2. Elected members of the Legislative Assembly of that State Legislative Assembly or Electoral College of the UT as the case may be. 3. The system of proportional representation by single tier unsufferable vote. 4. The system of proportional representation by list. A1 and 3. B1 and 4. C2 and 3. D2 and 4. Answer: C. Question 267. Which of the following criteria is laid down by the Constitution? Read with the Representation of the People Act, 1951, for a person to be chosen a member of Parliament. 1. If a candidate is to contest a seat reserved for SC Cent, he must be a member of a SC Cent in any state or union territory. 2. He/she must not have been punished for preaching and practicing social crimes such as untouchability, dowry and sati. 3. He/she must not have any interest in government contracts, works or services. A1 only. B2 and 3 only. C1, 2 and 3. D none of these. Answer: C. Question 268. Which of the following statements are correct? 1. If an MLA is elected to be an MP, his seat in Parliament becomes vacant if he does not resign his seat in the state legislature within 14 days. 2. If a person is elected to 2 seats in a house, he should exercise his option for one. Otherwise both seats become vacant. A1 only. B2 only. C both. D none. Answer: C. Question 269. As observed by Salmond, jurisprudence is concerned with: A. To discover new rules. B. To reflect all the rules already known. C. To derive rules from authority and apply them to problems. D. Logi. C. Answer: B. Question 270. Who said jurisprudence is formal science of positive law? A. Bentham. B. Stone. C. Austin. D. Holland. Answer: D. Question 271. Who said jurisprudence is nothing but lawyers' extroversion? A. Bentham. B. Stone. C. Austin. D. Holland. Answer: B. Question 272. Who is the author of the book, Taking Rights Seriously? A. R. Dworkin. B. Hart. C. Bentham. D. Tom Bingham. Answer A. Question 273. The concept of law depends largely on the A. Social values. B. Accepted norms. C. Behavioral pattern of the particular society at a given time. D. All of the above. Answer D. Question 274. Law consists of social norms which are A. Coercive. B. Ethical. C. Non-coercive. D. Religious. Answer A. Question 275. Jurisprudence has been defined as the science of first principle of civil law by A. Salmond. B. Holland. C. Gray. D. Patton. Answer A. Question 276. The expression law in jurisprudence is mostly used to denote A. Positive law. B. Negative law. C. Fundamental legal principles. D. Legal systems. Answer C. Question 277. Austin's law is A. Command of sovereign. B. Command of God. C. Command of people. D. Command of constitution. Answer A. Question 278. Which of the following is not a statement from the Austinian theory? A. Every law is a command, imposing a duty, enforced by a sanction. B. Law is a rule laid down from the guidance of an intelligent being by an intelligent being having power over him. C. A legal rule can be defined as one which prescribes a code of conduct which is done with a feeling of such conduct is obligatory. D. If a determinate human superior not in a habit of obedience to a like superior, receives habitual obedience from the bulk of a given society, that determinate superior is sovereign in that society. Answer C. Question 279. Mark the incorrect statement. A. Law do not always command. But confers privileges also, e.g., right to make a will. B. The notion of command is applicable to modern social welfare legislation. C. Austin's notion that sovereignty indivisible is falsified by federal constitutions, e.g., India, USA. D. Austin's insistence on sanctions as a mark of law conceals and distorts the real character and functions of law in a community. Answer B. Question 280. Who said, law consists of rules which are of broad application and non-optional character, but which are at the same time amenable to formalization, legislation and adjudication? A. Hart. B. Salmond. C. Kelson. D. Austin. Answer A. Question 281. Which of the following is not a statement from Hart's theory? A. Law is a system of social rules which acquire the character of legal rules. B. The union of the primary and secondary rules constitute the core of a legal system. C. A legal rule can be defined as one which prescribes a code of conduct, which is done with a feeling that such conduct is obligatory. D. The law is a normative and not a natural science. Answer D. Question 282. Mark the incorrect statement. A. Positive law is made by sovereign and positive morality not by it. B. Positive law is made by the sovereign and positive morality by go. D. C. Positive law is made by the sovereign and positive morality by the consent of the people. D. None of the above. Answer B. Question 283. The pure theory of law advocated by Kelson implies that A theory which excludes everything which is strictly not law. B. A theory which includes everything which is law. C. A theory which includes everything which is strictly law. D. None of the above. Answer A. Question 284. According to Kelson, the law is a system of behavioral norms which can be traced back to some ground norms or basic norms from which they derive their existence. The ground norm, I, must be efficacious too. The ground norm is not deduced from anything else but is assumed as an initial hypothesis. 3 should secure for itself a minimum of effectiveness, and when it ceases to derive minimum of support of people, it is replaced by some other ground norm. Codes AI and 3, B2 and 3, CI 2 and 3, DI and 2. Answer C. Question 285. Mark the incorrect option. A. The province of jurisprudence determined, Austin. B. The concept of law, Hart. C. Vienna School of Legal Thought, Kelson. D. None of the above. Answer D. Question 286. Mark the correct statement. A. Natural law approach is not realistic and practical approach. B. Natural law principles have inspired positive law, constitution and international law. C. Naturalists bid to introduce moral element into a criterion of identification, and laws have the effect of founding law on the value judgment. D. All of the above. Answer D. Question 287. The philosophical school seeks to investigate A. Quest of the law. B. Purpose for which a particular law has been enacted. C. The philosophical basis of the law. D. None of the above. Answer B. Question 288. Law is a product of social life and is not created by arbitrary will of individual but by slow unavoidable advancement of human development. This statement belongs to A. Analytical school. B. Historical school. C. Sociological school. D. None of the above. Answer C. Question 289. Which of the following is incorrectly matched? I. Fuller, Inner Morality 2. Bentham, Utilitarianism 3. Manet, Status of Contract 4. Duguet, Social Solidarity v. Hart Rules on Fundamentals of a Legal System Codes. A. None except I. B. None except 3. C. None except 4. D. None of the above. Answer D. Question 290. Mark the correct option. A. Sources of law, Salmond. B. Nature and sources of law, Gray. C. Des Recht des Besitzes, Sauvigny. D. All of the above. Answer D. Question 291. A legal custom has to possess a sufficient measure of antiquity. Sufficient under the English law means that it must have existed since 1189. The law in India. A. is same. B. does not need a fixed period for which custom must have been in existence for its validity. C. Antiquity is not essential. D. None of the above. Answer B. Question 292. The actual finding of true meaning of particular word in a statute is called A. Interpretation of statute. B. Construction of statute. C. Both A and B. Deharmonization of statute. Answer A. Question 293. It is one of the cardinal principles of delegate legislation that the legislature should not delegate to a subordinate body the power make rules on A. Technical matter. B. Policy matter. C. Matter of inclusion and exclusion. D. Date of commencement of a statute. Answer B. Question 294. Which of the following is not a means for exercising control over delegated legislation? A. Parliamentary control. B. Judicial control. C. Publication of delegated legislation. D. Registration of delegated legislation. Answer, D. Question 295. Mark the incorrect option. A. Literal rule, grammatical or plain meaning rule. B. Golden rule, purpose of legislation. C. Harmonious construction rule, social welfare legislation. D. Literal rule, strict interpretation. Answer, C. Question 296. Which rule of interpretation is employed in the social welfare legislation? A. Literal rule. B. Golden rule. C. Harmonious construction rule. D. Liberal or beneficial construction rule. Answer, D. Question 297. Which rule of construction is applied in the construction of penal statutes? A. Literal rule. B. Golden rule. C. Harmonious construction rule. D. Liberal rule. Answer, A. Question 298. The maxim aegis dem generis means A. Of the same kind or nature. B. When particular words are followed by general words, the general words are constructed as limited to things of the same kind as specified in the particular words. C. Both A and B. D. None of the above. Answer, C. Question 299. Which of the following is an internal aid to construction of a statute? A. Title. B. Preamble. C. Proviso and explanation. D. All of the above. Answer, D. Question 300. The maxim generalia specialibus non deterogant means A. A general later law does not abrogate an earlier special law by mere implication. B. A general later law abrogates an earlier special law by mere implication. C. A special later law does not abrogate an earlier general law by mere implication. D. None of the above. Answer, A. Question 301. Which of the following is not an external aid to construction of a statute? A. Parliamentary debates. B. Statement of object and reasons. C. Books and dictionaries. D. Marginal notes. Answer, D. Question 302. Which of the following statements is the most appropriate in the present-day context? A. Judges did not create any new principles of law through their decisions but simply put a stamp of authority on the already existing principles of law in the society. B. Judicial decisions are not source of law but as the proof of what the law is. C. Judges not only declare law but also make it through their decisions. D. The judges either apply the constitution or legislation or a custom to come to a conclusion. Answer, C. Question 303. Who said, case law is gold in mine while statute law is coin of the realm ready for immediate use? A. Grotius. B. Hugo. C. Puchta. D. Salmond. Answer, D. Question 304. The realist theory is given by A. I. Herring. B. Jayuk. C. Savigny. D. Kelson. Answer, B. Question 305. The making of law by the recognition and application of new rules by the courts themselves in the administration of justice implies A. Judicial precedent. B. Judicial decision. C. Judicial activism. D. Both A and C. Answer, D. Question 306. The doctrine of precedent is of antiquity. While the stare decisis is relatively modern, the latter relates to A. Settled judicial hierarchy of courts and law reports. B. Emergence of concept of sovereignty of parliament. C. A point of law settled by a judicial decision. D. None of the above. Answer, C. Question 307. Ratio decidendi of a case can be defined as the a. Material facts of the case plus the decision thereon. B. Obiter dicta of the case plus the decision thereon. C. The decision of a case. D. None of the above. Answer A. Question 308. The decision of the Supreme Court are bounded on A. All court within the territory of India, including Supreme Court. B. High courts only. C. All courts within the territory of India, except Supreme Court. D. Indians living abroad. Answer C. Question 309. According to who, ratio decidendi is nothing more than the decision based on the material facts of a case. A. Dias. B. Wamborg. C. Gugarth. D. Bentham. Answer C. Question 310. Who said, a right is a faculty which resides in a determinate party or parties by virtue of a given law and which avails against a party or parties other than the party or parties in whom it resides? A. Austin. B. Salmond. C. Hart. D. Kelson. Answer A. Question 311. Which of the following is incorrect in relation to right in its various forms and its opposites? A. Claim, duty. B. Liberty, no claim. C. Power, liberty. D. Immunity, disability. Answer C. Question 312. Mark the incorrect options. A. Liberty, freedom from the claim other. B. Duty gives content to the claim of a person. C. Power, ability of a person to change relations. D. Absolute duty, have a correlative claim. Answer D. Question 313. In India, it is a duty of every citizen to respect national flag, protect culture et. C. It is A. Absolute duty. B. Relative duty. C. Secondary duty. D. None of the above. Answer A. Question 314. What is the main element of a right? A. Will. B. Interest. C. Both A and B. D. Coercion. Answer C. Question 315. A jural relation between A. Person and person. B. Person and a thing. C. Person and state. D. Person and object. Answer A. Question 316. Duties without a corresponding rights are called A. Absolute duty. B. Relative duty. C. Secondary duty. D. None of the above. Answer A. Question 317. A gives B 600 rupees as a consideration for a contract. Now A has A. Power. B. Privilege. C. Claim. D. Immunity. Answer C. Question 318. Mark the incorrect option. A. Immunity, freedom from the power of another. B. Disability, absence of power. C. Nemo dat quod non habet, disability on the part of persons in general to answer for property that they do not themselves own. D. Disability, no right. Answer D. Question 319. Duty implies A. Obligation. B. An act that opposite of which would be wrong. C. One may perform a certain act. D. None of the above. Answer B. Question 320. Which of the following is incorrect in relation to right in its various forms and its opposites? A. Right, no right. B. Liberty, duty. C. Power, immunity. D. Immunity, liability. Answer C. Question 321. When a power is coupled with a liberty to exercise it, it is called A. Discretionary power. B. Ministerial power. C. Wrongful power. D. Relative power. Answer A. Question 322. A primary right can be A right in rem only, B right in personam only, C either A or B, D none of the above. Answer C. Question 323. All cases of damnum sine injury are cases of A. Disability, B. Liability, C. Liberty, D. No right. Answer D. Question 324. Which of the following is not mentioned in the Hoffeldian scheme? A. Jural correlatives, B. Jural opposites, C. Jural contradictories, D. None of the above. Answer C. Question 325. A right in personam is A. Available only against a particular person, B. Available against person in general, C. A positive right, D. Both A and C. Answer D. Question 326. The object of right is called A. Juice, B. Race, C. Sign, D. Lakes. Answer B. Question 327. A time-barred claim is A. Perfect right, B. Imperfect right, C. Right in rem, D. None of the above. Answer B. Question 328. A person is any being whom the law regards as capable of A. Rights only, B. Duties only, C. Rights or duties, D. None of the above. Answer C. Question 329. Legal theory assumes that a person is an entity which is capable of suing and being sued. D. In view of this, which of the following are not a legal person? A. Idiots, B. Lunatics, C. Dead persons, D. All of the above. Answer D. Question 330. Who said the child in womb is not a legal personality and can have no right? A. Savigny, B. Bentham, C. Patton, D. Salmond. Answer C. Question 331. Natural persons being human beings are A. Person in fact, B. Person in law, C. Both A and B, D. None of the above. Answer C. Question 332. A company is vested with a distinct corporate personality from the members who compose it. Was held in A. Salomon vs. Salomon & Co., B. Daimler Co. Lieutenant, D. vs. Continental Tire Co., C. Bridges vs. Hawkeshworth, D. Both A and B. Answer A. Question 333. The main purpose of corporate soul is A. Protect the property of the governed, B. Maintain continuity of an office, C. Make the property easily transferable, D. Make the property easily inheritable. Answer B. Question 334. An incorporated group of coexisting persons. A. Corporation soul, B. Corporation aggregate, C. Individual, D. Institution. Answer B. Question 335. Who amongst the following was the propounder of the theory that says, the movement of the progressive societies has hitherto been a movement from status to contract? A. Hugo, B. Burke, C. Henry Manet, D. Herbert Spencer. Answer C. Question 336. Law is the sum of the conditions of social life in the widest sense of the term, as secured by the power of the state through the means of external compulsion. This statement relates to A. Historical school, B. Analytical school, C. Natural law school, D. Sociological school. Answer D. Question 337. Which one of the following is not natural law? A. Living law. B. Divine law. C. Universal law. D. Moral law. Answer: A. Question 338. A right with me is a child of law ____ natural law is a son that never had a father. Who said this? A. Jeremy Walden. B. Bentham. C. Salmond. D. Patton. Answer: B. Question 339. Which of the following pairs are jural correlatives? 1. Power, liability. 2. Power, disability. 3. Liberty, duty. 4. Immunity, disability. Of the above pairs, choose the answer. A. 1 and 3 are correct. B. 2, 3 and 4 are correct. C. 1 and 4 are correct. D. 1, 3 and 4 are correct. Answer: C. Question 340. The concept of social engineering is at the root of the definition of law given by A. Savigny. B. Roscoe. C. Hegel. D. Ehrlich. Answer: B. Question 341. Do you know how they make it? Just as a man makes law for his dog. This famous statement on judge-made law was made by A. Aristotle. B. Plucknet. C. Montesquieu. D. Bentham. Answer: D. Question 342. Who amongst the following treats law as a system of rules? A. Allen. B. Hart. C. Jenks. D. Lloyd. Answer: B. Question 343. In order that a local custom may be valid operative as a source of law, which of the following requirements besides antiquity to be satisfied? 1. Reasonableness. 2. Conformity with the statute. 3. Observance as matter of moral right. Select the answer using codes given below. A. 1 and 2. B. 1, 2 and 3. C. 2 and 3. D. 1 and 3. Answer: A. Question 344. The idea of natural law first appeared in A. French Revolution. B. American War of Independence. C. Roman law. D. Greek thinking. Answer: D. Question 345. Consider the following statements. 1. Precedents are created by the judges. 2. A precedent is not binding if it is inconsistent with a statute. 3. Precedent can sometimes be created by legislation. Choose the answer. A. 1, 2 and 3 are correct. B. 1 and 3 are correct. C. 1 and 2 are correct. D. 2 and 3 are correct. Answer: C. Question 346. Who is generally considered as the founder of the historical school of jurisprudence? A. Hegel. B. Savigny. C. Karl Marx. D. Immanuel Kant. Answer: B. Question 347. Which of the following statement is correct? A. Possession in fact confers actual right to property. B. Possession in fact exists only when a person has immediate physical control of the thing. C. Possession in fact also extends to things which are beyond a person's immediate physical control. D. Possession in fact is possible only when the possessor has the legal right to possess. Answer: B. Question 348. Sovereignty according to Austin has the characteristics: A. Positive and negative both. B. Positive only. C. Negative only. D. Internal. Answer: A. Question 349. Consider the following 4 types of legal doctrines. 1. Volksgeist. 2. Imperative theory of law. 3. Social engineering. 4. Social solidarity. Identify the correct order in terms of time in which they appeared. A. 1, 2, 3 and 4. B. 3, 4, 1 and 2. C. 2, 1, 3 and 4. D 2, 1, 4 and 3. Answer, D. Question 350. Who opines that codification is the reduction of the whole corpus juris so far as practicable in the form of enacted law? A. Savigny, B. Salmond, C. Hobbes, D. Pollock. Answer, B. Question 351. Who among the following said that the ownership is a right indefinite in point of user, and restricted in point of disposition and unlimited in point of duration? A. Austin, B. Kelson, C. Holland, D. Hart. Answer, A. Question 352. The celebrated essay determining ratio decidendi of case was written by A. Goodarth, B. Winfield, C. Oppenheim, D. Stone. Answer, A. Question 353. The author of the book Province of Jurisprudence Determined is A. Bentham, B. Austin, C. Kelson, D. Hart. Answer, B. Question 354. Which one of the following does not come within the ambit of ownership? A. Right to possess, B. Right to dispose, C. Right to use and enjoy, D. Right to destroy. Answer, B. Question 355. Which one of the following jurists was hostile to the natural law of school? A. Immanuel Kant, B. Jeremy Bentham, C. Stamler, D. John Rawls. Answer, B. Question 356. Which one of the following cases does not relate to possession? A. Bridges vs. Hawkesworth, B. R vs. Moray, C. London Street Tramways vs. LCC, D. Towers & Co. Ltd vs. Gary. Answer, C. Question 357. According to Austin, which of the following is not an essential element of law? A. Command, B. Ideal, C. Duty, D. Sanction. Answer, B. Question 358. Which one of the following is not an essential element of custom? A. Certainty, B. Reasonableness, C. Continuance, D. Moral force. Answer, D. Question 359. Which of the following is not a characteristic of legal right? A. Person of inheritance, B. Person of incidence, C. Subject matter of right, D. Novation of right. Answer, D. Question 360. Point out incorrect response. A. I.B.C. and claim are correlative, B. Claim and duty are correlative, C. Power and liability are correlative, D. Immunity and disability are correlative. Answer, A. Question 361. Which one of the following schools adhered to the view that law is found not made, it is self-existent? A. Analytical school, B. Historical school, C. Sociological school, D. Realist school. Answer, B. Question 362. Which one of the following is not a legal mode of acquisition of possession? A. Taking, B. Delivery, C. By acquisition, D. By operation of law. Answer, C. Question 363. Match list I with list 2 and select the answer by using the code given below the lists. List I, list 2. A. Historical School 1, Aquinas, B. Sociological School 2, Bentham, C. Natural Law 3, Auguste Comte, D. Analytical School 4, Puchta Codes. A. ABC D 3421, B 4312, C 1234, D 2143. Answer, B. Question 364. According to Salmond, supreme legislation refers to A. Colonial legislation, B. Executive legislation, C. Judicial legislation. D. Law made by the Parliament. Answer D. Question 365. The constitutional basis of the doctrine of precedent is found in A. Article 12. B. Article 136. C. Article 141. D. Article 14. Answer C. Question 366. The original author of the book, The Limits of Jurisprudence Defined, is A. Austin. B. Stuart Mill. C. David Hume. D. Bentham. Answer D. Question 367. Which of the following jurists is not related to historical school of jurisprudence? A. H. B. Savigny. C. Henry Manet. D. Hegel. Answer A. Question 368. Match list I with list 2 and select the correct answer using the codes given below. List I, list 2. A. Utilitarian individualism 1. Duguet. B. Social engineering 2. I. Herring. C. Social solidarity 3. Bentham. D. Social utilitarian 4. Roscoe Pound. A. ABCD 1 2 3 4. B 2 3 4 1. C 3 4 1 2. D 3 2 4 1. Answer C. Question 369. Right of eligible employees to be considered for promotion is virtually a part of fundamental right of employees, was decided by the Supreme Court in A. Union of India versus Hemraj Singh Chauhan. B. Supreme Court Employees Association versus Union of India. C. John Wallamatam versus Union of India. D. St. Stephen's College versus University of Delhi. Answer A. Question 370. Sunil Batra versus Delhi Administration is a landmark case on A. Aut fois acquit. B. Bias. C. Habeas corpus. D. Mandamus. Answer C. Question 371. Using codes given below, find out correct answer was administrative law deals with I. The powers of constitutional authorities. 2. The powers of judicial authorities. 3. The powers of the administrative authorities. 4. The powers of the legislative authorities. Codes A only, I, and 2 are correct. B only, 2 is correct. C only, 3 is correct. D, I, 2, 3, and 4 are correct. Answer C. Question 372. Match list I with list L using codes given below. List I, list 2, I. There is no rigid formula for principles 1. R.S. Thus versus Union of India of Natural Justice. 2. Choice of application of rules of 2. R versus Sussex Justice. Natural justices. 3. Justice should not only be done. 3. Union of India versus P.K. Roy but manifestly and undoubtedly be seen to be done. 4. Meaning of bias 4. Seki. To gov.tr Support Depth versus Munuswamy Codes. I, 2, 3, 4, 2413. B3142. C1324. D3124. Answer D. Question 373. Read assertion I and reason R and find out answer using codes given below. Assertion I. Legitimate expectation does not grant an absolute right to a claimant. Reason R. Legitimate expectation protects the right of fair hearing before a decision which results in negating a promise or withdrawing an undertaking being taken. Codes I, and R are true and R is correct explanation of I. B, and R are true, but R is not correct explanation of I. C. A is true and R is false. D. A is false and R is true. Answer A. Question 374. Which of the following statement is correct? A. Gullapalli Nageshwar Rao vs. State of AP is about bias. B. K.L. Tripathi vs. State Bank of India is about right of cross-examination. C. General Medical Council vs. Speakman is about irrelevance of principles of natural justice, if in reaching a decision, the principles make no difference. D. N. Kalindi W.S. Tata Locomotives is about the right of representation by a lawyer being considered to be a part of natural justice and it can be claimed as of right. Answer B. Question 375. Abuse of discretion can be inferred from the following circumstances. Find out the answer from the codes given below. 1. Non-application of min. D. 2. Colorable exercise of power. 3. Non-observance of audi alterum partem. 4. Irrelevant considerations. Codes. A. Only I is correct. B. Only I and 2 are correct. C. Only 2 and 3 are correct. D. Only 2, 3 and 4 are correct. Answer D. Question 376. What was the principle laid down by the Supreme Court in A.K. Kripak vs. Union of India? Find answer from the following statements. A rule of law is embedded in Article 14 of the Constitution of India. B. Judicial review is a part of basic structure of the Constitution. C. Principles of natural justice are applicable to administrative proceedings. D. Post-decisional hearing would be sufficient for the observance of principles of natural justice. Answer C. Question 377. Find answer from the following statement. A quasi-judicial body may never review its own decision unless authorized by the statute. B. A quasi-judicial body may review its own decision if there is grave error of law in. C. A quasi-judicial body may review its own decision if there is violation of natural justice. D. All tribunals may review their decisions. Answer A. Question 378. Doctrine of forum prorogatum means a jurisdiction cannot be conferred upon an existing tribunal not otherwise competent by the litigants during the proceedings. B. Jurisdiction can be conferred upon an existing tribunal not otherwise competent by the litigants during the proceedings. C. Jurisdiction can be conferred upon an existing tribunal not otherwise competent by the litigants after the proceedings. D. None of the above. Answer B. Question 379. Which one of the following is not basic source of administrative law? A. Custom. B. Delegated legislation. C. Ordinance promulgated by Governor. D. Reports of the committees and commission. Answer A. Question 380. Which of the following statements is true? A. Mandamus lies against quasi-judicial order. B. Mandamus is issued where inferior court declined jurisdiction. C. Mandamus may be issued, even if alternate remedy is available. D. Mandamus may be issued even no legal right of petitioner subsists. Answer B. Question 381. The rule of audi alterum partem requires reasonable opportunity of hearing. Hearing may be A. Only in writing. B. Only orally. C. Written or oral. D. Written and oral both. Answer C. Question 382. The High Court can exercise the supervisory jurisdiction over the courts and tribunals subordinate to it under A. Article 32. B. Article 226. C. Article 227. D. Article 141. Answer, C. Question 383. The appropriate writ issued by Supreme Court to quash the appointment of a person to a public office is A. Certiorari, B. Mandamus, C. Prohibition, D. Quo warranto. Answer, D. Question 384. What are exceptions to the rule of natural justice? Answer using codes given below. I. Exclusion by statutory provisions. 2. Exclusion by constitutional provision. 3. Exclusion in case of legislative act. 4. Exclusion in public interest. Codes. A. Only I is correct. B. Only I and 2 are correct. C. Only I, 2 and 3 are correct. D. All of above are correct. Answer, D. Question 385. Read assertion A and reason R and find answer using codes given below. Assertion A. In India the order passed in violation of the principles of natural justice is VOL. D. Reason R. In India there is void in the area of principles of justice by nature. Codes A and R are true and R is correct explanation of A. B. A and R are true, but R is not correct explanation of A. C. A is true, but R is false. D. A is false, but R is true. Answer, C. Question 386. In which of the following conditions the abuse of discretionary power is inferred? I. Use for improper purpose. 2. Mala fide. 3. Relevant consideration. 4. Leaving out irrelevant consideration. Answer using codes given below. Codes. A. Only I is correct. B. Only I and 2 are correct. C. Only I, 2 and 3 are correct. D. All of above are correct. Answer, B. Question 387. Administrative law is the law concerning the powers and procedures of administrative agencies, including especially the law governing judicial review of administrative action. This definition of administrative law is given by A. Ivor Jennings, B. Garner, C. K. C. Davis, D. Wade. Answer, C. Question 388. In which of the following grounds a right of certiorari may be issued? A. Error of jurisdiction. B. Error apparent on face of record. C. Violation of natural justice. D. All of the above. Answer, D. Question 389. Answer the following using the codes given below. Administrative law deals with I. Composition, powers and functions of the administrative authorities. 2. Procedures to be followed by the administrative authorities in the exercise of their powers and functions. 3. Methods of control of powers of the administrative authorities. 4. Remedies available to a person in case of violation of his rights by the administrative authorities. Codes. A. Only I is correct. B. Only I and 2 are correct. C. Only I, 2 and 3 are correct. D. All of the above are correct. Answer, D. Question 390. Read assertion A and reason R, and with the help of codes given below, point out the correct explanation. Assertion A. One of the principles of natural justice is, no man shall be judge in his own cause. Reason R. Principles of natural justice require fair play in action. A. Codes A and R are true and are is the correct explanation of A, B, A, and are true, but are is not the correct explanation of A. C. A is true and R is false. D. A is false and R is true. Answer A. Question 391. Match list I with list 2 and indicate the answer using the codes given below. List I, list 2, I, A.K. Cr.P.C 1. Post-decisional hearing versus Union of India. 2. Manak Lal versus 2. Personal bias Dr. Prem Chand. 3. Maneka Gandhi 3. Pecuniary bias versus Union of India. 4. Olga Tellis versus 4. Reasonable opportunity of hearing Bombay Municipal Corporation. A codes I 2 3 4 1 2 3 4. B 1 3 4 2. C 2 3 1 4. D 3 2 4 1. Answer C. Question 392. Answer the following using the codes given below. Which of the following doctrines were developed by the court to control the administrative actions? I. Doctrine of promissory estoppel. 2. Doctrine of legitimate expectations. 3. Doctrine of separation of power and rule of law. 4. Judicial activism. A codes only I, 2, and 3 are correct. B only 2 and 4 are correct. C only I and 3 are correct. D all of the above are correct. Answer D. Question 393. Answer the following using the codes given below. In which of the following grounds the judicial review of an administrative action be made? I. Abuse of discretion. 2. Mala fide or bad faith. 3. Irrelevant consideration. 4. Unreasonableness. A codes only I, 2, and 3 are correct. B only I and 2 are correct. C only 2 and 3 are correct. D all I, 2, 3 and 4 are correct. Answer D. Question 394. A writ of mandamus will not lie against A. President of India. B. Parliament. C. Local authorities. D. Courts and tribunals. Answer A. Question 395. Match list I with list 2 and indicate the answer using the codes given below. List I, list 2, 1. Bring the body 1. Writ of mandamus before the court. 2. Petitioner's legal 2. Writ of mandamus right to compel the performance of public duty. 3. By what authority? 3. Writ of habeas corpus a person is holding the public post. 4. Action of 4. Writ of quo warranto subordinate court in violation of the principles of natural justice. A codes I, 2, 3, 4, 1 2 3 4. B 3 1 4 2. C 3 2 1 4. D 3 4 2 1. Answer B. Question 396. According to AIBE in India, the rule of law is embodied in A. Article 12 of the Constitution of India. B. Article 13 of the Constitution of India. C. Article 14 of the Constitution of India. D. Article 21 of the Constitution of India. Answer C. Question 397. When the court declared that certain provisions of the Act as invalid, it does not affect the validity of the Act and it remains as it is. The principle is known as A. Doctrine of prospective overruling. B. Doctrine of severability. C. Doctrine of pleasure. D. Doctrine of eclipse. Answer B. Question 398. Find answer. Administrative law is the law relating to the powers and procedures of a. The Parliament, b. the legislature, c. the administrative authorities, d. judiciary. Answer, c. Question 399. Find the answer. The principles of natural justice are: I. No person can be judge in his own case. 2. No person shall be condemned. A. Codes, only, I, is correct. B. Only, 2, is correct. C. I, and, 2, are correct. D. None of the above are correct. Answer, C. Question 400. Find answer. Administrative tribunals exercises: A. Purely administrative functions. B. Purely judicial functions. C. Purely legislative functions. D. Quasi-judicial functions. Answer, D. Question 401. What is the effect of violation of the rule, audi alterum partem, on an administrative action? A. Mere irregularity. B. Null and void. C. An illegality. D. Voidable. Answer, D. Question 402. In which of the following cases, the Supreme Court held that the principles of natural justice are applicable to administrative proceedings? A. M. C. Mehta vs. Union of India. B. Maneka Gandhi vs. Union of India. C. A.K. Kripak vs. Union of India. D. SMT Indira Nehru Gandhi vs. Rajnarayan. Answer, C. Question 403. Find answer. The writ of prohibition may be issued when there is: A. An absence of jurisdiction or abuse of jurisdiction. B. Violation of principles of natural justice and fraud. D. C. Any kind of contravention of the law the land. D. D. All of the above. Answer, A. Question 404. Find answer. The writ of certiorari necessarily implies that A. An error of fact cannot correct. D. B. An error of law apparent on the face of the record can be correct. D. C. Violation of natural justice. D. None of the above. Answer, B. Question 405. Assertion: A. The principles of natural justice ensures fair hearing. Reason: R. It requires unbiased judge to decide after hearing all parties. A. Codes, both A and R are true and R is good explanation of A. B. Both A and R are true and R is not a good explanation of A. C. A is true, but R is false. D. A is false, but R is true. Answer, A. Question 406. Prerogative writs to review an administrative action are: A2. Writ of habeas corpus and writ of mandamus. B3. Writ of habeas corpus and writ of mandamus and writ of prohibition. C4. Writ of habeas corpus and writ of mandamus and writ of prohibition and writ of certiorari and writ of quo warranto. D5. Writ of habeas corpus, writ of mandamus, writ of quo warranto, writ of certiorari and writ of prohibition. Answer, D. Question 407. A mandatory procedural requirement for an administrative tribunal must be: A. Legal representation. B. Cross-examination. C. Reasoned decision. D. All of the above. Answer, C. Question 408. Judicial review of an administrative action means: A. Review by the Parliament. B. Review by the government. C. Review by the Legislative Assembly. D. Review by the judiciary. Answer, D. Question 409. Find answer: Administrative law is a branch of public law and is only a part of constitutional law. It cannot control the constitutional law. B. Administrative law is a branch of private law. C. Administrative law is independent to constitutional law. D. Administrative law is neither the branch of public law nor of private law, but a part of constitutional law. Answer: A. Question 410. The first committee to recommend for the establishment of an ombudsman type of institution in India was A. Gorwala Committee, B. Santhanam Committee, C. Kripalni Committee, D. Administrative Reforms Commission. Answer: B. Question 411. The chairman of which of the following parliamentary committees is invariably from the members of ruling party? A. Committee on Public Undertakings, B. Public Accounts Committee, C. Estimates Committee, D. Committee on Delegated Legislation. Answer: C. Question 412. The judicial control over administrative acts emanate from the doctrine of A. Separation of powers, B. Judicial review, C. Rule of law, D. Delegated legislation. Answer: B. Question 413. The Committee on Public Undertakings was set up on the recommendation of A. Administrative Reforms Commission, B. Lanka Sundaran, C. Krishna Menon Committee, D. Chitla Commission. Answer: C. Question 414. The chairman of which of the following committee is generally from the opposition party? A. Estimates Committee, B. Committee on Public Undertaking, C. Public Accounts Committee, D. Committee on Assurances. Answer: C. Question 415. Which of the following is exclusively a committee of the lower house Lok Sabha? A. Committee on Assurances, B. Committee on Delegated Legislation, C. Committee on Public Undertakings, D. Estimates Committee. Answer: D. Question 416. Central Vigilance Commission was set up on the recommendation of A. Administrative Reforms Commission of India, B. Gorwala Report, C. Kripalni Committee, D. Santhanam Committee. Answer: D. Question 417. The institution of Lokayukta was created for the first time by the state of A. Odisha, B. Bihar, C. Punjab, D. Maharashtra. Answer: D. Question 418. In the context of judicial control over administration, malfeasance stands for A. Error of law, B. Error of fact-finding, C. Abuse of authority, D. Error of procedure. Answer: C. Question 419. Which of the following is not correctly matched? A. Central Bureau of Investigation, 1941, B. Special Police Establishment, 1941, C. Prevention of Corruption Act, 1947, D. Central Vigilance Commission, 1964. Answer: C. Question 420. Which of the following statements are incorrect about the difference between the writ jurisdiction of the Supreme Court and High Courts in India? 1. The Supreme Court can issue writs not only for the purpose of enforcement of fundamental rights but also for any other purpose, whereas High Courts can issue writs only for the purpose of enforcement of fundamental rights. 2. High Courts can issue the writ of injunction, whereas the Supreme Court cannot issue the writ of injunction. 3. The Supreme Court can issue writs only in the case of appeal, whereas High Courts can issue writs only when the party directly approaches it. 4. High Courts can issue writs not only for the purpose of enforcement of fundamental rights but also for any other purpose, whereas the Supreme Court can issue writs only for the purpose of enforcement of fundamental rights. A1 and 2. B1, 2 and 3. C2 and 3. D3 and 4 only. Answer, B. Question 421. In countries with parliament, like India, legislative control over administration is considerably reduced and restricted effectiveness due to which of the following reasons? 1. The expansion in the volume and variety of administrative work. 2. Frequent use of guillotine. 3. The large size of the legislature. 4. The members of the legislature are laymen. 5. The financial committees do post-mortem work. A1, 2 and 5. B2, 3 and 4. C2, 3, 4 and 5. D1, 2, 3, 4 and 5. Answer, D. Question 422. Which of the following are the means of judicial control over administration? 1. Suits against government. 2. Judicial review. 3. Rule of law. 4. Statutory appeal. 5. Droit administratif. A1, 2 and 3. B1, 2 and 4. C2, 4 and 5. D1, 3 and 5. Answer, B. Question 423. Which of the following are the limitations of judicial control over administration? 1. Its intervention takes place only when it is sought by the affected person. 2. It is a post-mortem control. 3. Statutory limitations. 4. Error of fact-finding. 5. Technical nature of the administrative activities. A1, 2 and 3. B2, 3 and 5. C2, 3 and 4. D1, 2, 3 and 5. Answer, D. Question 424. Which of the following are incorrect statements about the Central Vigilance Commission? 1. It was set up on the recommendations of Administrative Reforms Commission. 2. It is headed by the Central Vigilance Commissioner appointed by the Prime Minister. 3. Its functions, in certain cases, overlap with the functions of UPS. C4. It is certainly a substitute for an ombudsman. 5. It receives complaints directly from aggrieved persons. A1, 2 and 5. B3 and 5. C1, 2 and 4. D2, 3 and 5. Answer, C. Question 425. The primary object of judicial control over administration is: A. To restrict the discretion and arbitrariness of administrative agencies. B. To help in redressing the grievances of citizens. C. To safeguard the rights and liberty of the citizens. D. To contain and penalize the wrongful acts of government officials. Answer, C. Question 426. Match the following, list I list 2, provisions, contained in 1. Writ jurisdiction of 1. Article 13 The Supreme Court. 2. Suits against government. 2. Article 226 meant. 3. Writ jurisdiction of 3. Article 300 The High Court. 4. Source of the power. 4. Article 32 of Judicial Review. A. Codes 1, 2, 3, 4, 4123. B. 3214. C. 4321. D. 1432. Answer, C. Question 427. Consider the following statements. 1. The chairman of the Committee on Public Accounts is appointed by the Speaker of the Lok Sabha. 2. The Committee on Public Accounts comprises members of Lok Sabha, members of Rajya Sabha and a few eminent persons of industry and trade. Which of the statements given above are correct? A1 only. B2 only. C both 1 and 2. D neither 1 nor 2. Answer A. Question 428. In the Parliament of India, the purpose of an adjournment motion is A. To allow a discussion on a definite matter of urgent public importance. B. To let opposition members collect information from the ministers. C. To allow a reduction of specific amount in demand for grant. D. To postpone the proceedings to check the inappropriate or violent behavior on the part of some members. Answer A. Question 429. Which of the following are the methods of parliamentary control over public finance in India? 1. Placing annual financial statement before the Parliament. 2. Withdrawal of monies from Consolidated Fund of India only after passing the appropriation bill. 3. Provision of supplementary grants and vote on account. Select the answer using the codes given below. A. Codes 1 only. B. 1 and 2 only. C. 2 and 3 only. D. 1, 2 and 3. Answer D. Question 430. In India, other than ensuring that public funds are used efficiently and for intended purpose, what is the importance of the Office of the Comptroller and Auditor General, CAG? 1. CAG exercises exchequer control on behalf of the Parliament when the President of India declares national emergency, financial emergency. 2. CAG reports on the execution of projects or programs by the ministries are discussed by the Public Accounts Committee. Which of the statements given above are correct? A. 1 only. B. 2 only. C. Both 1 and 2. D. None of them. Answer B. Question 431. Consider the following statements. The Parliamentary Committee of Public Accounts 1. Consists of not more than 25 members of the Lok Sabha. 2. Scrutinize appropriation and finance accounts of the government. 3. Examines the report of the Comptroller and Auditor General of India. Which of the statements given above are correct? A. 1 only. B. 2 only. C. 2 and 3 only. D. 1, 2 and 3. Answer C. Question 432. The functions of Estimate Committee include 1. To suggest alternative policies in order to bring out efficiency and economy in administration. 2. To see that the expenditure conforms to the authority which governs it. 3. To examine whether the money is well laid out within the limits of the policy implied in the estimates. 4. To suggest the form in which estimates shall be presented to the Parliament. Which of the above, the correct statement are? A. 1 and 2. B. 1, 3 and 4. C. 1, 2 and 4. D. 1, 2, 3 and 4. Answer B. Question 433. Assertion A. Parliamentary control over public expenditure is diminished by the creation of the Contingency Fund of India. Reason The Contingency Fund of India is operated by the executive on behalf of the President of India. Select the correct code. A. Both A and R are true and R is the correct explanation of A. B. Both A and R are true but R is correct explanation of A. C. A is true but R is false. D. A is false but R is true. Answer A. Question 434. An act is crime, in the content of Indian law, as A. It is so declared by public. C. B. It is so dictated by morality. C. Statute makes it. D. Common law has declared it. Answer C. Question 435. Mark the answer. A. Crime is essentially an immoral act. B. Crime is an illegal act. C. Crime is essentially a socially reprehensible act. D. Crime is essentially an anti-religious act. Answer C. Question 436. Criminal law consists of a. Definition of offenses and punishment for them, I.P.C. b. Procedure for investigation, prosecution, trial, Cr.P.C, et. C. It includes prevention of offenses as well. D. All are correct. Answer, D. Question 437. In order that an act should be punishable, it must be morally blameworthy. It must be a sin. Which of the following judges made this observation? A. Salmond, B. Krishna Iyer, C. Lord Denning, D. Stephen. Answer, C. Question 438. The I.P.C. was enacted on A. 6 October 1860, B. 1 September 1872, C. 1 July 1882, D. 6 December 1890. Answer, A. Question 439. The draft of I.P.C. was prepared by A. Dr. Hari Singh Gaur, B. Lord Macaulay, C. D. F. Mullah, D. Kenney. Answer, B. Question 440. I.P.C. Act XLV of 1860 is divided into A. 21 chapters and 503 sections, B. 23 chapters and 511 sections, C. 22 chapters and 511 sections, D. 23 schedules and 511 sections. Answer, B. Question 441. Section 1 of the I.P.C. talks about the A. Definition of crime, B. Title and jurisdiction of the code, C. Title and extent of operation of the code, D. Title and object of the code. Answer, C. Question 442. Mark the correct statement. The penal code applies to every person in any part of India for every act or omission contrary to the provisions of the code. B. The code applies to any offence committed by any citizen of India without and beyond India. C. Every act committed outside India which, if committed in India, would be punishable under the code. D. All of the above. Answer, D. Question 443. If a person who is a citizen of India commits any offence out of India, he A. cannot be prosecuted in India, as the act was not committed in India. B. can be prosecuted in the country where the offence was committed. D. C. can be prosecuted in India in any place in which he may be found. D. cannot be prosecuted neither in India, nor in the country where the crime was committed. Answer, C. Question 444. Under which of the following situations would Indian courts have jurisdiction? I. Crime committed by an Indian in a foreign country. 2. Crime committed by a foreigner in India. 3. Crime committed by a person on an Indian ship. Codes A. I and 2. B. I and 3. C. 2 only. D. I, 2 and 3. Answer, D. Question 445. Mark the correct statements. A. The Indian Penal Code prescribes no fixed time within which prosecution should be launched. D. B. The code follows the maxim nullum tempus occurret regi. C. The Criminal Procedure Code introduced the concept of limitation. D. All of the above. Answer, D. Question 446. Which of the following statement is incorrect? A. Crime is a branch of public law. B. To constitute crime, mens rea is required. D. C. In crime, statute has no control over proceedings. D. In crime, there is a punishment. Answer, C. Question 447. Which of the following statements is correct? Other categories of the criminal should be determined by general laws. B. The penal statutes should be strictly followed or constructed. D. C. There should be ex post facto penal laws. D. The persons should be punished without an act. Answer B. Question 448. Special law, as defined in Section 41, I.P.C. means A. A law applicable to a particular subject. B. A law applicable to a particular part of India. C. A law applicable to a class. D. A law applicable to a local community. Answer A. Question 449. The term offense means A. A thing made punishable by the penal code. B. A thing punishable by the penal code or any special or local law, in certain case. C. Both A and B. D. None of the above. Answer C. Question 450. The essential ingredients of a crime are A. Motive, mens rea and actus reus. B. Motive, intention and knowledge. C. Mens rea and actus reus. D. Knowledge, intention and action. Answer C. Question 451. Actus reus is defined as such result of human conduct as the law seeks to prevent. In the light of this observation, which following statements is incorrect? A. Actus reus means an act of omission or commission, which is called conduct. B. Actus reus means a conduct prohibited by law. C. Actus reus means a voluntary as well as involuntary human actions. D. Actus reus includes results of an act, i.e., injury. Answer D. Question 452. Section 497, I.P.C. defines adultery, thus, whoever has sexual intercourse with a person who is and whom he knows, or has reason to believe to be the wife of another. Here, actus reus relates to A. Time. B. Place. C. Person. D. Married woman. Answer D. Question 453. The maxim, actus non facet reum, nisi mens sit re means A. Guilty minds gives birth to crime. B. There can be no crime without a guilty man. D. C. Crime is a child of guilty men. D. Criminal mind leads to crime. Answer B. Question 454. Which of these is a landmark judgment on the applicability of Section 303 in a criminal trial? A. Valsa Singh vs. State of Punjab. B. Inder Singh vs. State of Pepsu. C. Brij Bhushan vs. State. D. R. Venkalu vs. State of Hyderabad. D. Answer A. Question 455. In the context of criminal liability, state which of the following statements is correct. A. Mens rea is a mandatory element of a crime and there cannot be any crime without mens rea. B. In its nature, the criminal liability is less punitive and more prohibitive. C. Criminal liability generally implies mens rea, except where it has been expressly excluded. D. The punishment is commensurate with the act. Answer C. Question 456. Match list I and list 2 and select the correct answer using the codes given below the lists. List I, list 2. A. Mens rea 1. Always not necessary. B. Motive 2. Condition precedent for any offense. C. Law presumes innocence 3. Relevant and to impute intention. D. Knowledge of the act to be 4. Until crime is proved beyond doubt. Unlawful. A. Codes A-1 B-2 C-3 D-4. B A-2 B-3 C-4 D-1. C A-4 B-3 C-2 D-1. D A-2 B-1 C-3 D-4. Answer B. Question 457. Which one of the following statements correctly describes the concept of mens rea? A. Mens rea need to be present at the stage of planning, but not at the stage of commission of the offense. B. Mens rea should be excluded unless the statute specifically requires it to be proved. D. C. Absolute prohibition is not required to negate mens rea. D. If the statute is silent about mens rea, as a general rule it should be read into the statute. Answer: D. Question 458. Local law as defined in say C42 I.P.C. means A. A law applicable to a particular subject. B. A law applicable to a particular part of India. C. The municipal law. D. A law applicable to a local community. Answer: B. Question 459. Give the correct response. A. The word attempt clearly conveys the idea that if attempt succeeded, the offense would have been committed. D. B. Attempt is the direct movement towards the commission of an offense after preparation has been made. C. If the actual transaction has commenced which would have ended in the crime if not interrupted, there is clearly an attempt to commit crime. D. All acts towards committing a misdemeanor are not indictable. Acts remotely leading towards commission of offences are not to be considered as attempt to commit, but acts immediately connected with it are. Answer: C. Question 460. Preparation and attempt are two stages of commission of crime. Preparation is not punishable generally, but attempts is. One basic reason as to why preparation is not punishable is that there A. is no nexus between preparation and attempt. B. can be chances of change of mind before commission of offense. C. is absence of intention. D. is absence of attempt. Answer: B. Question 461. In which of the following cases, Cr.J.S.C. disapproved the narrow view taken by Kenny that attempt is the last, penultimate act which a person does towards the commission of an offense, the consummation of the offense being hindered by circumstances beyond his control? A. Asghar Ali Pradhania vs. Emperor. B. State of Maharashtra vs. M. D. Yaku. B. C. Abhyanand Mishra vs. State of Bihar. D. Multayat Singh vs. State of Punjab. B. Answer: B. Question 462. Which of the following correctly describes the four stages of a crime? A. Attempt, preparation, intention, result. B. Intention, attempt, preparation, result. C. Intention, preparation, attempt, result. D. Result, intention, preparation, attempt. Answer: C. Question 463. In State of Maharashtra vs. M. D. Yakub, which of the criteria was used by the court to distinguish an attempt to commit a crime from its mere preparation? A. Impossibility. B. Danger to the society. C. Opportunity to retreat from the offense. D. Proximity. Answer: D. Question 464. Section 511 does not apply in case of A. Attempt of riot. B. Attempt of theft. C. Attempt of murder. D. Attempt of affray. Answer: C. Question 465. State in which of the following cases P is guilty of attempting to commit the offense. A. P, in order to forge a document purporting to be executed by Q, sends his servant to buy a stamp paper in the name of Q. As the servant reaches stamp shop, he is arrested. D. BP shoots at Q whose back is toward the attempt fails as Q catches A is beyond the range of the gun. C.P. pours half a pint of substance from bottle marked poison into the whiskey of Q, Q is not aware. It turns out that bottle did not contain any poison. D.P administers some noxious substance to a woman so that an abortion results. The woman was not pregnant. Answer B. Question 466. A purchased a stamp paper in the name of person whose name he intended to forge. As guilty of A. Attempt of forgery. B. Attempt of cheating. C. Attempt of criminal misappropriation. D. No offense. Answer D. Question 467. A woman ran to a well stating she would jump in it, but she was caught before she could reach it. She is guilty of A. Attempt to suicide. B. Attempt to murder. C. Attempt to culpable homicide. D. No offense. Answer D. Question 468. Which of the following is an instance of criminal attempt? A procures color with an intent to make false coins. B. A is in possession of some obscene photographs and he thought of publishing them. C. A, with an intent to kill. B, administers sugar thinking it to be poison powder. D. None of the above. Answer D. Question 469. X, with a view to murdering Y, enters Y's bedroom at night when Y is out of station. X is guilty of A. Murder. B. House trespass. C. Attempt to murder. D. No offense. Answer B. Question 470. Section 511. I.P.C. is not related to the offense for which the punishment is A. Death sentence. B. Life imprisonment. C. Imprisonment. D. Both A and C. Answer A. Question 471. A. Intending to murder. B. By poison, purchases poison and mixes the same with a glass of water. He gives to bearer to serve. B. The bearer while approaching. B. Loses balance and the glass drops out of his plate. A. Has committed no offense. B. Has committed the offense of attempt to commit culpable homicide. C. Has committed the offense of abetment. D. Has committed the offense of attempt to murder. Answer D. Question 472. Z, with intention to steal ornaments, opened Y's box and found it empty. Which one of the following statements is correct? Z is A. Not liable for attempt to commit theft as the box being empty, commission of theft was impossible. B. Not liable for attempt commit theft as he did not do the penultimate act towards commission of theft. C. Not guilty of attempt to commit theft as he made only preparation to commit theft. D. Guilty of attempt to commit theft as he had an intention to commit theft and did an act towards its commission. Answer D. Question 473. Assertion A. There is no liability for an attempt to commit an impossible theft. Reason No criminal liability can be incurred under say C. 511 for an attempt to do an act which, if done, will not be an offense. A. Both A and R are true and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true, but R is false. D. A is false, but R is true. Answer D. Question 474. The fundamental principle of criminal liability is embodied in the maxim, actus non facet reum nisi mens sit re. The maxim was developed by A. Equity courts. B. Common law courts. C. Southern Nijamat court. D. None of the above. Answer B. Question 475. Wrongful gain. Me answer A. Gain by lawful Meanswer of property which the person gaining is not entitled. B. Gain by unlawful meanswer of property which the person gaining is not entitled. C. Gain by unlawful meanswer of property which the person gaining is entitled. D. All the above. Answer B. Question 476. Wrongful loss meanswer. A. Loss by unlawful meanswer of property which the person losing it is legally entitled. B. Loss by lawful meanswer of property which the person losing it is not legally entitled. C. Loss by lawful meanswer of property which the person losing is not legally entitled. D. All the above. Answer A. Question 477. The provision of personation at elections under Section 171D of I.P.C. A. Shall apply to a person who has been authorized to vote as proxy for an elector under any law in force. B. Shall not apply to a person who has been authorized to vote as proxy for an elector under any law in force. C. Does not lead to any restriction under any law in force. D. None of the above. Answer B. Question 478. Dishonestly has been defined as doing anything with intention to cause wrongful gain to one person and wrongful loss to another, under A. Section 21, B. Section 23, C. Section 24, D. Section 25. Answer C. Question 479. Fraudulently has been defined as doing anything with intent to defraud. A. Section 23, B. Section 25, C. Section 24, D. Section 26. Answer B. Question 480. When a criminal act is done by several persons in furtherance of the common intention of all, A. Each of such person is liable for that act in the same manner as if it were done by him alone. B. Each of such person is liable for his own overt act. C. Each of such person shall be liable according to the extent of his participation in the crime. D. Both B and C. Answer A. Question 481. Which of these punishments was removed from the I.P.C. in the year 1949? A. Penal servitude. B. Death. C. Forfeiture of property. D. Solitary confinement. Answer A. Question 482. To establish Section 34 of I.P.C. A. Common intention be proved but not overt act of each be proved. B. Common intention and overt act both be proved. C. Common intention need not be proved but overt act be proved. D. All the above. Answer A. Question 483. Section 34 of I.P.C. A. Creates a substantive offense. B. Is a rule of evidence. C. Both A and B. D. Neither A nor B. Answer B. Question 484. X and Y go to murder Z. X stood on guard with a spear in hand but did not hit Z at all. Y killed Z. A. Only Y is liable for murder of Z. B. X and Y both are liable for murder of Z. C. X is not liable as he did not perform any overt act. D. Both A and C. Answer B. Question 485. Voluntarily has been defined as an effect caused by meanswer whereby a person intended to cause it or by meanswer, at the time of employing those meanswer, knew or had reason to believe it to be likely to cause it under A. Section 39, B. Section 38, C. Section 37, D. Section 40. Answer A. Question 486, under Section 45 of I.P.C, life denotes A. Life of a human being. B. Life of an animal. C. Life of human being and of an animal both. D. Life of either human being or animal. Answer A. Question 487, under Section 46 of I.P.C, death denotes A. Death of a human being. B. Death of an animal. C. Death of a human being and of an animal both. D. Death of either human being or an animal. Answer A. Question 488, illegal signifies A. Everything which is an offense. B. Everything which is prohibited by law. C. Everything which furnishes ground for civil action. D. All the above. Answer D. Question 489, animal denotes A. Any living creature including human being. B. Any living creature other than a human being. C. Any creature, live or dead. D. Either A or C. Answer B. Question 490, how many types of punishments have been prescribed under the Indian Penal Code? A. 3. B. 6. C. 5. D. 4. Answer C. Question 491, under Section 60 of I.P.C, in certain cases of imprisonment, the sentence of imprisonment A. has to be wholly rigorous. B. has to be wholly simple. C. can be partly rigorous and partly simple. D. either A or B. Answer C. Question 492, sentence of imprisonment for non-payment of fine under Section 64 of I.P.C. A. shall be in excess of any other imprisonment to which an offender has been sentenced. B. shall be concurrent of any other imprisonment. C. shall not be in excess of any other imprisonment. D. both B and C. Answer A. Question 493, under Section 65 of I.P.C, sentence of imprisonment for non-payment of fine shall be limited to A. 1/3 of the maximum term of imprisonment fixed for the offence. B. 1/4 of the maximum term of imprisonment fixed for the offence. C. 1/2 of the maximum term of imprisonment fixed for the offence. D. equal to the maximum term of imprisonment fixed for the offence. Answer B. Question 494, in case of an offence punishable with fine only, imprisonment for non-payment of fine, A. has to be rigorous. B. has to be simple. C. can be rigorous or simple. D. can be partly rigorous and partly simple. Answer B. Question 495, under Section 498 of I.P.C, cruelty includes A. harassment of the woman. B. physical cruelty only. C. mental cruelty only. D. cruelty by wife. Answer A. Question 496, in case of an offence punishable with fine only, an offender who is sentenced to pay a fine of not exceeding 100 rupees but exceeding 50 rupees, the imprisonment in default of payment of fine shall not exceed A. 2 months. B. 3 months. C. 4 months. D. 6 months. Answer C. Question 497, in case of an offence punishable with fine only, an offender who is sentenced to pay a fine exceeding 100 rupees, the imprisonment in default of payment of fine shall not exceed A. 1 year. B. 6 months. C. 4 months. D. 2 months. Answer B. Question 498, Section 64 of I.P.C provides for A. nature and maximum limit of imprisonment for non-payment of fine. B. nature and minimum limit of imprisonment for non-payment of fine. C. Nature but does not prescribe any limit of imprisonment for non-payment of fine. D. Limit of imprisonment for non-payment of fine but does not prescribe the nature of imprisonment. Answer: C. Question 499. Imprisonment for non-payment of fine shall terminate: A. On payment of fine. B. On expiry of the term of imprisonment for non-payment. C. Both A and B. D. Neither A nor B. Answer: C. Question 500. In case of imprisonment for non-payment of fine, if a part of the fine is paid, such sentence: A. shall be reduced proportionately. B. shall not be reduced in direct proportion to the fine paid. C. shall be reduced but subject to the discretion of the court as to the quantum of reduction. D. All of the above. Answer: A. Question 501. Section 73 of I.P.C. provides for the maximum limit of solitary confinement to be: A. 1 year. B. 2 years. C. 3 months. D. 6 months. Answer: C. Question 502. If an offender has been sentenced to imprisonment not exceeding 6 months, the solitary confinement: A. shall not exceed 15 days. B. shall not exceed 1 month. C. shall not exceed 2 months. D. shall not exceed 45 days. Answer: B. Question 503. If an offender is sentenced to imprisonment for a term exceeding 6 months but not exceeding 1 year, the term of solitary confinement: A. shall not exceed 1 month. B. shall not exceed 45 days. C. shall not exceed 2 months. D. shall not exceed 3 months. Answer: C. Question 504. If an offender is sentenced to imprisonment for a term exceeding 1 year, the term of solitary confinement shall not exceed: A. 1 month. B. 2 months. C. 3 months. D. 6 months. Answer: C. Question 505. Nothing is said to be done or believed to be done in good faith which is done or believed without due care and intention, is the definition of good faith contained in: A. Section 29 of I.P.C. B. Section 29 of I.P.C. C. Section 52 of I.P.C. D. Section 52 of I.P.C. Answer: C. Question 506. General exceptions are contained in: A. Chapter 3 of I.P.C. B. Chapter 4 of I.P.C. C. Chapter V of I.P.C. D. Chapter 6 of I.P.C. Answer: D. Question 507. Section 76 provides that nothing is an offense which is done by a person who is or who by reason of: A. mistake of fact in good faith believes himself to be bound by law to do it. B. Mistake of law in good faith believes himself to be bound by law to do it. C. Mistake of fact believes himself to be bound by morals to do it. D. All the above. Answer: A. Question 508. Under Section 79, nothing is an offense which is done by a person who is justified by law or who by reason of mistake of fact in good faith believes himself to be: A. bound by law to do it. B. justified by law to do it. C. bound by morality to do it. D. all the above. Answer: A. Question 509. The maxim, ignorantia juris non excusat means: A. ignorance of law is no excuse. B. ignorance of fact is no excuse. C. ignorance of law is an excuse. D. ignorance of fact is an excuse. Answer: A. Question 510. Section 76 and Section 79 of I.P.C. provide the general exception of: A. mistake of law. B. mistake of fact. C. Both mistake of law and fact. D. Either mistake of law or of fact. Answer B. Question 511. Accident as an exception has been dealt with in A. Section 77, B. Section 78, C. Section 80, D. Section 82. Answer C. Question 512. Under Section 80, the exception of accident is available when an offense is committed while A. Doing a lawful act in a lawful manner by lawful means, B. Doing a lawful act in any manner by any means, C. Doing a lawful act in a lawful manner by any means, D. All the above. Answer A. Question 513. The principle as to the way in which a man should behave when he has to make a choice between two evils is illustrated in A. Section 80 of I.P.C, B. Section 81 of I.P.C, C. Section 82 of I.P.C, D. Section 78 of I.P.C. Answer B. Question 514. The motive under Section 81 of I.P.C should be A. Prevention of harm to person, B. Prevention of harm to property, C. Both A and B, D. Either A or B. Answer C. Question 515. Infancy as an exception has been provided under A. Section 80, B. Section 81, C. Section 82, D. Section 84. Answer C. Question 516. Section 82 of I.P.C provides that nothing is an offense which is done by a child under A. 6 years of age, B. 7 years of age, C. 9 years of age, D. 10 years of age. Answer B. Question 517. Section 82 of I.P.C enunciates A presumption of fact, B. A rebuttable presumption of law, C. A conclusive or irrebuttable presumption of law, D. None of the above. Answer C. Question 518. A person is stated to be partially incapable under Section 83 I.P.C if he is aged A. Above 7 years and under 12 years, B. Above 7 years and under 10 years, C. Above 7 years and under 16 years, D. Above 7 years and under 18 years. Answer A. Question 519. Section 83 of I.P.C lays down A presumption of fact, B. An inconclusive or rebuttable presumption of law, C. Conclusive or irrebuttable presumption of law, D. Irrebuttable presumption of fact. Answer B. Question 520. Section 82 of I.P.C down the rule of A. Wholly incapable, B. Partially incapable, C. Both A and B, D. Either A and B. Answer A. Question 521. Under Section 82 and Section 83 of I.P.C an offense is punishable if it is done by a child A. Of below 7 years of age, B. Of above 7 years of age but below 12 years if he has not attained sufficient maturity and understanding, C. Of above 7 years of age but below 12 years having attained sufficient maturity and understanding, D. All of the above. Answer C. Question 522. The maxim actus non facet reum nisi mens sit re, means A. Crime has to be coupled with guilty mind, B. There can be no crime without a guilty mind, C. Crime is the result of guilty mind, D. Criminal mind leads to crime. Answer B. Question 523. I. The physical aspect of crime is actus res. 2. The mental aspect of crime is mens re. 3. The motive is the desire to commit crime. Which of the following is correct for the aforesaid? A. I and 2 are correct but 3 is not correct. B. Only 2 and 3. C. Only 2 and 3. D. All the above. Answer A. Question 524. Section 84 of I.P.C. provides for A. Medical insanity. B. Legal insanity. C. Moral insanity. D. Unsoundness of mind of any kind. Answer B. Question 525. Irresistible impulse is a defense. A. In India. B. In England. C. In India and England both. D. Neither in India nor in England. D. Answer B. Question 526. A hangman who hangs the prisoners, pursuant to the order of the court, is exempt from criminal liability by virtue of A. Section 77 of I.P.C. B. Section 78 of I.P.C. C. Section 79 of I.P.C. D. Section 76 of I.P.C. Answer B. Question 527. Insanity as a defense means that a person at the time of doing an act, by reason of unsoundness of mind, is incapable of knowing A. The nature of the act. B. That what he is doing is wrong. C. That what he is doing is contrary to law. D. Either A or B or C. Answer D. Question 528. Which of the following is correct? A. The burden of proof that the accused was not insane at the time of commission of offense is on the prosecution. B. The burden of proving that the accused was insane at the time of commission of offense is on the accused. C. There is a rebuttable presumption of fact that accused was insane at the time of commission of the offense. D. It is a matter of inference to be drawn by the court on the facts proved by the prosecution. Answer B. Question 529. For unsoundness of mind, the impairment of the cognitive faculty of mind to escape criminal liability. A. Must be total. B. Must be partial. C. Both A and B. D. None of the above. Answer A. Question 530. Intoxication as defense is contained in A. Section 85 of I.P.C. B. Section 86 of I.P.C. C. Section 87 of I.P.C. D. Both A and B. Answer D. Question 531. For a defense of intoxication, to escape criminal liability, the degeneration of mental faculties. A. Must be total. B. Must be partial. C. Both A and B. D. Only B is correct and A is incorrect. Answer A. Question 532. For a defense of intoxication, to escape criminal liability, the intoxication A. can be self-administered. B. administered against his will or knowledge. C. should not be self-administered. D. all of the above. Answer B. Question 533. In cases where the act involves a specific mens rea, in cases of intoxication under Section 86 of I.P.C., A. the existence of mens rea is presumed. B. the specific mens rea is not presumed. C. the specific mens rea depends upon the attending circumstances and the degree of intoxication. D. none of the above. Answer C. Question 534. The term of judges of International Court of Justice is A. 3 years. B. 5 years. C. 6 years. D. 9 years. Answer D. Question 535. When was the Charter of Human Rights adopted in Paris in the year A. 1945. B. 1948. C. 1951. D. None of these. Answer, B. Question 536. The bar doctrine is related to A. The recognition of a state. B. The recognition of a government. C. The recognition of insurgents. D. None of these. Answer, B. Question 537. Conference of Bogota was held in A. 1920. B. 1936. C. 1948. D. None of these. Answer, C. Question 538. Vienna Conference of 1961 is related to A. Diplomatic intercourse and immunities. B. Prisoners of war. C. Recognition of states. D. Berlin Crisis. Answer, D. Question 539. Who is called the father of international law? A. Hugo. B. Oppenheim. C. Suarez. D. None of these. Answer, A. Question 540. Foreign warships have A. The right of free passage in the territorial waters. B. The right of innocent passage in the territorial waters. C. To stay in the territorial waters. D. None of these. Answer, B. Question 541. Under the UNCLOS framework, landlocked states have access to surplus of allowable catch in the A. Contiguous zone. B. Lakes and rivers in their own territory. C. Exclusive economic zone. D. Pacific Ocean. Answer, C. Question 542. Contiguous zone is limited to a maximum of A. 25 miles, 24 nautical mile. B. 50 miles. C. 12 miles. D. None of these. Answer, A. Question 543. The Alabama arbitration case was decided in A. 1872. B. 1854. C. 1890. D. None of these. Answer, A. Question 544. The Convention for the Protection of the Ozone Layer was done on A. 22 March 1985. B. 23 March 1986. C. 24 March 1987. D. None of these. Answer, A. Question 545. Calvo clause means A. A state can intervene on behalf of its nationals. B. A state can't intervene on behalf of its nationals. C. An alien agrees not to seek the diplomatic protection of his own state. D. None of these. Answer, C. Question 546. Diplomatic relations are established by A. Mutual consent. B. A unilateral decision. C. A decision of a regional organization. D. None of these. Answer, A. Question 547. Eruption of war terminates A. All treaties. B. No treaty. C. Only political treaties. D. None of these. Answer, C. Question 548. Foreign ships sailing and anchoring in coastal waters of another state are A. Subject to the law of flag state. B. Subject to the law of coastal state. C. Subject to the law of both the states. D. None of these. Answer, C. Question 549. Piracy is an offense within the jurisdiction the A. Flag state. B. Offenders state. C. All the states. D. None of these. Answer, C. Question 550. Territorial waters are A. Waters outside the territorial limits of a state. B. Waters dividing territory of two or more states. C. Waters adjacent to the contiguous zone. D. None of these. Answer, C. Question 551. Non-permanent members of the Security Council are elected for a period of A. 7 years, B. 3 years, C. 2 years, D. None of these. Answer, C. Question 552. The Montreal Convention for the Safety of Civil Aviation was signed in A. 1975, B. 1974, C. 1971, D. None of these. Answer, C. Question 553. Diplomatic staff enjoys complete immunity from A. Civil jurisdiction, B. Criminal jurisdiction, C. Both, D. None of these. Answer, C. Question 554. Number of judges of International Court of Justice is A. 9, B. 12, C. 15, D. None of these. Answer, C. Question 555. Permanent Court of International Justice was established under A. League of Nations, B. UNO, C. European Union, D. None of these. Answer, A. Question 556. Pacta sunt servanda. A. Treaties between states are to be respected. B. An unwanted person. C. International law must be honored. D. None of these. Answer, A. Question 557. Headquarters of International Court of A. The Hague, B. Geneva, C. New York, D. None of these. Answer, A. Question 558. Persona non grata means A. Impracticable article of international law, B. A fugitive criminal, C. A person refused for asylum, D. None of these. Answer, C. Question 559. Which of these is true in relation to European Commission on Human Rights? A. It was abolished in 1988. B. It restricted an individual's direct access to European Court of Human Rights. C. Both A and B. D. It is still working, however no president is appointed. Answer, C. Question 560. Principles jus soli means A. Grant of nationality on the basis of place birth, B. Grant of nationality on the basis of blood relationship, C. Grant of nationality through naturalization, D. None of these. Answer, A. Question 561. Much of international law is derived through analogy from A. Islamic law, B. Christian law, C. Roman law, D. None of these. Answer, C. Question 562. Vienna Convention on Law of Treaties was signed in A. 1969, B. 1945, C. 1927, D. None of these. Answer, D. Question 563. Truce mean A. Temporary arrangement between the belligerent parties for cessation of hostilities, B. Any peace treaty to end a war, C. No war pact, D. None of these. Answer, A. Question 564. Declaration is a treaty between the contracting parties which A. is always subject to ratification, B. is not needed to be ratified, C. may or may not be subject to be ratification, D. None of these. Answer, C. Question 565. Diplomatic protection means a protection and security granted A. to a diplomat by UNO, B. by a state to its national abroad, C. by a state to a person seeking asylum, D. None of these. Answer, B. Question 566. Kellogg-Briand Pact or Paris Peace Treaty was signed in A. 1945, B. 1928. C. 1919. D. None of these. Answer, B. Question 567. Recognition of new states is a matter of A. International law, B. Constitutional law, C. Policy of the state, D. None of these. Answer, C. Question 568. Grant of extraterritorial asylum in a litigation. A is a part of customary international law. B is a part of Vienna Convention on Diplomatic Relations 1961. C depends on circumstances. D. None of these. Answer, C. Question 569. To get asylum in a foreign state by an individual. A is his basic right. B is not his right. C depends on circumstances. D. None of these. Answer, A. Question 570. The Security Council has been given the power to use force against a state under which article of the UN Charter? A. Article 41. B. Article 40. C. Article 39. D. Article 42. Answer, D. Question 571. Territorial sea of a state is under A. Its total control, B. Its control, but subject to certain international obligations, C. Its control, only for exploration of mineral resources, D. None of these. Answer, A. Question 572. Genocide Convention was adopted by the UN General Assembly in A. 1948, B. 1950, C. 1960, D. None of these. Answer, A. Question 573. Binker-Shook principle is related to A. Measurement of maritime belt, B. Contiguous zone, C. Extradition of criminals, D. None of these. Answer, A. Question 574. Principle of double criminality means that other person who is being extradited must be tried in both the states. B. The person who is being extradited must be tried in both the states but may be punished in one. C. That the offense for which a person is extradited must be an offense in both the states. D. None of these. Answer, C. Question 575. Principle of specialty means that other person extradited must be awarded special punishment by the requesting state. B. The person extradited must not be awarded special punishment by the requesting state. C. The person extradited must be punished only for the offense for which he has been extradited. D. None of these. Answer, C. Question 576. Features of international law include all except which of the following? A. There is no single legislative source of international law. B. There is no single world court for interpreting international law. C. There is no world executive branch that can enforce international laws. D. None of these. Answer, D. Question 577. Which of the following is not a source of international law? A. Treaties and conventions, B. Custom, C. Judicial decisions and teachings, D. All of these are sources of international law. Answer, D. Question 578. The United Nations is governed by all except which of the following? A. The General Assembly, B. The Security Council, C. The Secretariat, D. None of these. Answer, C. Question 579. The group of European countries created to promote peace, security, economic and social unity is called the A. European Market, B. European Union, C. European Coalition, D. None of these. Answer, B. Question 580. GATT is a multilateral treaty that A. restricts trade among non-member countries. B. imposes multiple trade barriers among its member nations. C. establishes trade agreements and limited tariffs and trade restrictions. D. none of these. Answer C. Question 581. The oldest principle of international law is the doctrine of A. sovereign immunity. B. foreign dignitaries. C. religious freedom. D. pact sunt servanda. Treaties must be kept. Answer D. Question 582. Diplomatic envoys are absolutely immune from which of the following jurisdictions? A. criminal jurisdiction. B. civil jurisdiction. C. both A and B. D. none of these. Answer C. Question 583. Which of the following is not an example extraterritorial asylum? A. asylum granted in a ship in high seas. B. asylum granted in the premises of an international institution. C. asylum granted in an embassy. D. none of these. Answer D. Question 584. The Security Council has been given the responsibility to maintain international peace and security. A. primary. B. exclusive. C. discretionary. D. ancillary. Answer A. Question 585. Continental shelf. Answer A. that portion of land which belongs to no state. B. that portion of land on the South Pole which can be used by any state. C. submerged bed of sea contiguous to a continental land mass. D. none of these. Answer C. Question 586. Vatican City is A. a province of Italy. B. is an independent state. C. is not an independent state. D. none of these. Answer B. Question 587. The jurisdiction of the International Court of Justice. A. is binding on all the members of the UNO. B. is not binding on all the members of the UNO. C. is binding only upon the members of the Security Council. D. none of these. Answer B. Question 588. A vassal state is the one which is A. situated on the seashore. B. an independent state. C. under the suzerainty of another state. D. none of these. Answer C. Question 589. Confederation means A. good diplomatic relation between some states. B. union between some states. C. relation between the provinces of a federal state. D. none of these. Answer B. Question 590. Littoral state means A. situated on the sea coast. B. an independent state. C. under the suzerainty of another state. D. none of these. Answer A. Question 591. Contiguous zone means A. that portion of land which belongs to no state. B. that portion of land on the South Pole which can be used by any state. C. that portion of sea which is adjacent to territorial waters. D. none of these. Answer C. Question 592. Maritime belt means A. that portion of land which belongs to no state. B. that portion of land on the South Pole which can be used by any state. C. that portion of sea which is adjacent to the territory of a coastal state. D. none of these. Answer C. Question 593. Economic and Social Council. A. was an organ of the League of Nations. B. is an organ of the WTO. C. is an organ of UNO. D. none of these. Answer C. Question 594. A state has the right to exploit in the continental shelf A. Living resources, B. Non-living resources, C. Both A and B, D. None of these. Answer C. Question 595. The principle of rebus sic stantibus means A. A state cannot use force, B. There is no crime without a law, C. Fundamental change of circumstances, D. None of these. Answer C. Question 596. The Schooner Exchange case dealt with the principle of A. A state has sovereign right its natural resources, B. A state courts have to accept the validity of a foreign state's acts, C. A state's right of reprisals in case of violation of rights, D. None of these. Answer B. Question 597. Hague Convention of 1970 dealt improperly with the crimes relating to A. Refugees, B. Prisoners of war, C. Hijacking, D. None of these. Answer C. Question 598. By virtue of first optional protocol to the International Covenant on Civil and Political Rights, the right to file a petition to the Human Rights Committee has been extended to A. All member states, B. Individuals, C. Diplomatic missions, D. International NGOs. Answer B. Question 599. Contiguous zone in India is adjacent to and beyond the territorial waters and extending seawards to a line A. 12 nautical miles, B. 24 nautical miles, C. 60 nautical miles measured from the baseline, D. None of these. Answer B. Question 600. De facto recognition is A. Legal recognition, B. Recognition in principle, C. Circumstantial and tentative recognition, D. None of these. Answer C. Question 601. The limit of territorial waters of India is A. 12 nautical miles, B. 20 nautical miles, C. 24 nautical miles beyond the land territory and internal waters of Pakistan, measured from the baseline, D. None of these. Answer A. Question 602. Continental shelf of India may extend up to a distance of A. 150 nautical miles, B. 200 to 350 nautical miles, C. 300 nautical miles beyond the limits of its territorial waters, D. None of these. Answer B. Question 603. Exclusive economic zone of India is beyond and adjacent to the territorial the limit of which is A. 12 nautical miles, B. 100 nautical miles, C. 200 nautical miles, D. None of these. Answer C. Question 604. Select the correct one. A. Only coastal states have the right to sail ships under their flags on the high seas, B. Every state has the right to sail ships under its flag on the high seas, C. Only 5 big powers have the right to sail ships under their flags on the high seas, D. No state has the right to sail ships under their flags on the high seas. Answer B. Question 605. Convention on the Law of the Sea was signed at Jamaica in A. 1948, B. 1975, C. 1982, D. None of these. Answer C. Question 606. Statutes of International Courts of Justice were drawn up by A. London Declaration in 1941, B. Moscow and Tehran Conference in 1943, C. San Francisco Conference in 1945, D. None of these. Answer C. Question 607. According to the Floating island, theory. A floating island is A. An island within 3 nautical miles from the coast of a country. B. An island on the high seas, which is not the territory of any particular state. C. A ship bearing the national flag of a state. D. None of these. Answer, C. Question 608. The Security Council is A. Specialized agency of the UN. B. Principal organ of the UN. C. NGO for settling disputes between various states. D. None of these. Answer, B. Question 609. In procedural matters, the decisions of the Security Council are made by the affirmative votes of any A. 5 members. B. 9 members. C. 15 members. D. None of these. Answer, B. Question 610. Extradition is normally granted A. In all cases. B. In criminal cases only. C. In civil cases only. D. None of these. Answer, B. Question 611. What is contraband? A. All narcotics. B. Articles banned by a government. C. All smuggled goods. D. Goods which may assist an enemy in the conduct of war. Answer, D. Question 612. The term of judges of the International Court of Justice is A. 3 years. B. 5 years. C. 7 years. D. 9 years. Answer, D. Question 613. A diplomatic agent is immune from local jurisdiction. A. In all cases. B. In criminal cases. C. In cases involving personal property. D. None of these. Answer, A. Question 614. Diplomatic protection is the protection which a state gives to A. Its nationals living abroad through its embassies. B. All diplomatic envoy on its own territory. C. Its own diplomatic agents in the foreign states. D. None of these. Answer, A. Question 615. Forum prorogatum means A. Jurisdiction conferred by implication or conduct. B. Inferior forum. C. Superior forum. D. Jurisdiction conferred by delegation. Answer, A. Question 616. Bryant-Kellogg Pact was meant to A. End war between France and Britain. B. Establish peace in Western Europe. C. Denounce war as an instrument for settling disputes. D. None of these. Answer, C. Question 617. Treaty of Westphalia was signed in A. 1658. B. 1680. C. 1776. D. 1648. Answer, D. Question 618. Permanent Court of International Justice was established in A. 1919. B. 1922. C. 1915. D. None of these. Answer, B. Question 619. Sri Lankan High Commissioner in Mumbai, if found involved in a serious crime in India, can be A. Arrested by local police and put to trial. B. Arrested and handed over to his home govt. C. Asked to leave the country by the government. D. None of these. Answer, C. Question 620. The Law of War and Peace was written by A. Hegel. B. Kelson. C. Grotius. D. None of these. Answer, C. Question 621. Permanent Court of Arbitration was an outcome of A. League of Nations. B. Hague Conference 1899. C. Hague Conference 1907. D. None of these. Answer, B. Question 622. Alabama Claims Arbitration Award 1872 established certain principles of A. Nationality, B. Neutrality, C. Extradition, D. None of these. Answer, B. Question 623. The leader of positive school of thought was A. Beinkershuk, B. Stark, C. Hart, D. None of these. Answer, C. Question 624. Assertion. A. International Law Commission has initiated studies and prepared draft codes on diverse fields in international law. Reason. Our International Law Commission was established under General Assembly Resolution number 174, 11, adopted on 21 November 1947 with an object to promote, progressively develop and codify international law. A. Codes, both A and R, are true. B. A is true but R is false. C. R is true but A is false. D. Both A and R are false. Answer, A. Question 625. In the continental shelf, the coastal state has A. the exclusive right over all resources, B. the exclusive right over its living resources only, C. the exclusive right over its non-living resources, D. none of these. Answer, A. Question 626. Vienna Convention on Law of Treaties was signed in A. 1961, B. 1969, C. 1975, D. none of these. Answer, B. Question 627. Territorial sea of a coastal state is A. open for innocent passage of all type of foreign ships, B. open for innocent passage of all except the fishing ships, C. reserved for vessels of the coastal states only, D. none of these. Answer, B. Question 628. Cabotage is A. part of the sea prohibited for war activity by law, B. no-fly zone, determined by UN during war, C. intercourse by sea between two ports of the same state, D. none of these. Answer, C. Question 629. Principle of jus soli is A. granting nationality on the basis of place of birth, B. granting nationality on the basis of parentage, C. invalidation of a treaty due to change in circumstance, D. none of these. Answer, A. Question 630. UN Declaration of Human Rights was passed in A. 1945, B. 1948, December, C. 1949, D. none of these. Answer, B. Question 631. Remunier and recastione cases for A. extradition of military offenders, B. extradition of political offenders, C. determining the enemy status of alien during war, D. none of these. Answer, B. Question 632. All international treaties signed by the U.S. President are subject to ratification by the U.S. A. Senate with second march majority, B. House of Representatives with second march majority, C. Congress with second march majority, D. none of these. Answer, A. Question 633. Prize courts are A. international courts, B. municipal courts, C. judicial tribunals under UNO, D. none of these. Answer, B. Question 634. The word tort has been derived from the Latin word A. tortum, B. tortus, C. torts, D. none of these. Answer, A. Question 635. With reference to the law of torts, Respond to the following. A. In the English law, tort is defined as a wrong. B. In the Roman law, tort is defined as deceit. C. In the Indian law, tort is defined as a civil wrong. D. All are correct. Answer D. Question 636. Tort means A. A wrong. B. A legal civil wrong. However, every civil wrong is not a tort. C. A legal wrong. D. All of the above. Answer B. Question 637. Law of tort developed mainly through A. Judicial decisions. B. Enactment. C. Customs. D. None of these. Answer A. Question 638. The major reason for the lack of tort litigation in India is A. Lack of consciousness about one's rights and the spirit of toleration. B. High cost of litigation. C. Undue delay in the final disposal of the cases. D. All of the above. Answer A. Question 639. Tort is a civil wrong for which the remedy is a common law action for unliquidated damages, and which is not exclusively the breach of a contract or the breach of a trust or other merely equitable obligation. This definition of tort is given by A. Winfield, B. Salmond, C. Pollock, D. Clark and Limdasell. Answer B. Question 640. The law of torts in civil wrongs is a collective name for the rules governing many species liability, which, although their subject matter is wide and varied, have certain broad features in common, are enforced by the same kind of legal process and are subject to similar exceptions. This statement was given by A. Salmond, B. Winfield, C. S.P. Singh, D. Pollock. Answer C. Question 641. The main supporter of the theory that it is a law of tort and not law of torts is A. Winfield, B. Salmond, C. Fleming, D. Huston. Answer A. Question 642. The propounder of pigeonhole theory, law of tort, and not law of tort, is A. Salmond, B. Clark and Limdasell, C. Austin, D. Winfield. Answer A. Question 643. The maxim, de minimis non curat, means A. No justice for incorrect petition, B. Slight harm, C. Exhibition of disrespect, D. Annoyance. Answer B. Question 644. The nature of a tort can be understood by distinguishing A. Tort and crime, B. Tort and duty in civil cases with A. Contract, a trust and a quasi-contract, C. Right and duty, D. Both A and B. Answer D. Question 645. The essential characteristics of tort is violation A. Right in personam, a right available only against some determinate person or property, B. A contractual right, C. Right in rem, a right vested in some determined person and available against the world at large, D. None of the above. Answer C. Question 646. Which among the following is difference between a tort and a crime? A. A tort is an infringement of the private right belonging to an individual. A crime is an invasion of public rights or duties affecting the whole society. B. In tort, the wrongdoer has to pay damages to the injured party. In crime, he is punished by the state and the fine imposed on him goes to government treasury. C. In tort, the civil action is brought by the injured party himself in the civil court, where in crime, the proceedings are taken and conducted in the name of the state in criminal court. D. All of the above. Answer D. Question 647. Wrongs are divisible into two sorts or species, private wrongs and public wrongs. The above distinction was made by A. Bentham, B. Blackstone, C. Salmond, D. Pollock. Answer B. Question 648. One of the following is a good defense for the tort of private nuisance. A. Plaintiff has come to the place of nuisance. B. Reasonable care was taken to prevent nuisance. C. The activity is for the public benefit. D. The activity is continuing for the past 20 years. Answer D. Question 649. There are various wrongs which find their place both under criminal law and law of torts. These wrongs are A. Assault, defamation and negligence. B. Assault, defamation, negligence, conspiracy and nuisance. C. Assault, defamation, negligence and conspiracy. D. Defamation, conspiracy and negligence. Answer C. Question 650. A tort may be described as a wrong independent of contract, for which the appropriate remedy is common law action. This definition is given by A. Salmond, B. Clark and Limdasell, C. Winfield, D. Pollock. Answer B. Question 651. Ubi jus I.B. remedium me. Answer A. Every law provides for remedies. B. There is a right without a remedy. C. If a law is made, corresponding remedy also must be made. D. Every remedy presupposes some injury to somebody. Answer B. Question 652. In the law of tort, the remedies available are A. Executive and non-judicial. B. Executive and judicial. C. Judicial and extrajudicial. D. Judicial, non-judicial and extrajudicial. Answer C. Question 653. The general remedy in law of tort is A. Action for damages. B. Action for injunction. C. Specific restitution of property. D. Action for unliquidated damages. Answer D. Question 654. To fasten liability on a person, mental condition of the wrongdoer is A. Relevant in all torts. B. Not relevant in tortious liability. C. Relevant in case of strict liability. D. Relevant in torts based on fault. Answer D. Question 655. Which one of the following statement is correct? A. Damages can be dispensed with in tort. B. A remedy by way of damages is an essential ingredient of tort. C. When other remedies are provided by a statute, damages cannot be awarded in tort. D. Damages can be awarded only for corporeal objects. Answer B. Question 656. Mark the incorrect statement. A. Contemptuous damages are awarded when it is considered that an action should never have been brought. B. Nominal damages are awarded when there has been infringement of the plaintiff's legal right but he has suffered no loss thereby. C. Ordinary damages are awarded where it is necessary to compensate the plaintiff fairly for the injury he has in fact sustained. D. Exemplary damages are not awarded under the law of torts generally. Answer D. Question 657. Ordinary damages are also called A. General damages. B. Compensatory damages. C. Both A and B. D. None of the above. Answer C. Question 658. Exemplary damages, which are awarded in excess of the material loss suffered by the plaintiff with a view to prevent similar behavior in future, are also called A. Punitive damages. B. Vindictive damages. C. Compensatory damages. D. Both A and B. Answer D. Question 659. Mark the incorrect statement. A. General damages are those which the law will imply in every violation of a legal right. B. Special damages are such as the law will not infer from the nature of the act complained of. C. The special damage denotes the actual and temporal loss which has, in fact, occurred. D. All are correct. Answer D. Question 660. Which of the following is an extrajudicial remedy? A. Expulsion of a trespasser. B. Re-entry on land. C. Distress damage feasant. D. All of the above. Answer D. Question 661. When the plaintiff elects to sue in quasi-contract instead of tort, he is said to have A. Waived the tort. B. Discharged the tort. C. Both A and B. D. None of the above. Answer A. Question 662. A discharge of tort implies A. The judgment has not been pronounced. D. B. That no relief has given. C. That no record has been arrived. D. No action lies against the wrongdoer. Answer D. Question 663. Mark the incorrect statements. A. Ordinarily, all persons are entitled to sue in tort. B. In India, unlike England, an action in tort by one spouse against the other is maintainable. C. An infant can sue for a tort. D. An infant is not liable for his torts. Answer D. Question 664. Which of the following are the essential of a tort? A. There must be a wrongful act or omission on the part of a person. B. That wrongful act or omission must result in legal damage to another. C. The wrongful act or omission must be of result a nature as to give rise to a legal remedy. D. All of the above. Answer D. Question 665. Liability in tort depends upon A. Quantum of damages suffered. B. Involvement of intention. C. Infringement of legal right. D. Effect on public interest. Answer C. Question 666. In which of the following cases, it was held that no exemption clause in a contract is capable of exempting a party from tortious liability? A. Donoghue vs. Stevenson. B. Grant vs. Australian Knitting Mills Lieutenant. D. C. White vs. John Warwick & Co. D. Ashby vs. White. Answer C. Question 667. The maxim alterum non leader means A. To hurt nobody by word or deed. D. B. Where there is a right there is a remedy. C. Infringement of a legal right without damage or loss. D. None of the above. Answer A. Question 668. The maxim ubi jus ibi remedium means A. To hurt nobody by word or deed. D. B. Where there is a right there is a remedy. C. Infringement of a legal right without damage or loss. D. None of the above. Answer B. Question 669. The maxim, damnum sine injury, means A. Damage or loss without infringement of legal right. B. Infringement of private legal right without damage or loss. C. Where there is a remedy, there is a right. D. Where there is a right, there is a remedy. Answer A. Question 670. The maxim, injury sine damnum, means A. Damage or loss without infringement of legal right. B. Infringement of private legal right without damage or loss. C. Where there is a right, there is a remedy. D. None of the above. Answer B. Question 671. Injury sine damnum relates to cases where there is a. An invasion of an absolute private right. B. An invasion of a public right. C. A violation of a legal right. D. A legally authorized act resulting in injury. Answer C. Question 672. If the plaintiff has a right, he must have means to vindicate and maintain it, and a remedy if he is injured in the exercise or enjoyment of it. Ashby vs. White. The above rule was laid down by A. Salmond, B. Holt, C.J., C. Blackburn, J. D. Winfield. Answer B. Question 673. The case Ashby vs. White recognized the principle of ubi jus ibi remedium. It followed the A. Winfield's theory, B. Salmon's theory, C. both A and B. D. None of the above. Answer A. Question 674. Damnum may be absc injury, as if I have a mill and my neighbor builds another mill whereby the profit of my mill is diminished, I shall have no action against him, although I am damaged. D. But if a miller disturbs the water from going to my mill, or does any nuisance of the like sort, I shall water such action as the law gives. The above observation was made by Justice Hungerford in A. Gloucester Grammar School case. B. Ashby vs. White. C. Chasemore vs. Richards. D. Dixon vs. Reuters Telegram Company. Answer A. Question 675. A qualified voter was denied his right to vote by the returning officer. The candidate for whom A. voted was nevertheless elected. D. An action in tort against the returning officer. A. does not lie because A. suffered no harm, the candidate he wanted to voted for was elected. B. does not lie because there was no malice. C. lies because a legal right was injured even though no harm was caused. D. none of the above. Answer C. Question 676. A. set up a rival school to that of the B.S. because of the competition. B. had to reduce their fees. A. B. had no remedy in tort for the loss suffered by them. B. had a remedy in other law. C. B. had a remedy in other law. D. none of the above. Answer A. Question 677. A. carrying on mining operations in his own land drained away the percolating water from the B.S. land and thus dried up his well. A. B. has the remedy against A. for loss suffered by him. B. A. will be liable for interference in B.'s use of land. D. C. B. has no remedy against A. because A. has infringed no legal right of B. D. none of the above. Answer C. Question 678. The term malice means A. in its legal sense a willful act done with just cause or excuse, and known as malice in law. B. it is an evil or improper motive and the same is known as malice in fact. C. both A. and B. D. neither of the two. Answer C. Question 679. In which of the following cases it was observed that if an act is otherwise lawful it does not become unlawful merely because the same has been done with an evil motive? A. Allen vs. Flood. B. Mayer vs. Bradford Court vs. Pickles. C. Town Area Committee vs. Prabhudayal. D. Stone vs. Bolton. Answer B. Question 680. The element of malice. A. is not essential. B. is essential in all torts. C. Is essential in the tort of defamation, malicious prosecution, willful and malicious damage to property maintenance and nuisance. D. Is essential in the tort of defamation and malicious prosecution only. Answer, C. Question 681. Mental condition of the wrongdoer at the time of wrongdoing is A. Relevant in all torts. B. Relevant in torts based on faults. C. Relevant in torts based on strict liability. D. Not relevant in tortious liability. Answer, B. Question 682. The maxim, Cr.P.C causa non aurito action means that A. An action does not arise from an immoral cause. B. An action arises from an immoral cause. C. Immorality always depends on the prevailing. D. None of the above. Answer, A. Question 683. The maxim volenti non fit injury means A. Voluntarily suffered injury is not fit for action. B. No breach of a legal right is committed against one who is a willing party. C. Harm suffered voluntarily does not constitute an injury and is not actionable. D. All are correct. Answer, C. Question 684. The basic ingredient in constituting the maxim volenti non fit injury, which the defendant must prove in order to justify his tort, is A. The plaintiff had the knowledge of the risk. B. The plaintiff with his free consent ran the risk of harm. C. Both A and B. D. None of the above. Answer, C. Question 685. Rousseau is a Janus-like figure in the history of national law, who said this. A. Hobbes. B. J. S. Mill. C. Locke. D. Barker. Answer, D. Question 686. The protection and improvement of environment including forests and wildlife of the country is A. Directive principle of state policy. B. Fundamental national policy. C. Fundamental duty of a citizen. D. Both directive principle of state policy and fundamental duty of a citizen. Answer, D. Question 687. Originally the Supreme Court consisted of a Chief Justice and A. 7 other judges. B. 12 other judges. C. 13 other judges. D. 15 other judges. Answer, A. Question 688. Two strangers took lift in a jeep. A bolt fixing the right front wheel to the axle gave way, toppling the jeep. Two strangers were thrown out and one of them died of injuries and the other sustained injuries. The driver is responsible for the accident as he did not take care and caution. B. The owner is responsible as he led the driver to drive a defective vehicle. C. The strangers are responsible as they took the lift willingly, volenti non fit injury. D. Both the driver and owner are responsible. Answer, C. Question 689. The Supreme Court held in which of the following cases that preamble is not the part of the Constitution of India? A. Berubari case. B. A. K. Gopalan case. C. Balaji case. D. Minerva Mills case. Answer, A. Question 690. Jurisprudence is as big as law and bigger. Who said this? A. Austin. B. Lloyds. C. Llewellyn. D. Holland. Answer, C. Question 691. The President's rule under Article 356 of the Constitution of India remains valid in the state for maximum period of A. 1 month. B. 3 months. C. 6 months. D. 1 year. Answer, C. Question 692. The power of the Parliament to amend the Constitution of India is a constituent power laid down in Article 368 by A. 24th Amendment Act, B. 26th Amendment Act, C. 42nd Amendment Act, D. 44th Amendment Act. Answer: A. Question 693. The maxim volenti non fit injury means A. Voluntarily suffered injury is not fit for action. B. No breach of a legal right is committed against one who is a willing party. C. Harm suffered voluntarily does not constitute an injury and is not actionable. D. All are correct. Answer: C. Question 694. The basic ingredient in constituting the maxim volenti non fit injury, which the defendant must prove in order to justify his tort, is A. The plaintiff had the knowledge of the risk. B. The plaintiff with his free consent ran the risk of harm. C. Both A and B. D. None of the above. Answer: C. Question 695. Which one of the following is not a valid defense in tort? A. Volenti non fit injury. B. Vis major. C. Scienti non fit injury. D. Consent. Answer: C. Question 696. The maxim scienti non fit injury means A. No injury is done to one who knowingly does an act. B. Voluntarily suffered injury is not fit for action. C. Where there is a right, there is a remedy. D. None of the above. Answer: A. Question 697. The term scienter is related to which one of the following signboards? A. Trespassers will be prosecuted. B. Beware of dogs. C. No parking. D. No admission without permission. Answer: B. Question 698. Two strangers took lift in a jeep. A bolt fixing the right front wheel to the axle gave way, toppling the jeep. Two strangers were thrown out and one of them died of injuries and the other sustained injuries. The driver is responsible for the accident as he did not take care and caution. B. The owner is responsible as he led the driver to drive a defective vehicle. C. The strangers are responsible as they took the lift willingly, volenti non fit injury. D. Both the driver and owner are responsible. Answer: C. Question 699. A music teacher was held liable for raping a minor girl even though he had taken her consent under the pretext that an operation, sexual intercourse, is required to improve her voice. It is the fact of the case in A.B. vs. White, B.R. vs. Clearance, C.R. vs. Williams, D.R. vs. Catherine. Answer: C. Question 700. The maxim volenti non fit injury would be applied in which of the following cases? A. When a servant is compelled to do some work in spite of his protest, Bowater vs. Rovelli. B. A workman adopts a risky method of work under his own free will, Imperial Chemical Industries Lieutenant. D. vs. Shotwell. C. The workman worked under constant risk of his life but during the accident, he was not warned, which was supposed to be Smith vs. Baker. D. Both A and C. Answer: B. Question 701. A lady died at the time of the birth of her child. D. An unqualified midwife attended her to on her own request at the time of the delivery. Her husband brought an action for damages. In this case, A. No damages are payable as the deceased lady voluntarily engaged the midwife. B. Damages are payable to the husband as his contest was not taken. C. No damages are payable as the unqualified midwife can be criminally tried. D. D. Damages are payable as the consent of the deceased was irrelevant. Answer: A. Question 702. A person who is not qualified as a medical practitioner performed an operation with the consent of a patient die. D. Which one of the following grounds will be most appropriate to determine his liability? A. Voluntary non-fit injury is a complete defense. B. He has no intention to kill and has performed the operation in good faith for the benefit of the person. C. He has earlier done similar operations with success. D. As he is not a medical practitioner and is unskilled, the plea of consent and good faith will not be available. Answer: B. Question 703. The plaintiff, a one-eyed man, employed by the defendants, was working in conditions involving some risk of eye injury, but the likelihood of injury was not sufficient to call upon the defendants to provide goggles as to a normal two-eyed workman. The plaintiff was injured in the eye while working. The defendants are: A. Liable because the plaintiff, being a one-eyed workman, magnitude of risk of injury to his remaining eye was very high and consequently the defendants should have provided him with goggles. B. Not liable because the defendants were not duty-bound to provide goggles to the plaintiff. C. Liable because the plaintiff's nature of duties was such that eye injury was probable. D. Not liable because the plaintiff had voluntarily undertaken the job fully appreciating the risks involved. D. Answer: A. Question 704. Which one of the following is not an exception to the rule of voluntary non-fit injury? A. A surgeon amputates a limb of a patient to save his life. B. Injury is caused while play fighting with naked swords at a religious function. C. Injury is caused to a player in a football match. D. Injury is caused while doing lawful acts under a contract. Answer: B. Question 705. Which one of the following limitations to the rule of voluntary non-fit injury is not correct? A. The consent should be free. B. Consent to illegal act is no consent. C. Mere knowledge of the risk is not an assumption of the risk. D. Consent in rescue cases is no consent. Answer: D. Question 706. The scope of application of the doctrine of voluntary non-fit injury has been curtailed. D. A. In rescue cases. B. When the person has taken the risk by his own free will. C. By the Unfair Contract Terms Act, 1977, England. D. Both A and C. Answer: D. Question 707. The servant of A left a horse van unattended on a street. A boy threw a stone at the horses that got frightened and bolted. D. This constituted a grave danger to the woman and the children on the road. D. A policeman perceiving this danger managed to stop the horses but was himself injured. D. An action against A by the policeman would lie because the latter acted under an exigency caused by wrongful conduct of A's servants. B. An action against A would fail because of voluntary non-fit injury on the part of the policeman. C. An action against A would fail because it was action of the boy that resulted in bolting of the horses. D. None of the above. Answer: A. Question 708. Who said, when the plaintiff himself is a wrongdoer, he is not disabled from recovering in tort, unless some unlawful act or conduct on his part is connected with the harm suffered by him as part of the same transaction? A. Sir Frederick Pollock. B. Sir Garfield Pollock. C. Winfield. D. Salmond. Answer: A. Question 709. A. An employee of a bank was arrested by the police upon a written complaint of bank A was acquitted at session trial. A claimed damages. A bank had a probable cause and hence no false imprisonment. B bank had a reasonable cause and hence no false imprisonment. C as bank caused arrest of a hence it is liable. D none of the above. Answer C. Question 710. Which one of the following statement is correct? A. Inevitable accident is not a defense at all but only a denial of liability. B. Inevitable accident is not a denial of liability but only defense. C. Inevitable accident is both defense and denial of liability. D. Inevitable accident is a chance event and can neither be a defense nor a denial of liability. Answer C. Question 711. Act of God is also known by the name A. Vis major. B. Damnum fatale. C. Vis major or damnum fatale. D. Force majeure. Answer A. Question 712. The act of God is A. An inevitable accident, without any human intervention. B. Beyond the control of humans' right. C. Extraordinary occurrence which could not be foreseen and could not have been guarded against. D. All of the above. Answer D. Question 713. A railway company was authorized by law to run railway trains on a track. The sparks from the engine set fire to the adjoining property belonging to the plaintiff. Which one of the following defenses will be most appropriate for the defendant to raise in an action for nuisance by the plaintiff? A. Public good. B. Nuisance due to others' acts. C. Reasonable act in conducting his business. D. Statutory authority. Answer D. Question 714. The maxim, salus populi supreme law, means A. No man is above the law. B. The welfare of the people is the supreme law. C. The defense of statutory authority is the supreme law. D. None of the above. Answer B. Question 715. The rule of strict liability implies A. No fault liability, i.e., the fault or negligence of the guilty party is immaterial. B. Liability based on fault. C. State liability. D. Absolute liability. Answer A. Question 716. The rule of absolute liability implies A. Strict liability. B. Stricter than strict liability. C. State liability. D. None of the above. Answer B. Question 717. The rationale of absolute liability is that the undertakers of hazardous activities have to pay A. if they are at fault. B. partially even if they are not their part. C. regardless of any fault on their. D. if they have not taken reasonable care. Answer A. Question 718. A person who, for his own purposes, brings on his land and collects and keeps there anything likely to do mischief, if it escapes must keep it in at his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape. The above rule was enunciated in A. Nichols vs. Marslan. D. B. Donoghue vs. Stevenson. C. Rylands vs. Fletcher. D. None of the above. Answer C. Question 719. The rule of strict liability was laid down in Rylands vs. Fletcher by A. Blackburn, J. in 1868. B. Lord Atking in 1635. C. Winfield in 1765. D. Holt, C.J. in 1868. Answer A. Question 720. The absolute liability theory as the basis for liability in court for industrial injuries was propounded by A. Blackburn, J. B. V. R. Krishna Iyer, J. C. P. N. Bhagwati, C. J. D. Lord Atking. Answer, C. Question 721. To bring the case within the ambit of strict liability, the following are necessary. A. Some dangerous thing must have been brought by a person on his land. D. B. The thing brought by a person on his land must escape. C. It must be unnatural use of land. D. D. All of the above. Answer, D. Question 722. The rule in Rylance vs. Fletcher is not applicable. A. Inevitable accident. B. Vis major. C. Negligence of the defendant. D. Mistake. Answer, B. Question 723. Give correct response. A. No person is liable for the wrongful acts of others. One is liable for his own acts. B. One person may be, vicariously, liable for the wrongful acts of others when a certain relationship exists between the two, such as of master and servant, principal and agent, or partners inter se. C. Both A and B are correct. D. None of the above. Answer, C. Question 724. The vicarious arising from relation is A. Of the principal and agent, B. Of the master and servant, C. Of the guardian and ward. D. D. All are correct. Answer, D. Question 725. Give correct response. A. The liability of master and servant is joint. B. The liability of master and servant is several. C. The liability of master and servant is joint and several. D. None of the above. Answer, C. Question 726. When an agent commits a tort in the performance of his duty as an age-injured party can sue A. The agent only. B. The principal only. C. Either the principal or the agent. D. Either the principal or the agent or B of them. Answer, D. Question 727. Which one of the following statements is correct? A. An innocent principal is not liable for the fraud of his agent. B. An innocent principal is liable for the fraud of his agents. C. An innocent agent is liable for all frauds of his principal. D. None of the above is correct. Answer, B. Question 728. The maxim, qui facet per alium facet per se means. A. He who does an act through another is deemed in law to do it himself. B. He who does an act through another is not deemed in law to do it himself. C. The vicarious liability. D. Both A and B. Answer, D. Question 729. A servant is a person. A. Who works for another. B. Who is employed by another. C. Who acts on behalf of the other. D. Who voluntarily agrees to work under the control and command of another during the period of employment, whether for remuneration or salary, or even gratuity hourly. Answer, D. Question 730. The employer will not be liable. A. Where the thing contracted to be done through the independent contractor is itself unlawful. B. For the words of an incompetent contractor. C. For the wrong of servants engaged by the independent contractor. D. In all the above cases. Answer, C. Question 731. A master is liable for the wrongs of his servant if the servant A. has acted outside the scope of his duty in violation of express orders. B. is temporarily lent to another. C. has acted in self-defense against the criminal conduct of the person who sues the master. D is drunk while on duty. Answer B. Question 732. X wanted to purchase Y's car and was driving it to test it with Y seated by his side. Because of X's negligence, an accident happened in which the plaintiff, Z, was injured. DZ sues Y for damages. Y is not liable as X was driving the car for his own purpose. Y is not liable as X was not the servant of. Y is liable because he had not abandoned his right and duty to control the way in which the car was driven. Y is liable because X was driving the car for Y's purpose. Answer B. Question 733. Consider the following elements. 1. Infringement of a legal right. 2. Legal damages. 3. Any damage. 4. Existence of a legal right. Right to claim damages in tort would arise only if A, I, and 2 are present. B, I, 2, and 4 are present. C, I, 3, and 4 are present. D, 3, and 4 are present. Answer A. Question 734. A master is liable for the tort committed by his servant when the servant acts A. for the benefit of his master. B. in course of his employment. C. during his duty hours. D. to the detriment of the plaintiff. Answer B. Question 735. The Crown Proceedings Act, which makes the Crown liable for the tortuous acts of its servants acting in the course of their employment, was enacted in A. 1835, B. 1932, C. 1948, D. 1947. Answer D. Question 736. Which article of the Constitution of India lays down that the Union of India and the states can sue and be used? A. Art. 301. B. Art. 300. C. Art. 304. D. Art. 365. Answer B. Question 737. An act done by a government servant in exercise of statutory power is a defense. A. if the said act is a constitution act. B. if the said act is in exercise of sovereign function. C. if the said act is in exercise of non-sovereign functions. D. none of the above. Answer B. Question 738. The distinction between sovereign and non-sovereign functions of the state was laid down in A. Rylands vs. Fletcher. B. Donoghue vs. Stevenson. C. M. C. Mehta vs. Union of India. D. Peninsular and Oriental Steam Navigation Co. vs. Secretary of State, India. Answer A. Question 739. Which of the following is not a sovereign function of the state? A. Administration of justice. B. Maintenance of law and order. C. Defense. D. Famine relief work. Answer D. Question 740. When two or more persons commit same tort against the same plaintiff, they may be A. Composite tortfeasors. B. Contributory negligence tort committers. C. Tort partners. D. none of the above. Answer A. Question 741. When the acts of two or more persons acting independently concur to produce a single damage, they are known as A. Independent tortfeasors. B. Joint tortfeasors. C. Nuisance. D. none of the above. Answer A. Question 742. The leading case on the subject of distinction between joint tortfeasors and independent tortfeasors is A. Meriwether vs. Nixon. B. Ramkumar vs. Ali Hassan. C. The Kursk. D. V. Lloyd vs. Grace Smith and Co. Answer A. Question 743. Which of the following is an example of joint tortfeasor? A. Partners. B. Principal and agent. C. Master and servant. D. All of the above. Answer D. Question 744. An agreement enforceable by law is A. Enforceable acceptance. B. Accepted offer. C. Approved promise. D. Contract. Answer D. Question 745. Every promise and every set of promises, forming the consideration for each other, of each other is an A. Agreement. B. Contract. C. Offer. D. Acceptance. Answer A. Question 746. Promises which form the consideration or part of the consideration for each other are called A. Reciprocal promises. B. Cross offers. C. Conditional offer. D. Conditional promises. Answer A. Question 747. An agreement not enforceable by law is stated called to be void under A. Section 2, D. B. Section 2, E. C. Section 2, 1. D. Section 2, G. Answer D. Question 748. Void agreement signifies A. Agreement illegal in nature. B. Agreement not enforceable by law. C. Agreement violating legal procedure. D. Agreement against public policy. Answer B. Question 749. Offer as defined under Section 2, A. Is A. Communication from one person to another. B. Suggestion by one person to another. C. Willingness to do or abstain from doing an act in order to obtain the assent of other thereto. D. None of the above. Answer C. Question 750. Under Section 2, B. If the person to whom the proposal is made signifies his assent, the proposal is said to have been A. Accepted. B. Agreed. C. Provisionally agreed. D. Tentatively accepted. Answer A. Question 751. A proposal when accepted becomes A. Promise under Section 2, B. B. Agreement under Section 2, E. C. Contract under Section 2, H. D. None of the above. Answer A. Question 752. When, at the desire of the promisor, the is promisee or any other person has done or abstained from doing or does or abstain from doing or promises to do or to abstain from doing something, such act or abstinence or promise under Section 2, D, is called A. Reciprocal promise. B. Consideration for the promise. C. Counter offer. D. Acceptance. Answer B. Question 753. Promises which form the consideration or part thereof, for each other under Section 2, F, are called A. Acceptances for different proposals. B. Agreements. C. Reciprocal promises. D. Consideration. Answer C. Question 754. Every promise or set of promises forming the consideration for each other under Section 2, E, is called A. Reciprocal promise. B. Contract. C. Agreement. D. None of the above. Answer C. Question 755. An agreement enforceable by law at the instance of one party and not of other party under Section 2, I, is called A. Valid contract. B. An illegal contract. C. Void contract. D. Avoidable contract. Answer D. Question 756. Which is correct? A. Proposal plus acceptance is equal to promise. B. Promise plus consideration is equal to agreement. C. Agreement plus enforceability is equal to contract. D. All the above. Answer, D. Question 757. In a valid contract, what comes first? A. Enforceability. B. Acceptance. C. Promise. D. Proposal. Answer, D. Question 758. Under Section 2, C. Promiser is the A. Person who makes the proposal. B. Person who accepts the proposal. C. Person who makes the promise. D. Person to whom the proposal is made. Answer, A. Question 759. Under Section 2, C. Promisee is the A. Person who makes the proposal. B. Person who accepts the proposal. C. Person who makes the promise. D. Person to whom proposal is made. Answer, B. Question 760. Goods displayed in a shop with a price tag is an A. Offer. B. Invitation to offer. C. Counter offer. D. None of the above. Answer, B. Question 761. Tender is A. An offer. B. An invitation to offer. C. A counter offer. D. A promise. Answer, B. Question 762. Communication of a proposal is complete. A. When it is put in the course of TR submission. B. When it comes to the knowledge of the person to whom it is made. C. When the proposal is communicated to the person to whom it is made. D. All the above. Answer, B. Question 763. Communication of acceptance is complete as against the proposer. A. When it comes to the knowledge of the proposer. B. When it is put in the course of TR submission to him so as to be out of power of the acceptor. C. When the acceptance is communicated to the proposer. D. All the above. Answer, B. Question 764. Communication of acceptance is complete as against the acceptor. A. When it comes to the knowledge of the proposer. B. When it is put in the course of TR submission. C. When it is communicated to the accepted that the acceptance has reached proposer. D. When the proposer conveys the acceptance to the acceptor. Answer, A. Question 765. Revocation of offer by letter or telegram can be completed. A. When it is dispatched. B. When it is received by the offeree. C. When it reaches the offeree. D. Both A and B. Answer, B. Question 766. Acceptance to be valid must A. Be absolute. B. Be unqualified. C. Both be absolute and unqualified. D. Be conditional. Answer, C. Question 767. A contract with or by a minor is A. Valid contract. B. Void contract. C. Voidable contract. D. Voidable at the option of either party. Answer, B. Question 768. A contract which ceases to be enforceable by law becomes void. A. When it ceases to be enforceable. B. Before it ceases to be enforceable. C. No such condition necessary. D. None of above. Answer, A. Question 769. An acceptance can be revoked. A. At any time before the communication of acceptance is complete as against the promisee. B. After its acceptance comes to the knowledge of the promisee. C. Both A and B. D. Neither A nor B. Answer, A. Question 770. A proposal stands revoked. A. By communication of notice of revocation by the proposer. B. By failure of acceptor to fulfill a condition precedent. C. By death or insanity of proposer to the knowledge of acceptor. D. All the above. Answer, D. Question 771. A proposal can be accepted. A. By notice of acceptance. B. By performance of condition of proposal. C. By acceptance of consideration for a reciprocal promise. D. All the above. Answer, D. Question 772. Enforceable agreements are the 1. A. Made by free consent. B. Parties to the contract are competent to enter into an agreement. C. Having lawful consideration and lawful object. D. All the above. Answer, D. Question 773. Competency to contract relates to A. Age of the parties. B. Soundness of mind of the parties. C. Both age and soundness of mind. D. Intelligence of the parties. Answer, C. Question 774. Which one of the following is correct? A. Past consideration is no consideration. B. Consideration can be past, present or future. C. Consideration can only be present. D. Consideration can only be present and future. Answer, B. Question 775. Past consideration is valid in A. England only. B. India only. C. Both in England and India. D. Neither in England nor in India. Answer, C. Question 776. An agreement not to raise the plea of limitation is A. Valid and binding. B. Void. C. Voidable. D. Illegal. Answer, B. Question 777. Which one of the following pairs does not match? A. Novation of contract, Section 62. B. Agreement in restraint of legal proceedings, Section 29. C. Tender of performance, Section 38. D. Unlawful object and consideration, Section 23. Answer, B. Question 778. When the consent to the contract is caused by coercion, the contract under Section 19 is A. Valid. B. Voidable. C. Void. D. Illegal. Answer, B. Question 779. A's son forged B's name to a promissory note. B. Under threat of prosecuting A's son obtains a bond from A for the amount of the forged note. If B sues on this bond the court, A has no jurisdiction in this case. B must not set aside the bond. C may set aside the bond. D. None of above. Answer, C. Question 780. When the consent is caused by misrepresentation, the contract under Section 19 is A. Valid. B. Void. C. Voidable. D. Illegal. Answer, C. Question 781. When the consent is caused by undue influence, the contract under Section 19 is A. Valid. B. Void. C. Voidable. D. Illegal. Answer, C. Question 782. Where both the parties are under mistake as to matter of fact, the contract under Section 20 is A. Voidable. B. Void. C. Valid. D. Illegal. Answer, B. Question 783. Where one of the parties is under a mistake as to matter of fact, the contract is A. Valid. B. Void. C. Voidable. D. Illegal. Answer, A. Question 784. Considerations and objects are unlawful where it is A. Forbidden by law or defeat the provision of any law. B. Which is fraudulent. C. Which is immoral and against the public policy. D. All the above. Answer, D. Question 785. If only a part of the consideration or object is unlawful, the contract under Section 24 shall be A. Valid, B. Voidable, C. Void, D. Illegal. Answer, C. Question 786. A contract without consideration under Section 25 is A. Valid, B. Voidable, C. Void, D. Illegal. Answer, C. Question 787. Consideration should be something in return of promise which A. Both the law and parties regard as having some value, B. Only law regards as having some value, C. Only the parties regard some value, D. Only adequate value necessary. Answer, B. Question 788. If the proposer prescribes the mode and manner of acceptance, the acceptance A. can be in any manner and mode, B. should be in the manner and mode prescribed, C. can be in any reasonable mode and manner, D. all the above. Answer, B. Question 789. Parties are not competent to contract if any of them is A. minor, B. insane, C. declared unqualified, D. all the above. Answer, D. Question 790. Consent is free under Section 14 if not caused A. coercion and undue influence, B. fraud and misrepresentation, C. mistakes subject to the provisions of Sections 20, 21 and 22, D. all the above. Answer, D. Question 791. Consent under Section 13 means A. agreeing on the same thing in the same sense, B. agreeing on the same thing at the same time, C. agreeing on the same thing at different time, D. agreeing on different things at different times. Answer, A. Question 792. A contract which is valid initially however, ceases to be enforceable subsequently, the contract A. remains valid, B. becomes voidable when enforceable, C. becomes void when it ceases to be enforceable, D. becomes void since inception. Answer, C. Question 793. Agreements, the meaning of which is not certain or not capable of being made under Section 29 are A. void, B. voidable, C. illegal, D. valid. Answer, A. Question 794. An agreement in restraint of trade under Section 27 is A. valid, B. voidable, C. void, D. unenforceable. Answer, C. Question 795. An agreement in restraint of trade valid under Section 27 if it relates to A. sale of goodwill, B. mutual adjustment, C. business contingency, D. none of the above. Answer, A. Question 796. An agreement not to pursue any legal remedy to enforce the rights under Section 28 is A. valid, B. voidable, C. void, D. unenforceable. Answer, C. Question 797. An agreement not to pursue legal remedies but to refer the dispute to the arbitrator under Section 28 is A. valid, B. voidable, C. void, D. unenforceable. Answer, A. Question 798. An agreement to refer the dispute to the arbitrator is valid A. in respect of disputes already arisen, B. in respect of disputes which may arise in future, C. both A and B, D. neither A nor B. Answer, C. Question 799. An agreement by way of wager under Section 30 is A. Void. B. Voidable. C. Valid. D. Unenforceable. Answer: A. Question 800. An agreement in connection with horse racing under Section 30 is A. Unlawful. B. Void. C. Voidable. D. Valid. Answer: D. Question 801. An agreement in restraint of marriage under Section 26 is A. Void. B. Voidable. C. Valid. D. Unenforceable. Answer: A. Question 802. If only a part of the consideration or object is unlawful, the contract under Section 24 shall be A. Valid to the extent the same are lawful. B. Void to the extent the same are unlawful. C. Void as a whole. D. Valid as a whole. Answer: C. Question 803. An agreement shall be void on account of A. Mistake of fact by one party. B. Mistake of fact by both the parties. C. Mistake of foreign law. D. Both A and B. Answer: B. Question 804. Coercion which vitiates free consent under Section 15 is A. Committing or threatening to commit any act which is forbidden by law. B. Committing or threatening to commit any act which is forbidden by Indian Penal Code. C. Unlawful detaining or threatening to detain any property with an intention to causing any person to enter into an agreement. D. All the above. Answer: D. Question 805. What is correct for a standard form of contract? A. It is a valid contract. B. One party has no choice but to accept and sign the contract. C. Both A and B. D. The consent is not a free consent. Answer: A. Question 806. Law of contract primarily A. Specifies the circumstances in which promises are binding on the parties to the contract. B. Lays down certain norms by which the parties are bound. C. Lays down the circumstances under which a promise may be made. D. All the above. Answer: D. Question 807. Misrepresentation under Section 18 means A. A positive assertion, in a manner not warranted by the information of the person making it, not true but he believes it to be true. B. Any breach of duty, which gains an advantage to the person committing it, by misleading another to his prejudice. C. Causing a party to make an agreement to make a mistake as to the subject matter of contract. D. All the above. Answer: D. Question 808. A person is deemed to be in a position to dominate the will of another by undue influence if the mental capacity is affected temporarily or permanently by A. Reason of age. B. Reason of illness. C. Mental or bodily distress. D. All the above. Answer: D. Question 809. An agreement to remain unmarried is A. Valid. B. Voidable. C. Void. D. Unenforceable. Answer: C. Question 810. A general offer open for world at large can be accepted. A. By sending a communication of acceptance. B. By complying with the conditions of offer. C. By tendering himself to comply the conditions of offer. D. None of the above. Answer: B. Question 811. The term consensus ad idem means A. General consensus. B. Reaching an agreement. C. Meeting of minds upon the same thing in the same sense. D. All the above. Answer: C. Question 812. Which one of the following does not amount to fraud? A. Suggestion as a fact which is not true, by one who does not believe it to be true. B. Active concealment of a fact. C. A representation made without knowing it to be false, honestly believing it to be true. D. A promise made without any intention of performing it. Answer: C. Question 813. Contract without consideration made in writing and registered and made on account of natural love and affection is A. Void. B. Voidable. C. Valid. D. Unenforceable. Answer: C. Question 814. Inadequacy of consideration does not make the contract A. Void. B. Voidable. C. Unenforceable. D. Neither void nor voidable. Answer: A. Question 815. Inadequacy of consideration is relevant in determining the question of A. Fraud. B. Misrepresentation. C. Undue influence. D. Free consent. Answer: D. Question 816. Agreement without consideration is valid A. When made out of love and affection due to near relationship. B. When made to compensate a person who has already done something voluntarily. C. When made to pay a time-barred debt. D. All the above. Answer: D. Question 817. A contract based on the happening or non-happening of a future event under Section 31 is called A. A contingent contract. B. A wagering contract. C. A contract marked with uncertainty and hence void. D. None of the above. Answer: A. Question 818. A contingent contract to do or not to do anything on the happening of an uncertain future event under Section 32. A. Is never enforceable. B. Becomes enforceable only on the happening of that event. C. Enforceable since the time of making it. D. Becomes enforceable in the immediate possibility of happening of that event. Answer: B. Question 819. A contingent contract. A. Is void. B. Never becomes void. C. Becomes void when the event impossible. D. Is voidable. Answer: C. Question 820. A contingent agreement based impossible event under Section 36. A. Is void. B. Is void till the impossibility is known. C. Becomes void on the knowledge impossibility. D. All the above. Answer: A. Question 821. What is true of misrepresentation? A. It is the same thing as fraud. B. It renders the contract voidable. C. It may be due to innocence. D. Both. B. and C. Answer: D. Question 822. Two persons have the capacity to contract under Section 11. A. If both are major. B. If both are not of unsound mind. C. If none is declared unqualified to contract. D. All are correct. Answer: D. Question 823. A contract with minor is A. Voidable at the instance of the minor. B. Voidable at the instance of other party. C. Void. D. Valid. Answer: C. Question 824. An agreement to do an act impossible in itself under Section 56 is A. Void. B. Valid. C. Voidable. D. Unenforceable. Answer: A. Question 825. A contingent contract based on the specified uncertain event happening within a fixed time under Section 35. A. Remains valid even if the event does not happen within that fixed time. B. Becomes void at the expiration of the time fixed. C. Becomes void if the happening of that event becomes impossible before the expiry of time fixed. D. Both. B. and C. Answer: D. Question 826. The Limited Liability Partnership Act, 2008, 6 of 2009, is an act to make provisions for the a formulation and regulation of general partnership firms and limited liability formed under Indian Partnership Act, 1932. B. Formulation and regulation of joint ventures with unlimited liability formed under Indian Contract Act, 1872. C. Formulation and regulation of chit funds organizations with unlimited liability formed under the Chit Funds Act, 1982. D. Formation and regulation of limited liability partnership with limited liability formed under the Limited Liability Partnership Act, 2008. Answer: D. Question 827. Foreign Limited Liability Partnership, FLLP, under the Limited Liability Partnership Act, 2008 means a limited liability partnership formed, incorporated or registered in that country to which the partners belong. B. A limited liability partnership formed, incorporated or registered under Economic Council of UNO. C. A limited liability partnership formed, incorporated or registered in Indian territory. D. A limited liability partnership formed, incorporated or registered outside India which establishes a place of business within India. Answer: D. Question 828. Every limited liability partnership as per the Limited Liability Partnership Act, 2008 shall have at least 2 designated partners, DPs, who are individuals, and A. At least one among them shall be resident in India. B. Both of them shall belong to one family residing in India. C. Both of them should be non-resident Indians, NRIs. D. Both of them should belong to a single country outside India. Answer: A. Question 829. Prior to the Indian Partnership Act, 1932, which came into force from 1st October 1932 except Section 69 which came into force from 1st October 1933, the law of partnership was provided in A. Sale of Goods Act, 1930. B. Indian Contract Act, 1872. C. Transfer of Property Act, 1908. D. English Partnership Act, 1890. Answer: B. Question 830. Unilateral dissolution of partnership by partner who is minority shareholder is A. Not permissible. B. Permissible. C. Permissible if all minority shareholders agree. D. Permissible if Memorandum of Association prescribes. Answer: D. Question 831. An act, to be called on, act of a firm, within the meaning of Section 2(a) of the Indian Partnership Act, 1932 is A. Every act of the partners. B. Only such acts which give rise to a right enforceable by or against the firm. C. Such acts which do not give rise to a right enforceable by or against the firm. D. Either A or B. Answer: D. Question 832. Any act or omission, to be an act of a firm, within the meaning of Section 2(a) of the Indian Partnership Act, 1932 must be act or omission of A. All the partners. B. Any of the partner. C. Agent of the firm. D. Either A or B or C. Answer: D. Question 833. Whether an act of a partner or agent can be regarded as an act of the firm is A question of fact. B. Question of law. C. Mixed question of fact and law. D. Either A or C. Answer: A. Question 834. In the Indian Partnership Act, 1932 the term business has been defined under A. Section 2, A. B. Section 2, B. C. Section 2, D. D. Section 2, E. Answer, B. Question 835. Under Section 2, B, of the Indian Partnership Act, business includes A. Every trade and occupation, B. Every occupation and profession, C. Every trade, occupation and profession, D. Every trade and profession. Answer, C. Question 836. The term partnership has been defined under A. Section 3, B. Section 4, C. Section 5, D. Section 6. Answer, B. Question 837. Under Section 4 of the Indian Partnership Act, partnership is A. Compulsory legal relation, B. Creation of choice and voluntarily agreement between the concerned parties, C. A relation arising from status, D. Either A or B or C. Answer, A. Question 838. Which of the following enactments insist for a written agreement of partnership? A. The Indian Partnership Act, 1932, B. The Indian Contract Act, 1872, C. The Indian Registration Act, 1908, D. Neither A nor B nor C. Answer, D. Question 839. A partnership can be A general partnership, B. A particular partnership, C. Either A or B, D. Only A and not B. Answer, B. Question 840. Section 8 of the Indian Partnership Act, 1932 provides for A particular partnership, B. A general partnership, C. A partnership at will, B. D. All the above. Answer, A. Question 841. The relation of partnership arises from contract and not from status, has been prescribed under A. Section 4, B. Section 5, C. Section 6, D. Section 7. Answer, B. Question 842. Section 7 of the Indian Partnership Act, 1932 provides for A. Partnership in undertaking, B. General partnership, C. Partnership at will, D. All the above. Answer, C. Question 843. A partnership firm is A distinct legal entity from its partners, B. Not a distinct legal entity from its partners, C. A juristic person, D. Either A or C. Answer, B. Question 844. For the purposes of income tax, a partnership firm A can be assessed as an entity distinct and separate from its partners, B cannot be assessed as an entity separate and distinct from its partners, C can be assessed as an entity distinct and separate from its partners only with the permission of the court, D can be assessed as an entity distinct and separate from its partners only if all the partners agree for the same. Answer, A. Question 845. A partnership cannot be constituted by A. Two individuals, B. Two Hindu joint families, C. Both A and B, D. Neither A or B. Answer, B. Question 846. The historic case laying down the test for determining the existence of a partnership is A. Grace vs. Smith, B. Wolf vs. Carver, C. Blorim vs. Pell, D. Cox vs. Hickman. Answer, D. Question 847. The mode of determining the existence of partnership has been laid down in A. Section 6. B. Section 5. C. Section 9. D. Section 10. Answer: A. Question 848. Which of the following in itself is not sufficient to constitute a partnership? A. The sharing of profits by persons having a joint or common interest. B. The receipt by a person of a share of the profits. C. The receipt by a person of a payment varying with the profits earned by business. D. All the above. Answer: D. Question 849. Which of the following is a valid partnership? A. Partnership between two partnership firm. B. Partnership between one partnership firm and an individual. C. Partnership between individual member of one firm and the individual members of another firm. D. Neither A, nor B, nor C. Answer: C. Question 850. A partnership firm is entitled to enter into a partnership with A. Another firm. B. Hindu undivided family. C. An individual. D. Neither A, nor B, nor C. Answer: D. Question 851. Mutual agency among the partner is A. A test to determine the existence of a partnership. B. A legal incidence of partnership. C. Both A and B. D. Neither A nor B. Answer: C. Question 852. A Hindu undivided family is entitled to enter into an agreement of partnership with A. Another joint Hindu family. B. Another partnership firm. C. An individual. D. Neither A nor B, nor C. Answer: D. Question 853. Which of the following is a valid partnership? A. Partnership between the Karta of a joint Hindu family in his representative capacity and an individual co-partner of the same family. B. Partnership between two Hindu joint families. C. Partnership between a Hindu joint family and a partnership firm. D. All the above. Answer: A. Question 854. Who wrote the famous 1855 poem, The Charge of the Light Brigade? A. Lord Alfred Tennyson. B. Christopher Marlowe. C. Johannes Gutenberg. D. René Descartes. Answer: A. Question 855. Section 5 of the Indian Partnership Act, 1932 does not apply to A. Muslim trading family. B. Christian trading family. C. Both A and B. D. Only A and not B. Answer: C. Question 856. The concept of partnership commensurate with A. Principal and agent. B. Co-owners of property. C. Joint owners of property. D. All the above. Answer: A. Question 857. A right to participate in profits, although strong but not a conclusive test of partnership. It was so held in A. Tellis vs. Saldanha. B. Cox vs. Hickman. C. Re. Stanton Iron Co. D. Grace vs. Smith. Answer: B. Question 858. Which of the following is not an essential requisite for creating a partnership as per Section 4? A. An agreement to carry on a business. B. Sharing of profits. C. Sharing of losses. D. Business to be carried by all or any of them acting for all. Answer: C. Question 859. A person who has lent money to a person or firm engaged in a business and has agreed to take a proportion of the profits of the business in addition to or in lieu of his interest, does not by that reason alone becomes a partner in the business, has been laid down in A. Badal vs. Consolidated Bank. B. Janes vs. Whitbread. C. Marconi's Wireless Telegraph Co. vs. Newman. D. Price vs. Groom. Answer A. Question 860. The Indian Partnership Act, 1932 provides for and recognizes A. Partnerships for a specified and fixed period. B. Partnerships for a specified and fixed venture. C. Both A and B. D. Only A and not B. Answer C. Question 861. A partnership for which no period or duration is fixed, under the Indian Partnership Act, 1932 is known as A. General partnership. B. Partnership at will. C. Particular partnership. D. Co-ownership. Answer B. Question 862. Partnership is A. Startup. B. Company. C. Mutual agency. D. Mutual fund. Answer C. Question 863. Which of the following is an exception to the partnership at will, as provided under Section 7 of the Indian Partnership Act, 1932? A. Where there is a provision for the duration of the partnership. B. Where there is a provision for determination of the partnership. C. Both A and B. D. Only A and not B. Answer C. Question 864. Where a partnership firm is constituted for a fixed period and after the expiration of that term, the firm continues to carry on business, without any new agreement. The partnership stands extended till the new agreement is made. B. The partnership becomes partnership at will. C. The partnership becomes illegal. D. The partnership stands dissolved on the date of expiry of the term and no partnership can be said to be in existence. Answer A. Question 865. In a partnership at will, A partner of a firm can retire from the firm at any time by giving a notice of his intention to retire to his co-partners. B. A partner of a firm can dissolve the firm at any time by giving a notice intention to dissolve the firm to his co-partners. C. Either A or B. D. Only B and not A. Answer C. Question 866. The test to determine whether the partnership is a partnership at will, whether the partnership could be dissolved by a single partner, has been laid down in A. Crochet vs. Moll. B. Abbott vs. Abbott. C. Cuff vs. Murtagh. D. Kurumuthu T. Chettiar vs. Eam. Mutlayappa Chettiar. Answer A. Question 867. For constituting a partnership within the meaning of Section 4 of the Indian Partnership Act, 1932, the business has to be of permanent nature. B. The business can be of temporary nature. C. It is immaterial as to whether the business is of temporary or permanent nature. D. Only A and not B. Answer C. Question 868. The principles governing partners' mutual relations have been laid down in A. Chapter 2 of the Indian Partnership Act. B. Chapter 3 of the Indian Partnership Act. C. Chapter 4 of the Indian Partnership Act. D. Chapter V of the Indian Partnership Act. Answer B. Question 869. General duties of partners have been laid down in A. Section 9 of the Act. B. Section 10 of the Act. C. Section 11 of the Act. D. Section 13 of the Act. Answer A. Question 870. Under Section 9 of the Indian Partnership Act, 1932, in doing best for the common body 1. A partner is regarded as a kind of trustee for the other partners too. A partner is liable to render the accounts to other partners in a fiduciary capacity. A. I only. B. two only. C. both. D. neither. Answer: C. Question 871. Under Section 10 of the Indian Partnership Act, every partner is under a duty: A. to indemnify the firm for any loss caused it by his fraud in the conduct of the business of the firm. B. to render true accounts and full information. C. not to carry on any business other than that of the firm. D. to be just and faithful to each other. Answer: A. Question 872. The rights and duties of partners inter se can be regulated and varied by the consent of the can partners by virtue of: A. Section 14 of the Act. B. Section 13 of the Act. C. Section 12 of the Act. D. Section 11 of the Act. Answer: B. Question 873. Under Section 11 of the Indian Partnership Act, 1932, in case of any conflict between the provision of the Act and the articles of the agreement, the articles of the agreement with it will be: A. valid. B. invalid. C. voidable at the instance of any of the partner. D. violable at the instance of a third party. Answer: B. Question 874. An agreement in restraint of trade in a partnership under Section 11 of the Act is: A. valid. B. voidable. C. void. D. invalid. Answer: A. Question 875. Section 12 of the Indian Partnership Act, 1932. A statement of rights of the partners in reference to the conduct of business. B. A statement of duties of the partners in the conduct of the business. C. A mixed statement of rights and duties of partners in reference to the conduct of the business. D. Neither A nor B. Answer: C. Question 876. Section 12 C of the Indian Partnership Act provides for A rule of majority. B. rule of unanimity. C. both A and B. D. only A and not B. Answer: C. Question 877. The rule of majority contained in Section 12 C of the Indian Partnership Act, 1932 is applicable in: A. trivial matters. B. ordinary matters. C. fundamental matters. D. all the above. Answer: B. Question 878. The rule of unanimity contained in Section 12 C of the Indian Partnership Act, 1932 has a reference to: A. fundamental matters. B. ordinary matters. C. trivial matters. D. all the above. Answer: A. Question 879. The rights and duties of a partner contained in Section 12 of the Indian Partnership Act, 1932 are: A. subject to the provision of the Indian Partnership Act, 1932. B. subject to a contrary arrangement between the partners. C. subject to the provisions of the Indian Contract Act, 1872. D. subject to the provisions of the Indian Trusts Act, 1882. Answer: B. Question 880. An agreement to carry on business in partnership in the future creates a partnership: A. immediately on the agreement. B. on the date mentioned in the agreement irrespective of whether the business has commenced or not on that date. C. only on the date when the business is actually commenced. D. never creates a partnership and any such agreement is void. Answer: C. Question 881. Whether a partnership exists or not is A question of fact. B. Question of law. C. Mixed. Question of fact and law. D. Either A or C. Answer A. Question 882. The maxim, soci me socius mu socius non est, me. Answer A. My partner's partner is not necessarily my partner. B. My partner's partner is necessarily my partner. C. The partnership has become illegal. D. The partnership stands dissolved by the act of God. Answer A. Question 883. The minimum number of persons required for a partnership is A. 2. B. 5. C. 10. D. 20. Answer A. Question 884. The maximum number of partners in a partnership has been provided under A. The Indian Partnership Act, 1932. B. The Indian Companies Act, 1956. C. The Indian Contract Act, 1872. D. The Indian Trusts Act, 1882. Answer B. Question 885. Under Section 11 of the Indian Companies Act, 1956, for a non-banking business, the maximum number of partners can be A. 10. B. 20. C. 25. D. 30. Answer B. Question 886. For a banking business, the maximum number of partners in a partnership under Section 11 of the Indian Companies Act, 1956, can be A. 10. B. 15. C. 20. D. 25. Answer A. Question 887. A partnership in which the number of partners exceeds than that allowed under Section 11 of the Indian Companies Act shall be A. valid. B. voidable at the instance of any of the partners. C. voidable at the instance of third parties. D. illegal. Answer D. Question 888. An illegal partnership. A. can sue. B. can be sued. C. cannot be sued. D. can sue and be sued. Answer C. Question 889. The members of an illegal partnership A. have a remedy against each other for the partnership dealings and transactions. B. have no remedy against each other for the partnership dealings and transactions. C. have a remedy against each other for the partnership dealings and transaction only with the permission of the court. D. either A or C. Answer B. Question 890. If the partners are equally divided on an issue, the rule is in re communipotier est condition prohibentis, which means A. those who forbid a change must have their way. B. those who do not forbid, i.e., in favor of the change, must have their way. C. the discussion on the issue be deferred for another day. D. opinion on the issue be taken from an expert. Answer A. Question 891. A partner has a right to have access to all the books of accounts et c. of the firm. A. during the subsistence of the partnership. B. during the proceedings for the dissolution of the firm. C. after the dissolution of the firm. D. all the above. Answer D. Question 892. A partner has a right to examine the account books et c. of the firm. A. himself. B. through legal representatives. C. through agent. D. either A or B or C. Answer D. Question 893. A partner can examine the books et c. of the partnership firm. A. as many number of times without any restriction. B. once a year. C. once a month. D. once a week. Answer A. Question 894. Section 13 of the Indian Partnership Act, 1932 is A mixed statement of rights and duties of the partners. B. A mixed statement of duties and liabilities of the partners. C. A mixed statement of rights and liabilities of the partners. D. A mixed statement of rights, duties and liabilities of the partners. Answer C. Question 895. The rate of interest prescribed under Section 13, where a partner advances money beyond the amount of capital for the business of the partnership, is A. 6%, B. 9%, C. 12%, D. 15%. Answer A. Question 896. Where a partner is entitled to interest on the capital subscribed, such interest is payable A. out of profits only, B. out of capital if no profits, C. out of capital if losses, D. either A or B or C. Answer A. Question 897. Section 13 A of the Indian Partnership Act, 1932 provides for A. payment of remuneration to a partner as a matter of right, B. payment of remuneration to a partner only when there is an agreement to that effect between the partners, C. non-payment of remuneration to a partner only when there is an agreement to that effect between the parties, D. both A and C. Answer B. Question 898. Under Section 13 B of the Indian Partnership Act, 1932 all the partners are entitled to A. share the profits and losses in the ratio of their capital contributions, B. share the profits and losses equally irrespective of any agreement between them to the contrary, C. share the profits and losses equally in the absence of any agreement to the contrary between them, D. share the profits and losses in the ratio of their personal efforts input. Answer C. Question 899. Where a change occurs in the constitution of a firm and no new agreement is made, the ratio of profit sharing shall become equal for all the partners. B. The ratio of profit sharing shall remain the same to the extent to which it is consistent with the altered composition of the firm. C. The ratio of profit sharing shall change in the ratio of capital contributions. D. The ratio of profit sharing shall change in the ratio of personal efforts labor input of the partners. Answer B. Question 900. As a general rule, by virtue of Section 13 of the Indian Partnership Act, 1932, a partner is not entitled to interest on the capital subscribed by him. B. Partner is not entitled to interest on the advance made over and above the share capital. C. Both A and B. D. Neither A nor B. Answer A. Question 901. As regards the capital contribution in the partnership business, the status of a partner is that of A. creditor of the firm, B. a partner of the firm, C. an employee of the firm, D. all the above. Answer B. Question 902. The status of a partner making advances to the firm for its business over and above the capital subscribed is that of A. partner of the firm, B. a creditor of the firm, C. an employee of the firm, D. both A and B. Answer B. Question 903. On the dissolution of the partnership, the interest on capital ceases run whereas interest of advances keeping running up to the date of payment, B. the interest on capital and the interest on advances cease to run, C. The interest on capital keeps running up to the date of payment, whereas interest on advances cease to run. D. The interest on capital as well as on advances keeps running up to the date of payment. Answer A. Question 904. Ordinarily, on the overdrawings by the partners from the firm, A. No interest is chargeable. B. Interest is chargeable at 6% PA. C. Interest is chargeable at 9% PA. D. Interest is chargeable at 12% PA. Answer B. Question 905. A partner has a right to indemnity for the acts done in A. The ordinary and proper conduct of the business. B. An emergency. C. Both A and B. D. Only B and not A. Answer C. Question 906. The right to indemnity is lost on A. The dissolution of the partnership. B. The death of the partner. C. The retirement of the partner. D. Neither A nor B nor C. Answer D. Question 907. Section 13 F of the Indian Partnership Act 1932 provides for A. Indemnity in favor of the partner against the firm. B. Indemnity in favor of the firm against a partner. C. Indemnity in favor of the third parties against the firm. D. All the above. Answer B. Question 908. An action for indemnity against a partner can be brought by A. The firm only. B. An individual partner. C. Either A or B. D. Neither A nor B. Answer C. Question 909. What constitutes the property of the firm has been dealt with in A. Section 16. B. Section 15. C. Section 14. D. Section 13. Answer C. Question 910. Section 14 of the Indian Partnership Act 1932. A. Exhaustive. B. Inclusive. C. Conclusive. D. Both A and C. Answer B. Question 911. Under Section 14 of the Indian Partnership Act 1932, the property thrown into the common stock at the commencement of the business A. becomes the property of the firm. B. remains the individual property of the partners in the shares contributed by them. C. becomes the individual property of the partners in equal shares irrespective of their contributions and profit sharing ratio. D. Either A or E. Answer A. Question 912. A property belonging to a partners and entering into a partnership and used for the purposes of partnership A. becomes the property of the firm. B. remains the property of that partner. C. becomes the property of the partner having highest share of capital contribution. D. becomes the property of the partners in their profit sharing ratio. Answer A. Question 913. All the benefits and liabilities arising out of a contract made on behalf of a partnership do not A. belong to the partnership if the contract has been performed before the dissolution of the firm. B. belong to the partnership if the contract has been performed before the retirement of the firm. C. belong to the partnership if the contract has been performed after the dissolution of the firm or retirement of a partner. D. none of the above. Answer C. Question 914. The property of the firm includes all property A. acquired by or for the firm. B. for the purpose or in the course of business of the firm. C. property purchased with money belonging to the firm. D. all the above. Answer D. Question 915. when the property is purchased out of the partnership funds but in the name of an individual partner, it A. becomes an estate of the partner. B. becomes a joint estate. C. is a question of fact to be determined with reference to the intention of the partners. D. is a question of law to be decided on legal principles. Answer B. Question 916. When the personal property of a partner is being used in the business of the firm, it A. is a question of fact to be determined with reference to the partner's intention whether it has become the property of the firm. B. becomes the joint estate. C. remains an estate of the partner. D. is a question of law to be decided on legal principles. Answer A. Question 917. Under Section 14 of the Indian Partnership Act, 1932, goodwill of the business is A. property of the firm. B. property of the managing partner. C. property of the partner having the highest share in the profits. D. property of the partner having the lowest share in the profits. Answer A. Question 918. Since the partnership property vests in all the partners and every partner has an interest in the property of the partnership, during the subsistence of partnership, A partner can deal with the property as his own. B. a partner can deal with a portion of the property up to his share in the partnership, as his own. C. a partner can deal with a specific item of the partnership property as his own. D. a partner cannot deal with any particular property or any portion of the property as his own. Answer D. Question 919. In a partnership property, a partner has A. something in the nature of personal ownership. B. only certain rights. C. both A and B. D. either A or B. Answer C. Question 920. If a partner chooses to use any assets of the partnership for his own purpose, it gives rise to A. civil liability of that partner. B. a criminal liability of that partner. C. both A and B. D. either A or B. Answer A. Question 921. Where a partner is authorized to recover dues of the partnership and spend the same for the business of the partnership, and if he does not deposit the money so collected in the bank, the partner is A. guilty of criminal breach of trust. B. accountable civilly to the other. C. both A and B. D. either A or B. Answer B. Question 922. Goodwill of the partnership business is the property of the partnership. A. under Section 14. B. under Section 15. C. under Section 16. D. under Section 17. Answer A. Question 923. The term goodwill is a thing very easy to describe but very difficult to define, is stated by A. Lord Hull. B. Lord Haldane. C. Lord Macnaghten. D. Lord Eldon. Answer C. Question 924. Section 15 of the Indian Partnership Act provides that the property of the firm shall be held and used by the partners exclusively for the purposes of the business of the firm. B. the property of the firm can be used by the partners for any of their personal use. C. the property of the firm can be used by the partners for the personal use of all the partners. D. both A and C. Answer A. Question 925. Section 15 of the Indian Partnership Act is a statement of A. right of the partners. B. duty of the partners. C. privilege of the partners. D. Liability of the partners. Answer B. Question 926. A marriage solemnized under Section 11 of Hindu Marriage Act, 1955 between any two Hindus, who are related to each other in Sapinda relationship, shall be A. Valid, B. Voidable, C. Void, D. Either valid or voidable. Answer C. Question 927. In case of impotence a marriage is voidable. A. Quod hanc, B. Quod hanc, C. Either A or B, D. Only A and not B. Answer C. Question 928. In violation of Section 5(3) of Hindu Marriage Act, a marriage solemnized between two Hindus as to the requirement of age, shall be A. Void, B. Voidable, C. Valid, D. Invalid. Answer B. Question 929. On which ground a marriage is voidable under Section 12 of Hindu Marriage Act, 1955? A. Physical incapacity, B. Mental incapacity, C. Both mental and physical incapacity, D. Only mental incapacity and not physical incapacity. Answer C. Question 930. An agreement between husband and the wife before the commencement of the Hindu Marriage Act, 1955. A. Cannot take away the right of the wife under Section 13(2) I. B. Can take away the right of the wife under Section 13(2) I. C. May or may not take away the right of the wife under Section 13(2), depending on the nature of compromise or agreement. D. Only A and not B or C. Answer A. Question 931. Order can be passed in respect of children under Section 26 of Hindu Marriage Act, who are A. Minor, B. Major, C. If girl either minor or major, D. Both A and B. Answer A. Question 932. Under Section 26 of Hindu Marriage Act, 1955 orders can be passed in respect of A. Illegitimate minor children, B. Legitimate minor children, C. Both illegitimate and legitimate minor children, D. Only A and not B. Answer C. Question 933. Under which section adultery is punishable as a matrimonial offense? A. Section 494 of I.P.C, B. Section 497 of I.P.C, C. Section 498 of I.P.C, D. Section 498 of I.P.C. Answer B. Question 934. Under Section 28 of the Hindu Marriage Act, 1955, every appeal according to the Marriage Laws, Amendment, Act 2003 shall be preferred within A. 60 days from the date of decree or order, B. 90 days from the date of decree or order, C. 120 days from the date of decree or order, D. None of the above. Answer B. Question 935. According to the Marriage Laws, Amendment, Act 2001, application for maintenance and education of the minor children pending the proceeding shall be disposed of within A. 60 days from the date of decree or order, B. 90 days from the date of decree or order, C. 120 days from the date of decree or order, D. None of the above. Answer B. Question 936. Under the Hindu Marriage Act, 1955 a petition can be presented before A. District Court, B. High Court, C. Supreme Court, D. District Court and the High Court. Answer A. Question 937. The court forfeits the right of maintenance on the ground of A. Remarriage, B. Sexual immorality, C. Either A or B, D. Only A and not B. Answer C. Question 938. If one of the spouse dies intestate after the passing of a decree for judicial separation, the other spouse A can inherit the property of that spouse only with the consent of the children. B can inherit the property of that spouse. C cannot inherit and only the children can inherit the property of that spouse. D cannot inherit the property of that spouse. Answer B. Question 939. As per Hindu Marriage Act, 1955 under Section 24, application for interim maintenance A can be filed before the filing of the written statement. B can be filed after the filing of the written statement. C only after the filing of the written statement and not before. D either before or after the filing of the written statement. Answer D. Question 940. As per Hindu Marriage Act, 1955 an application under Section 25 can be made A at any time subsequent to the passing of the decree, B in the main proceedings either before or at the time of passing of the decree granting substantive relief, C either A or B, D only A and not B. Answer C. Question 941. As per Hindu Marriage Act, 1955 an order for the grant of permanent alimony under Section 25 A operates on a charge on the property of the respondent when the court creates a charge on the property. B cannot operate as a charge on the property of the respondent under any circumstances. C by itself operates as a charge on the property of the respondent. D either A or C. Answer A. Question 942. Under Section 25 of Hindu Marriage Act, 1955 an order of maintenance can be varied, modified or rescinded. A retrospectively, B prospectively, C either prospectively or retrospectively depending on the facts and circumstances of the case. D only prospectively and not retrospectively. Answer C. Question 943. A pre-marriage agreement to live separately is A void, B voidable, C valid, D invalid. Answer A. Question 944. A post-marriage agreement to live separately in future is A void, B voidable, C valid, D invalid. Answer B. Question 945. A petitioner shall be entitled to a decree of restitution A on establishing that he or she has a desire to resume matrimonial cohabitation and to perform all matrimonial obligation. B on admission of the respondent that he or she is living separate on of the respondent spouse. C either A or B. D neither A nor B. Answer A. Question 946. A respondent can be ordered to take residence with the spouse A where the marriage has not been 28 consummated and the parties have not provisionally lived together. B where the marriage has been consummated. C where the marriage has not been consummated though the parties have provisionally lived together. D in all the above circumstances. Answer D. Question 947. Under Section 13(2)(I) of Hindu Marriage Act, 1955 a right to divorce has been given to A the first wife, B the second or subsequent wife or wives, C the first wife as well as the second or subsequent wife or wives, D only A and not B. of C. Answer C. Question 948. Under Section 13, 1, 2 of Hindu Marriage Act 1955, a bride can be exercised by a party 3. A. who continues to be a Hindu, B. who ceases to be a Hindu, C. both A and B, D. either A or B. Answer A. Question 949. Adoption is recognized under the A. Muhammadan law, B. Hindu law, C. Parsi law, D. all above. Answer B. Question 950. As per Hindu Marriage Act 1955, adultery means A. sexual connection of a husband with his wife against her wishes, B. sexual connection of a husband or wife with somebody other than a lawful spouse, C. sexual connection of a husband with his wife who is less than 15 years of age, without her consent, D. all the above. Answer B. Question 951. Marriage between two persons who are related to each other within the degrees of prohibited relationship shall be A. void, B. voidable, C. valid, D. invalid. Answer A. Question 952. Which section provides the Hindu marriage registration? A. Section 6 of Hindu Marriage Act, B. Section 8 of Hindu Marriage Act, C. Section 10 of Hindu Marriage Act, D. Section 12 of Hindu Marriage Act. Answer B. Question 953. Remedy of restitution of conjugal rights is aimed at A. dissolving the marriage, B. preserving the marriage, C. both A and B, D. either A or B. Answer B. Question 954. Restitution of conjugal rights is available to A. husband, B. wife, C. wife and husband both, D. only husband and not wife. Answer A. Question 955. Hindu Marriage Act 1955 Section 9 provides for A. judicial separation, B. jurisdiction of court, C. restitution of conjugal rights, D. ceremonies of marriage. Answer C. Question 956. A decree of judicial separation A. dissolves the marriage, B. does not dissolve the marriage and the marriage subsists, C. either A or B, D. only A and not B. Answer B. Question 957. In Hindu Marriage Act 1955 under Section 25, an order passed is A. an interlocutory order and no appeal lies against it, B. appealable only with the leave of the court, C. appealable generally, D. either A or B. Answer C. Question 958. Ceremonies to marriage have been laid down in minute details in A. Dharma Shastras, B. Dharma Sutras, C. Grahya Sutras, D. all the above. Answer C. Question 959. Children of annulled voidable marriages and of void marriage are A. heirs of their parent as well as to others in the family of their parents, B. heirs of their parents alone and to none else, C. neither the heirs of their parents nor to anyone else, D. either A or C. Answer B. Question 960. During judicial separation the A. parties continue to be husband and wife and may suspend or may not suspend the marital rights and obligations, B. parties continue to be husband and wife and the marital rights and obligation remain in fact, C. parties continue to be husband and wife but marital rights and obligations are suspended, D. Parties cease to be husband and wife. Answer, C. Question 961. Degrees of prohibited relationship include relationship by A. Adoption, B. Full blood, C. Half or uterine blood, D. All the above. Answer, D. Question 962. Doctrine of factum vallet enables to cure the violation of A. Fundamental principles, B. Essence of the transaction, C. A directory provisions or a mere matter of form, D. All the above. Answer, C. Question 963. Doctrine of recrimination provides that A. If both parties, independent of each other, have committed matrimonial offences, the marriage should not be dissolved. B. If both parties, independent of each other, have committed matrimonial offences, the marriage should be dissolved. C. If both parties, independent of each other, have committed matrimonial offences, they should be judicially separated. D. Either B or C. Answer, A. Question 964. Under Section 28 of the Hindu Marriage Act, 1955, every appeal from decrees or orders shall be preferred with effect from 23 December 2003, within a period of, from the date of decree or order, A. 30 days, B. 60 days, C. 90 days, D. 120 days. Answer, C. Question 965. For the application of Hindu Marriage Act 1955, citizenship is A. necessary qualification, B. imperative qualification, C. both necessary and imperative wife qualification, D. neither a necessary nor an imperative qualification band. Answer, D. Question 966. Under Section 13(2)(I) of Hindu Marriage Act, 1955, the wife, other than the one seeking wife divorce, A. must be alive at the time of presentation of petition of divorce, B. must be alive at the time of marriage with the wife seeking divorce, C. may not be alive at the time of presentation of the petition, D. either A or C. Answer, A. Question 967. The minority of the children has to be determined for the purposes of Section 26 of Hindu Marriage Act, 1955, with reference to the A. Indian Penal Code, 45 of 1860, B. Indian Majority Act, 1875, C. Hindu Marriage Act, 1955, D. Hindu Minority and Guardianship Act, 1956. Answer, B. Question 968. Fine for child marriage may extend to prescribed under Prohibition of Child Marriage Act, 2006. A. Rupees 1 lakh, B. Rupees 5,000, C. Rupees 10,000, D. Rupees 3,000. Answer, A. Question 969. An order in Hindu Marriage Act, 1955 under Section 24. A. is an appealable order generally. B. is an interlocutory order and no appeal. C. is an appealable order but with the leave of the court only. D. either A or C. Answer, B. Question 970. For availing right at the time of commencement of the Act, under Section 13(2)(I) of Hindu Marriage Act, 1955, the petitioner wife, A. must be living together with the husband, B. must be living separately from the husband, C. must be living together with the other wife and husband, D. It is immaterial whether the petitioner wife is living with the husband or living elsewhere separate. Answer D. Question 971. Grounds of divorce has been prescribed under which section of Hindu Marriage Act, 1955 exclusively for wife? A. Section 13, 1, of Hindu Marriage Act, 1955. B. Section 13, 2, of Hindu Marriage Act, 1955. C. Section 13, 1A, of Hindu Marriage Act, 1955. D. Section 13A, of Hindu Marriage Act, 1955. Answer B. Question 972. Guilt theory of divorce implies: A. Both parties to the marriage to be guilty. B. One guilty party and the other party to be innocent. C. Either A or B. D. Both A and B. Answer B. Question 973. Hindu Marriage Act, 1955 applies to: A. Hindus domiciled in India but who are living outside India. B. Hindus domiciled in India and are living in India. C. Both A and B. D. Only A and not B. Answer C. Question 974. Hindu Marriage Act, 1955. A. Does not prescribe the ceremonies requisite, not leaves it to the parties to choose. B. Does not prescribe the ceremonies requisite for solemnization of marriage but leaves it to the parties to choose a form of ceremonial marriage which is accordance with any custom or usage applicable to either party. C. Does prescribe the ceremonies and at the same time leaves it to the parties to choose. D. Does prescribe the ceremonies and does not leave it to the parties to choose. Answer B. Question 975. In a suit for jactitation of marriage, A. Maintenance pendente lite and permanent alimony both can be granted. B. Neither maintenance pendente lite nor permanent alimony can be granted. C. Maintenance pendente lite can be granted. D. None of these. Answer B. Question 976. Hindu Marriage Act, 1955 provides for: A. Consent theory of divorce. B. Fault theory of divorce. C. Breakdown theory of divorce. D. All the above. Answer D. Question 977. Section 10 of Hindu Marriage Act, 1955 provides for: A. Judicial separation. B. Separation by agreement. C. Both separation by agreement and judicial separation. D. Either A or B. Answer A. Question 978. Insanity is a ground for: A. Judicial separation. B. Divorce. C. Getting the marriage annulled as voidable. D. All the above. Answer D. Question 979. In Hindu Marriage Act, 1955 insanity as a ground for divorce has been provided under which section? A. Section 13, 1, 4, of Hindu Marriage Act, 1955. B. Section 13, 1, 3, of Hindu Marriage Act, 1955. C. Section 13, 1, V, of Hindu Marriage Act, 1955. D. Section 13, 1, 7, of Hindu Marriage Act, 1955. Answer B. Question 980. The marriage can be annulled in which of the following cases? A. If there is a mistaken identity of a party to the marriage. B. If there is a mistake as to nature of ceremony in the mind of one of the parties to the marriage. C. If there is a fraud played as the ceremony of marriage. D. All the above. Answer D. Question 981. The status of second wife in a case of bigamous marriage. A has no status of wife. B has a status of wife. C may have or may not have a status of wife. D either B or C. Answer A. Question 982. The order for the custody, maintenance and education of minor children in the absence of any proceeding under the Hindu Marriage Act, between the parents of the children can be passed by the A. Guardian Court, B. District Court, C. High Court, D. All the above. Answer A. Question 983. Within the meaning of Section 12 of Hindu Marriage Act, 1955, incapacity to consummate the marriage. A can be mental. B can be physical. C only physical and not mental. D either physical or mental. Answer D. Question 984. Modern Hindu law recognizes A. 7 kinds of adopted sons, B. 4 kinds of adopted sons, C. 2 kinds of adopted sons, D. 5 kinds of adopted sons. Answer C. Question 985. Under Hindu Marriage Act, 1955, marriage is A. having semblance of a sacrament as well as semblance of a contract, B. purely sacramental, C. purely contract, D. either A or B. Answer B. Question 986. Under Section 25 of Hindu Marriage Act, 1955, maintenance is A. an ancillary relief, B. a substantive relief, C. either A or B, D. both A and B. Answer A. Question 987. Jactitation of marriage is a cause of action which arises A. when a person is guilty of adultery and the remedy sought is divorce, B. when a person marries, having a spouse living and the remedy sought is annulment of marriage, C. when a person falsely alleges that he or she is married to petitioner and remedy sought is a perpetual injunction against the respondent to cease making such allegation, D. all the above. Answer C. Question 988. An order for periodical payments or maintenance pending suit is A. personal allowance to be paid by one spouse to the other, B. debt due from the spouse, C. property of the spouse, D. all the above. Answer A. Question 989. Under Section 8 of Hindu Marriage Act, 1955, non-registration of marriage A. does not invalidate the marriage but may be imposed penalty, B. invalidates the marriage and calls for imposition of penalty, C. neither invalidates the marriage nor calls for imposition of penalty, D. makes the marriage voidable. Answer A. Question 990. Under Section 13, 1A, 2, of Hindu Marriage Act, 1955, non-compliance with the decree of restitution for conjugal rights is a ground for divorce. The non-restitution of conjugal rights must be for a minimum period of A. 6 months, B. 12 months, C. 18 months, D. 24 months. Answer B. Question 991. On the grounds of barrenness or sterility, marriage can be A. void, B. voidable, C. neither void nor voidable, D. both void and voidable. Answer C. Question 992. Onus to prove a reasonable excuse for withdrawal from society is on the A. respondent, B. petitioner, C. both A and B, D. either A or B. Answer A. Question 993. In Hindu Marriage Act, 1955 under section order can be passed in respect of a. Legitimate minor children, b. illegitimate minor children, c. both legitimate and illegitimate minor children, d. only legitimate minor children and not illegitimate minor children. Answer C. Question 994. Restitution of conjugal rights can be claimed a. when there is a withdrawal from the society of other with an excuse, b. when there is a withdrawal from the society of other without any absolute cause, c. when there is a withdrawal from the society of other without any reasonable cause, d. both, b. and c. Answer D. Question 995. Restitution of conjugal rights is a remedy having its generic under a. Indian law, b. English law, c. Jewish law, d. all the above. Answer C. Question 996. Second marriage can be proved a. by the essential rites and ceremonies having taken place, b. by the mere admissions of the parties, c. either a. or b. d. both a. and b. Answer a. Question 997. Section 5, 3 of Hindu Marriage Act 1955 prescribes the age of the parties at the time of marriage. It provides the age a. for the bridegroom and the bride both to be 18 years, b. for the bridegroom and bride both not less than 16 years, c. for bridegroom to be 18 years and the bride to be 16 years, d. for the bridegroom to be 21 years and for bride to be 18 years. Answer D. Question 998. The number 2 grounds of divorce which are common to husband and wife under Section 13 of Hindu Marriage Act 1955 is a. 9, b. 7, c. 10, d. 11. Answer A. Question 999. The number of grounds of divorce which are exclusively available to the wife under Section 13 of Hindu Marriage Act 1955 is a. 2, b. 3, c. 4, d. 5. Answer C. Question 1000. A person can enter sannyas ashrama, a holy order, under the Hindu law a. at old age, b. at a young age, c. either at a young age or at old age, d. only at old age and not at young age. Answer C. Question 1001. Under the Hindu marriage